Hey, Ted. Boon, sorry. Good morning in your language. Bundera Hunzu. Bundera Hunzu. Someone tell me good day in your language. Who's paying attention? All the ones I said, right? All right. All right, if I could get people to take their seats. We're still actually waiting for Miss Cindy Blackstock, but we have the fabulous Mary Teegee with her legal counsel, Scott Smith. So I think we have enough to start. I don't know why, what we're getting the feedback from. But that hurt my ears. All right, so we're gonna go to Mary Teegee at microphone 1 or 2, whichever. Microphone 1 to start us off. I'd like to thank you for coming back today and rejoining us. Good morning to the ones that are on the Zoom. We had an enjoyable evening with Mary and Cindy last night to talk about the final settlement agreement, and that's what we're discussing this morning. So over to you, Mary.
Good morning, everyone. I'm Mary Teegee. I am Takla Nation. I come from God's country. I'm Gikson and I'm Carrier. I'm from the Lac Gaboo clan. My hereditary chief's name is Mausham Gaboo, which is White Wolf. I'm the chair of the Indigenous Child and Family Services Directors Forum. I'm also the president of the BC Aboriginal Child Care Society. I represent British Columbia on the National Advisory Committee for Child and Family Service Long-Term Reform since 2017. I also am the board representative, British Columbia board representative on the First Nations Caring Society, and I've been in that role since 2007. So today we're going to be speaking about the draft final settlement agreement, and what we intend to do is to give you a bit of the history of the agreement, how we came here today, and what we're recommending moving forward. I'll just give you, as you know, the draft final settlement agreement comes from the agreement in principle. The agreement in principle, and I think this is what I really need to make clear, the agreement in principle comes from the Canadian Human Rights Tribunal ruling and the orders. As you know, in 2006, the AFN, led by the Caring Society, took Canada to court for discriminating against First Nations children. Canada was then found in 2016 to be discriminatory against First Nations children. Now, the discrimination was based on Canada's funding of the First Nations Child and Family Services program, so funding the agencies back then. So Canada would fund the nations or the agencies very little, if anything at all. And so what we had to do was show that Canada was discriminatory, and the way we did that is through the agencies and a comparator with the ministry, in BC's case, MCFD. So at the time in 2006, 2007, even before that, we had provided many reports and research that showed the underfunding causing the discrimination for First Nations children, and that took a lot of work. The Auditor General wrote a report in 2006 directing Canada to remedy the discrimination, and they chose not to. So we had no recourse, and so our little society, we had, I think, about 5 or 6 people, part of the Caring Society, decided to take Canada to court. We then got the support from AFN. What we were able to prove is that Canada grossly underfunded agencies based on their archaic 20-1 policy, funding policy, which was based on per capita. It was not based on need. So I'll give you an example. When my social workers, I would pay about $6 less or $3 less than if they were working for the ministry. For my nations, I tried to provide prevention services on reserve. So for 11 nations, my total budget would be anywhere between $11,000 to $32,000. That was it. And so we had no recourse except to go to court. So we went to court, we won. And then 2016, we had to take Canada to court again because they were appealing it. In fact, Canada appealed the decision again and again and again. We had to take Canada back to court for every little win. And we did that because the Canadian Human Rights Tribunal always ordered in our favor because, of course, we made sense. We had the facts. We had experiences from coming directly from the community. And so when we won all those cases, again and again, those non-compliance, Canada did this, although they were ordered to do it, they would never have done it out of the goodness of their heart. We know that. So you fast forward to a couple of years ago, when Canada, yet again, we had to file an order of non-compliance, and that's, we filed the non-compliance because Canada, where they were providing funding finally for prevention in communities, they weren't funding any capital in communities. So we were able to hire staff and do training, but there was no infrastructure. So if you wanted to, say, build a clan house or a group home or an office in your communities, there was no money to do that. Canada argued that they weren't obligated to do that, so we took them back to court and we won. We won again, and they were ordered to pay for capital. They were ordered, just as they were ordered to pay Jordan's principal, all of these pieces. So what ended up happening then is that Canada, on September 29th, the day before the first Truth and Reconciliation Day, was going to appeal the decision. And so through media, through many of the chiefs here, we finally got, Trudeau was in British Columbia at the time, if you recall, we finally got Canada to agree to not appeal. So Minister Mark Miller phoned and said, would we negotiate? And we agreed to negotiate. And that's how we ended up with the agreement in principle. The agreement in principle included other things such as post-majority, housing, different things. We then had to negotiate the final settlement agreement. And we know this in BC. There's all the treaties. There's agreement in principle, then you negotiate in good faith. Remember that, in good faith. So we were negotiating at the table with the Chiefs of Ontario, NAN. Now, Chiefs of Ontario and NAN, Anishinaabe Nation, were there because they had filed for intervenor status. BC chose not to. We didn't, I don't know why, we didn't file for intervenor status. So we had the Chiefs of Ontario, NAN, Canada, and the AFN legal team at the negotiating table, and myself and Cindy and our pro bono lawyers. That's who were at the table. And so when we were negotiating the final settlement agreement, during that time, Canada had committed to ensure that they were going to uphold the orders for Jordan's principle, and they didn't. We worked with them on a roadmap, on a work plan, to ensure that all children that were eligible to receive Jordan's principle services would receive it. That they did not do that. There was a wait list for over 8,000 children. In that time, there were a couple of deaths that occurred because of lack of services. So in good conscience, we could not sit there at the table, at the negotiating table, while Canada was acting in bad faith. So we had no recourse other than to file a non-compliance order, which we did December 8th of this last year. That non-compliance order was based on Canada's ineffectiveness of abiding by the CHRT orders, and in fact, in some places, just denial of those orders, which we saw. So when we did that, because we signed the agreement in principle, we had agreed that, that we were, that there was going to be, it was going to be confidential, that we weren't going to take the parties to court. But we couldn't sit there while Canada was not abiding by the orders and they were not acting in good faith, and that's why we did it. And so that's the reason why we could not be sitting at the negotiating table, because we could not keep doing what the table was doing. We're just ignoring Canada's failure to implement Jordan's principle and harming our children. And so that's sort of where we came with the final settlement agreement. And so Cindy is going to be talking about what's in that final settlement agreement. I just wanted to be very clear, that we were not at the table when this deal was struck and finalized. So with that little introduction, I'm going to open the floor to our wonderful children's champion, our indomitable, our fearless leader, Dr. Cindy Blackstock.
Thank you. Before we get to Cindy, I just want to let you know that the cutoff for proxies to be sent in is 10 a.m. today, and that's for you to be able to vote for the women's rep. You'll recall that we heard from Ron LaFleur yesterday. The voting closes at 12 noon, and we should know something by 1. So that was just our PSA. Oh, apologies. The voting closes at 1 p.m., but the cutoff for you to have the proxy sent in is 10 a.m. And we'd like to welcome, as our friend, dear friend and sister Mary Teachy said, the fearless and the indomitable, Dr. Cindy Blackstock. Could you pass over microphone 2, please?
Good morning, elders, chiefs, young people, and respected experts who are every day on the ground working with First Nations children and families. I want to pay my respects to the Musqueam Nation and to all of you for your dedication and time for being here for your children. I'm going to take you through a bit of a Caring Society analysis of the final settlement agreement. Our complete materials are available to you publicly. We really believe in being available publicly and having our positions out there so that we can be accountable to you, and most importantly, we can invite all of your better ideas. You can see from the title of this document, it really is "We Can Do Better." From that, you're going to hear from me that the analysis that the Caring Society has is that this agreement, unfortunately, does not meet the standards of the Canadian Human Rights Act. It does not meet the standards of UNDRIP, and it could be substantially improved and ought to be. I want to begin with some disclosure. The Caring Society is a party to the Canadian Human Rights Tribunal. We were honored to work with then National Chief Phil Fontaine and with many of you to get the authority to file this case along with the Assembly of First Nations in 2007. So even though we're not part of the negotiations, we will have authority to make representations before the tribunal, and that's important for you to know. So it's a two-step approval process for this final settlement agreement. One is under Section 379 of the agreement, which says approval by First Nations leadership, and it's unclear what that means. The second step in the approval is if that is granted, then it goes on to the tribunal for a second approval process. During that approval process, we will be making representations. We respect the other parties, but we take a very different view about what is in this agreement, the merits of the agreement, and proposed solutions. We are an apolitical organization, and we strongly recommend that First Nations get their own independent legal advice and technical advice. And frankly, one of the things that you may want to consider is requiring Canada to fund that advice, because I think this is so important that you have that on an ongoing basis to support your decision making. Also important for you to know is that AFNQ and Canada have an obligation under paragraph 379 of the agreement to promote the agreement in a manner to secure the endorsement of you. So that is set out in paragraph 379 to 382. And I thought I would just bring that to your attention as you're hearing from different parties about the agreement. We're not bound by that section, by the way. So let's kind of reboot on the case. So what is this case about? It's about stopping discrimination in child and family, now and forever. It's about stopping discrimination in Jordan's Principle by Canada, now and forever. Those are the material issues at hand in this case. This final settlement agreement will only deal with child and family, but it will have, of course, implications for Jordan's Principle, because we all know that a lot of families are in need of both. Because it's a legal case where is already a legal finding that Canada discriminated, and indeed about over 20 non-compliance and procedural orders forcing Canada into compliance, you could achieve a resolution to the case by negotiation only. And that's really what the parties have chosen to do, because the final settlement agreement would get rid of the tribunal and replace all of its orders with the final settlement agreement. But there are two other tools in the toolkit that haven't been used. One is to just develop a deal and bring a motion on behalf of First Nations to the tribunal and say this is what we need for our kids. It doesn't rely on Canada's agreement, and it's a public process. Or you could do a middle of the road, and in fact, that's where we've had a lot of success over the years, is see what Canada will agree to. But if there are material things that are critical to stopping the discrimination, then we litigate on those specific items. We're also, as you can hear Mary talk about, we're concerned about Canada's willingness to follow through with any agreement. In fact, we were at the non-compliance order on Jordan's Principle because they violated a negotiated agreement on Jordan's Principle. So that is going to be something that we have to keep in mind. So I just went through this briefly before. How do you finalize it? Well, in the final settlement agreement, it provides for your approval at paragraph 379. And then if it's approved, it goes on to the tribunal. I'm going to talk about, I understand the AFN's approval threshold is 60%. So let's say you were a nation who couldn't vote, or you chose not to vote, or you voted against it. How could you have your voices heard at the tribunal? I'll get to that at the end of this presentation. So here's some stuff you need to know. First of all, this agreement is 10 years and it ends after year 10. There is an allowance for a funding review at year 9, but there's no legal binding obligation for Canada to do it. AFN has submitted amendments that we have quickly reviewed, because we say quickly because we just got them yesterday. Now they're saying that Canada will consider legislation in year 9 and 10. That to me is insufficient to protect your kids against discrimination. They should be doing that now. There should be statutory funding now. The other thing you need to know is the agreement is actually only for 9 years because you're already in year 1. So that is an important matter to know. We've also been, according to representations made by AFN Legal Counsel at the Jordan's Principle non-compliance hearings in September of this year, and representations by Canada's Legal Counsel, they have advised the tribunal that they want to complete a final settlement agreement on Jordan's Principle by March 31st of 2025. So this agreement that you're looking at here, this one, is a precedent for what is about to come. There's no clear process we've seen for receiving amendments or discharging those amendments. The Caring Society has proposed amendments to address some of the issues I'll get into, but we have been advised by the parties that they are not willing to entertain substantive amendments at this time. The AFN has said that the FSA approval is 60% of those present. I'm really delighted that AFN has opened it up for virtual voting for leadership who can't make it. But there is nothing in the agreement that speaks to if you're not there, if you are not in support, or if you abstain. So a couple of things around the thing not being completed. We just got terms and conditions, and these things are really important. They were just released by the parties last week, and we were just taking a quick review through them. And one of the key pieces that you need to know is that it caps any recipient at $150 million. We actually don't know if that includes capital or not, and that's something that we'll find out more about. The other thing is that everybody, all First Nations and agencies will go through a risk assessment. And if the department determines that you're at higher risk, then you will be put on a 1-year fixed agreement, and they could restrict the amount of money that you're getting. The sections 42 on capital and post-majority are still outstanding. We have not seen them. They were targeted in the agreement for delivery on September 1st, but we've not seen them. The alternative dispute resolution mechanism, says there's enabling legislation. Canada's advised that that will not be provided to the chiefs until after you approve this deal and after the tribunal approves the deal. So that is an important piece to know, that that's not coming. The next thing that you need to know, particularly in British Columbia, is Canada, of course, funds provinces directly for the provision of First Nations Child and Family Services in BC. That agreement is not disclosed. There is no clarity about what are the terms and obligations of the province to make sure they're delivering culturally appropriate services that meet the needs of your children. Today, there are 3 upcoming votes on the FSA that I just wanted to alert you to. Today, actually, the Anishinaabe Nation leadership are meeting, and they're voting on a resolution on the final settlement agreement. Tomorrow, that'll be the Chiefs of Ontario. It says on the slide 10th to 11th, but my understanding is that the Chiefs have decided only to meet for 1 day, but I might be wrong about that. But anyway, it's the 10th, somewhere in that day, the next couple days. And then, of course, the SCA is next week. Here are some of the strengths we see in the agreement. The substantive equality principle is a good one. We want to make sure our kids get more support because of the higher levels of disadvantage they and their families have received. We also are happy to see what's called a special purpose allotment, which protects it from INAC using it for different purposes. And we're glad to see that there's information on stress on data collection. That's important. We need to know how our kids are doing and whether what we're doing is working. That's good. So those are some of the strengths. Here are some of the structural weaknesses. One is the 10-year deal. This case has been going on for 18 years. I thought it would be done, actually, I thought it would be done just within months of filing it, because I thought, oh, once they know we're serious, they'll do the right thing. That's how naive I was back then. So what your chances are at year 9 and 1 day would be to bring a brand new complaint against Canada, and that would be a heavy lift. You might end up doing as I do, getting a lot older while you wait for that to process. It's very Indian Act centric. We saw an opportunity, for example, to define First Nations child in the way that Tribunal already defined it First Nations child for Jordan's principle, which is recognition by your nation, and that includes on and off reserve. The definition in here is simply on the Indian Act and only on reserve. There's no decision making for you as leaders after the agreement is approved at a national level. Your decision making is now going to be replaced by a reformed implementation committee, which we understand from AFN's amendments, you from BC could nominate a representative now, but it's the parties who choose which representative sits for you. So you do not at this table appoint the representative. And we didn't see any changes to the terms of reference, and that group operates in secret, and they make all the big calls. The major problem is, of course, they replace you as decision makers. They also have control over the technical bodies. AFN, CU, and NAN would still be the only members of a board of directors over technical bodies. There's, in our view, poor funding structure. There's an ADR that's First Nations, and we support that. We would love to see First Nations courts and tribunals. But it can't order Canada to give you more money. It can't deal with systemic cases. It can't deal with award damages. So on all the big ticket items that we will need an ADR for, it does not have jurisdiction to do that. That is a problem, and it's expensive. It's $52.8 million over 9 years. And I would rather, like, honestly, if it's not strengthened, I'd rather see that money go to helping out with the opioid crisis or other things. They want to get rid of the tribunal. No more non-compliance orders from the tribunal. And in fact, all those orders would cease to exist. So, you know, here's kind of a comparator. Really, when we look at the status quo, what we do is we look back at the agreement in principle that AFN was a part of, And I'll actually share this with you. This is the Department of India, INAC's own PowerPoint slide that shows that 19.8 billion over 5 years, that the vast majority of that's protected by CHRT orders. You adjust that for inflation, as is required by the orders, that brings us up to about 22.5 over 5. You double it up and you're at about 45. Plus you have the actuals orders on top of that for capital, for protection services and everything else, right? That's what you got right now, protected by legal orders where the appeal periods have already expired. So whatever's in this agreement should be better than that, right? On the security, nothing's for sure, but legal orders are legal orders, and they are durable across any government. They have to abide by them. We can enforce them in the courts. And what we saw is a misalignment between the responsibilities that First Nations and agencies have and the resource allocation there. We're concerned that it'll set First Nations up to be underfunded, particularly because you don't get really dedicated capacity, money, and time to build up time to deliver prevention services. And we also know from analysis by financial experts that agencies in BC will be short about 1.3 billion over 5 years. Nationally, agencies will be short about nearly 10 billion over 10 years. So if you look at the final settlement agreement, some people say, well, it's a 10-year deal, we should go for it. I would say the key paragraphs of this agreement actually are in 379 to 384, because that's where the fine print is. So I'm just going to say I'm just going to read you paragraph 383. So the final settlement agreement provides for a fixed amount of $47.8 billion. But paragraph 383 reads as follows: any and all funding commitments by Canada or amendments agreed to by the parties in this final settlement agreement remain subject to annual appropriation by the Parliament of Canada or other necessary approval processes required by the Government of Canada, and those are undefined. So Canada basically has a lot of discretion here about whether the money will be allotted or not, especially given the ADR. Now, there is a typo. Was there a typo on this one? No, I fixed it, I think. I hope I did. I hope the last one says 8. That's the problem. Like, you've been doing this so long, you get old and you can't see anymore. That's why we can't do this again. We got to make sure we get it right this time. These are just so you can fact check me on the back orders. And again, I'll send you the department's own PowerPoint so you can see how they feel the amounts protected by the orders. You don't have to just rely on me. The governance, I've already gone through it a bit with that Reform Implementation Committee. We have serious concerns about that replacing your decision making. This case has always done that. We've had a good relationship with AFN in the past where we would bring key messages, decisions to you, and you'd provide direction. And indeed you did that under Resolution 2022-40, but not all of that was followed. But I suspect Scott will speak to that, so I won't. What we would like to see, oh, by the way, there's 7 committees in total governing this agreement. That's a lot of committees for one agreement. We would like to see it streamlined down to 3. And we would like to see the rest of the money saved actually go out to kids and families. Now, the AFN has amended the agreement with the other parties to include regional representatives on the RIC. But as I already told you, in our view, that does not fix the major problem, which is you are still not the decision makers over the agreement, and that you only get to nominate people and they get to choose, which is forgive me, I don't know a lot about the processes here, so I might be wrong about this, but my experience in the past is that the chiefs from the regions would appoint somebody, and then that's the person. There wasn't somebody else choosing people, but I could be wrong about that. And also Canada is still on this thing, and I don't think they should be. The whole goal of the agreement is to stop them and from discriminating and hold them accountable, so why would they be on the governance? So here is where we're going next. We want to restore you as decision makers in our governance approach. We would like to see a Children's Chiefs Committee nationally. There was a Chiefs Committee, but that has not met for 3 years. So it probably needs a refresh, and it would be advisory in nature and public, and their job would be to identify key issues that need decision-making by chiefs. It should include representation from nations not affiliated with AFN. Advising them would be a national advisory committee that wouldn't report to AFN staff, rather it would report to the Children's Chiefs Committee. And it would be advisory in nature, and it would also have a duty to engage your experts on the ground. The third committee that we're proposing is an expert advisory committee. That actually was created by the tribunal to reform the department. They should be entirely independent, they should be public, and they should have a right to talk to you or anyone else. Under the final settlement agreement, this group is required to sign a confidentiality order, so they can't talk to you. And they are also required to report to the RIC, which also operates under a confidential manner. We're looking at whether we should amend this thing or rewrite it. One of the things that we started to do is we looked at all these amendments, which we have shared publicly, and we got feedback from many of our technical experts. What we found is when we tried to fix one paragraph, we'd have to fix about 6 or 7 more and go back to the principles. So we actually think it's faster to rewrite it. Based on the work that we've already done over the years on CFS, we've done a lot of research, we have a lot of factual reports. We have the principles of C92 to build on, we have your direction to build on, so it wouldn't be starting from scratch. But we would need the flexibility to be able to go back to the tribunal and not just go into a process where it's whatever Canada will agree to, because that will always not be enough for our kids. We also are recommending changes in the process. This process, I don't think has achieved what we'd hope it would achieve. We would like to see a new negotiation process that's open, transparent, accountable, and that is overseen by the Children's Chiefs Committee, with technical advice from the NAC, and that you approve the negotiation mandates, protocols, and teams for any groups that represent you. Also important on Jordan's principle, I'm just going to be very honest here. I am very concerned that Jordan's principle may be subject to an agreement like this. This is a concerning process. We don't want to create more difficulties. If we want to get refresh happening, I don't think there should be negotiations on Jordan's principle until the chiefs have provided a negotiated mandate, protocol, and direction on that as well, and that there's a Chiefs Committee to supervise it. So overall, the Caring Society unfortunately cannot recommend the final settlement agreement. If it came to the tribunal, we would oppose it. It would be a contested hearing, and we would be raising many of the issues that we've already raised with you. We are recommending that there be this new process. You're experts in all of that, not me, but you can say what that process ought to look like. And then there be actual compliance with Resolution 40/2022, which said to come back to you as leaders with options and all the supporting materials, and then you make a decision from there. So one of the things that I just want to touch on is interested party status. So if we've been asked by some leadership, what happens if it passes? Well, if it passes, you would still have the ability to be heard as a collection of nations or individual nations at the tribunal by applying for interested party status. That requires that you make an application to the tribunal as soon as possible, early in the proceedings. The final settlement agreement says that they will bring a motion to get it approved by the tribunal within 30 days. So I think as early in that period as you can. You have to provide a unique perspective, as I understand it, and I'm not a lawyer, so get legal advice on this. You can't replicate the submissions of the parties or delay the proceedings, but you do get a direct voice, and indeed the BC Leadership Council in a very helpful and constructive way, did intervene on the Jordan's Principle non-compliance motion. So we have a lawyer here. I'm not a lawyer, so I think that's really helpful to kind of have him here to fact check me on the legal stuff, because I don't want to misstate things. So here's our recommendation. We cannot support the agreement. We cannot support it even if the amendments adopted, proposed by AFN are put forward. We would recommend that there be either a substantial amendments on this process or a rewrite. That's up to you. But it's in alignment with a new negotiation process and no negotiation on Jordan's Principle. And we have circulated all of our proposed amendments. They are draft because we want you to do better. If we're on the wrong path, if these things don't make sense, let us know. And one of the ones that I want to make sure we addressed were paragraph 383. So I just want to make sure that that other required processes is taken out, because that gives Canada a lot of berth to be able to reduce the funding. And we will be proposing amendments to the terms and conditions as well. With that, Chair, I'll conclude my presentation.
Thank you. Are we going to take questions next, or are we? Yeah.
Yep.
So Scott,
I'll
you're
go
going to
next.
be,
Yep,
Yep.
that's okay.
but you're not going to be more than 10? Yeah, because we want to, everyone's going to have questions. So you guys will still be talking. Okay, thank you.
Good morning, Chiefs. If we get my presentation put up, that would be very helpful. So thank you for inviting us to come and speak to you on a very critical issue, the issue of the final settlement agreement. So my name is Scott Smith. I'm a partner at Airden Burles. I'm here to give a very high-level overview of what's happening in the final settlement agreement and my legal review of the final settlement agreement. I've been told that I have 10 minutes by our chair, so I'll try to do that in a very summary way. And so just a bit of a disclosure as well for me. I'm doing this on a pro bono basis because I think we can do a lot better than what's in the current draft of the final settlement agreement. So
I didn't know you had a PowerPoint, so as long as you're done by 10.
yeah, okay. So there's a couple of issues that I want to talk about. So you heard Dr. Blackstock talk about and Mary talk about the background. So what we're trying to do here fundamentally is to stop the discrimination and ensure it never happens again. My serious concerns about the final settlement agreement as currently drafted is that it will not stop the discrimination, and the mechanisms are not in the agreement that would be required to ensure that that discrimination doesn't happen again. I'm going to talk to you a little bit. You heard Dr. Blackstock refer to this. I'm going to talk to you a little bit about what AFN's required to do. They're actually in the agreement required to promote the agreement and procure your approval as the chiefs. I'm going to talk to you a little bit about the standards at international law that apply to these types of negotiations and how different they could be. And then I'm going to get into the potential for ongoing discrimination. One of the key messages, in addition to what Dr. Blackstock has covered that I want to leave you with, is there is no decision-making role for British Columbia in this agreement. So once the chiefs, if the chiefs sign off on it as currently drafted, there's nothing in the agreement, no roles whatsoever for BC decision-making. Save and accept the minor amendment that BC or AFN is now proposing in relation to you being able to nominate potential members of the implementation committee. Again, as Dr. Blackstock said, the parties would retain discretion as to who would actually be put on the committee. So I'm just going to skip over a few of these background slides. Mary's covered that. I did want to draw your attention in particular to paragraph 379 of the final settlement agreement. And this relates to the sessions that AFN has been holding leading up to the meeting next week in Calgary, as well as the meeting in Calgary. And the actual text of the final settlement agreement requires that AFN promote the agreement and make best efforts to procure your approval. This is very different than, and we'll see this in a second, the directions from both the Chiefs in Assembly nationally at AFN as well as a resolution that you passed as BCAFN in terms of what was supposed to be going on in the negotiations. So I'll cover that in a minute. Very briefly, Dr. Blackstock and Mary asked me to look into, well, what are the standards at international law that apply to negotiations in relation to dealing with ongoing systemic violations of human rights? And we looked at that, and frankly, from my perspective, the negotiation process to date has ignored those critical standards. So at international law, victims of human rights violations have the right to reparation, which it's clearly been established includes the right to be consulted about, and I'll underline, participate in the development of measures to eliminate systemic discrimination. And there's a set of key principles that apply to those issues, and I've taken a quote from those set of standards. International reforms aimed at preventing a recurrence of violations should be developed through a process of broad consultations, including the participation of victims in other sectors of civil society. So you'll see as I go through the presentation that there were no broad public consultations, that these final settlement agreement was developed in confidential negotiations. And in a meeting with some of you last night, Regional Chief TG let us know that he hadn't even seen a draft of the final settlement agreement until it was provided on July 11th. So Cindy mentioned non-compliance with the standards in the United Nations Declaration on the Rights of Indigenous Peoples. That international instrument, of course, enshrines the rights of Indigenous peoples to be informed and consulted about matters through your own representative institutions chosen in accordance with your own procedures. So I'll draw your attention to Article 19, which I think is the most applicable article here. States shall consult and cooperate in good faith with Indigenous peoples concerned through their own representative institutions in order to obtain, and these are the key words, free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. So we'll go on to see that the Chiefs in Assembly, both nationally and here in British Columbia, have set what that process should have been to obtain your free, prior, and informed consent. And as I mentioned, those key provisions have not been followed. So in addition to the international legal standards, the standards in the and basic human rights set out in the Declaration, of course, the honor of the Crown and Canada's fiduciary obligations to you as First Nations are at stake in this process. And it appears to me that Canada has offloaded those duties, and including the fiduciary obligations, to AFN. And so I want to just skip right away to the next slide here. So Cindy mentioned AFN Resolution 40-2022. This was the resolution passed nationally by the Chiefs in Assembly to direct how the negotiation of the final settlement agreement was to occur. And so I've set out the key parts of the resolution in the first column on the left, and then the status in the middle. And the report card I've given is an F, complete failure to comply with any of the requirements in this resolution. So first key element, no reduction in funding. As you heard from Dr. Blackstock, the FSA funding is anticipated to be inadequate. It also only covers a 10-year term. So I want to be very clear about that 10-year term. there is no certainty after the 10-year term. We don't know what's going to happen. And in a worst case scenario, you could find yourselves in the same position that we were in 2006, when AFN and the Caring Society had to initiate the complaint with the Canadian Human Rights Tribunal. Okay, next, First Nations and Assembly must approve the FSA on long-term reform. That issue is unclear based on the drafting in the current FSA. Canada to fund the First Nations National Advisory Committee to inform the FSA. So this is a critical issue. No experts were in the room when the FSA was negotiated. From my understanding, the AFN stopped calling NAC meetings in February of this year, and the National Advisory Committee on long-term reform to Child and Family Services had no ability to provide any input. So the expertise at NAC, the expertise at the Caring Society, the expertise that exists here regionally in British Columbia and elsewhere were all excluded from those negotiations. I've never seen a negotiation that's occurred in that way before, where experts were excluded from the process. Next, Canada to provide chiefs, and I want to underline these words: all available options and related supporting financial resources to ensure free, prior, and informed consent on long-term reform. So what the Chiefs and Assembly directed was, go away, come up with a bunch of options for us on how to deal with long-term reform, coupled with funding mechanisms, and then bring those options back to the Chiefs for your consideration and input. That didn't happen. Instead of getting a bunch of options with some recommendations, you got a essentially take it or leave it final settlement agreement. Next, ensure the final settlement agreement does not inhibit the right to seek CHRT orders. In fact, that wasn't complied with, and the FSA purports to end the tribunal's jurisdiction almost immediately. So turning to the next resolution, this is BCAFN Resolution 7-2024. This also has not been complied with. So this was a resolution that the Chiefs passed earlier this year. So I'll point to the second point here. AFN to share drafts of FSA with the Caring Society, the NAC, regional experts, and, quote, meaningfully incorporate their recommendations for change. No such drafts were shared with any of those bodies. In fact, I think the first time most, if not all of you, would have seen the draft, including members of the NAC and the Caring Society, was on July 11th when it was published. Next, Canada was to provide funding for regional engagement on the draft compensation distribution protocol. That hasn't happened. I see Leah's looking at me in terms of time, so I'm going to speed up a little bit. Cindy talked a little bit about the potential for ongoing discrimination. There's a lot of fear-mongering happening right now in terms of some of the sessions and materials that I've seen that are saying, well, we need to sign this deal immediately because what happens if Pierre Poilievre gets elected and his new government doesn't want to do a deal with First Nations? So I want to say a few things about that. First of all, the $45 billion plus actuals, and many of those orders don't have funding caps, which is a big difference between the current status quo and the final settlement agreement, are not at risk if the final settlement is rejected by the Chiefs and sent back for revisions. The CHRT orders will remain in place, and the CHRT will retain jurisdiction and the ability to continue to force Canada to comply with these orders. So that's the status quo that will be in place if the final settlement agreement is rejected. And I want to emphasize that because that also provides a lens through which the Chiefs, in my view, should be looking at the final settlement agreement. We should be doing better than the status quo, not worse. And unfortunately, the FSA walks us back quite a bit on a number of fronts. So I'm going to skip this over or summarize this very quickly. Cindy's already spoken to this. Experts have looked at this and concluded that the funding is likely going to be inadequate. This is particularly true here in British Columbia, where we only started receiving money for prevention services in 2017. So we still don't have an established baseline for what those costs are going to be. And so there's a very serious risk, and indeed highly likely risk, that the estimates in the FSA for what these things are going to cost have significantly underestimated what we're going to see here. This combined with the dispute resolution mechanism are highly problematic. So the FSA, as Cindy mentioned, purports to eliminate the tribunal's jurisdiction. So that means the only recourse that First Nations would have is to this dispute resolution tribunal that's created under the FSA. Now, there are very serious fundamental problems with that dispute resolution mechanism. One, it can't order Canada to pay more money. So there's no way to resolve a situation where the monies being provided under the FSA are insufficient, discrimination is ongoing, additional monies are required. The tribunal can't order Canada to pay more money. Second thing is, can't order Canada to deal with systemic reform. So it's unclear to me how you're going to eliminate systemic discrimination that the tribunal has found if there's not an ongoing ability to police that issue. So Cindy mentioned the term of the FSA. So it's 10 years. We've already started year one, even though you haven't actually approved the agreement. That gives us a 9-year window. The agreement is silent on what happens after year 10, and there is no guarantee for funding after that 10-year term expires. Now, I do want to draw the Chief's attention to this, because one of the other serious issues, and Cindy spoke about this, is the funding in the agreement is subject to appropriations by Parliament and any other federal approval processes. Well, first of all, we don't know what that means. Second of all, that means you're going to get funding for year one, and then you've got forecasted funding moving forward. And there are other options to deal with this issue of parliamentary appropriation. And Cindy mentioned that AFN had recently published some proposed amendments that were put on its website yesterday or the day before. And I want to draw your attention, Chiefs, to the one of the solutions they're proposing after the 10 years. And they're saying, quote, "In considering the Reform Implementation Committee's second program assessment opinion, Canada shall consider the viability of embedding the reformed funding approach and any recommended changes thereto into legislation, statutory funding." Well, why don't we have statutory funding right now that applies to the 10-year term that deals with the risks associated with the agreement being subject to parliamentary appropriation? So this is an example where there are clear tools available to the parties to deal with the fundamental flaws in the agreement that simply aren't being brought forward. Okay, yeah. So last point that I want to make, Chiefs, and I provided this slide deck to BCAFN, so I'm sure they'll be circulating or making that available to you. There is no ongoing decision-making role for you as the Chiefs, either at a regional level through the First Nations Leadership Council, BCAFN, the union, or as individual First Nations. You're not going to be parties to the settlement agreement. It means you won't be participating in any dispute resolution mechanisms that are brought before the tribunal. You're going to have very little, if any, influence on who's put on the implementation committees. And perhaps most importantly, you're not going to be receiving any of the funding that's going to be provided. So right now, no funding provided to BC regional or sub-regional organizations. And in contrast, there's $22 million provided to AFN, COO, and NAN to participate in the Reform Implementation Committee, and another $84 million to support their participation in national and regional secretariats. So real usurping of your decision-making roles and responsibilities. So, Chair, I think I'll end there. And I think, Mary, you maybe want to make a few comments before we take questions. So thank you.
Wait a second here. I have a list, and I see that Dawn is on this panel. So I'd like to go to Dawn quickly, and then we'll go to Mary. Bearing in mind, we'd like to get to the delegates to ask you questions where you all will be doing more talking. So it will all work out. Could you pass over microphone 2, please? Or 1, sorry.
Hi, everyone. For those that haven't met me, I'm Dawn Johnson. I'm a member of the Athabasca Chippewa First Nation, and I'm a lawyer with Mandel Pinder, who was asked to provide some insight and review on the agreement. My colleagues have provided a very in-depth analysis and review of the agreement, and I also just 15 minutes ago had the opportunity to review these proposed amendments, so don't want to go too far into commenting on those pieces until we have a chance to look at it more thoroughly. A couple of things that we did want to highlight, though, that we had identified as issues previously that remain relevant and outstanding. And Mary spoke to the capital funding piece and the issues and the need for capital funding here in BC. And so one of the things within the proposed draft final settlement agreement is that capital funding at cost per the CHRT orders will end under this agreement. And so that will have significant impacts for First Nations and agencies here in BC, in particular those in rural and remote communities and smaller nations and agencies who haven't had the opportunity to fully benefit from that capital funding as of yet. And I don't know that the process for the renewed capital funding approach has been released, and we haven't had an opportunity to review that. So nations also aren't aware of what that looks like moving forward. Also, that post-majority services are no longer going to be funded at cost. Some of the other pieces that are a significant difference within the current proposed agreement is the prevention funding and the allocation of prevention funding. And so this shifts prevention funding completely away from First Nations agencies and to First Nations, unless the First Nation provides notice to ask that they want it to go to the agency. So within a couple of years, agencies who are providing prevention services will no longer be receiving that prevention funding unless the nations that they serve ask ISC to allocate it to them instead. Instead, the full amount will be going to First Nations to provide prevention services at all levels. There was some reference to the governance within the agreement. That was one of the key issues that we also identified was the regional representation and the top-down approach to governance that is set out in the final settlement agreement. So there was mention of the National Secretariat. So this is termed as a First Nations led and directed organization that's going to be formed, and it will be formed with AFN, COO, and NAN. And so they continue to have this really strong role in the governance and rollout and operation of the agreement. And that includes through the Reform Implementation Committee. And so we had identified those as issues previously. I understand that there may be some proposed amendments on that piece, but haven't had a chance to review that in depth, so I don't want to go too far into that. Also around the regional secretariats. So there's regional secretariats that can be established through the agreement, but AFN determines which regions will have those regional secretariats. And the agreement as it was released previously stated that that would be within an existing First Nations service organization. So again, it's that top-down approach to governance rather than it coming directly from First Nations and you directing what that looks like. The Dispute Resolution Tribunal, touch quickly on that. So there's an interim dispute resolution process that's set out in the agreement that will then, is supposed to come into force via legislation. And so in that, there's two types of disputes. There's party disputes and there's claimant disputes. So party disputes, anytime you're seeing party in the agreement, that's referring to AFN, COO, NAN, and Canada. So there's those disputes, and then claimant disputes is with reference to First Nations and First Nations service providers, so agencies. Some of the things we've heard, I mean, it's unclear whether or not the funding allocated is going to address the discrimination. There's mixed reviews around that piece, I would say. And some nations are happy with this and are supporting the agreement. There's others that really aren't. So it's divided. It's important for you to have the opportunity to look at it in depth and to look at these revisions that are being proposed in depth as well. As soon as we've had a chance to review them, we'll share our analysis of that with the FNLC that could be shared with you. As mentioned by Cindy and others, this is going before the Chiefs next week for ratification. And so one of the concerns around this has been the lack of transparency to date, but also the lack of time that leadership has had to review this agreement and whether or not the changes that are being proposed are sufficient. So it is important to be looking at it in depth, receiving your own advice from your technicians and legal counsel so you can make an informed decision when it's time to vote on it next week. And Cindy outlined what the process will be after that. So I'm going to leave it there and turn it over for questions.
Thank you. Mary?
Thank you. How long do I have? 5 minutes? So I'm just wanting to put it in the British Columbia context. One thing we know for certain is that BC is not being served by this agreement in no way, shape, or form. As I said earlier, British Columbia did not start receiving the prevention funding till about 2017, 2018. The other regions across Canada had been receiving federal prevention funding, the Enhanced Prevention Framework, since about 2007, 2008. That's why the rest of the country, they'll have infrastructure and they'll have programs that are up and running. And so when we looked for BC, we haven't had the opportunity to build that capacity within the agencies or within the nations the way that we should. We also, in British Columbia, we also haven't had, I think, the opportunity really to realize your community plans for prevention. I think there's many things that we still need to work on. So we don't have a baseline, and that's important. So if you look in the agreement, they're looking at the 1922-23 baseline. Think about that time. In British Columbia, we only started receiving funding, as I said, at least for my agency, substantially about 2019. Then what happened shortly after was that COVID. So in the 22-23, we weren't expending our funding because we couldn't get the staffing. Our offices were closed. So we weren't able to build the infrastructure. So the 22-23 baseline that they're using falls far short of what BC's actually cost. We don't know what our baseline is yet in British Columbia. So how can we agree to this final settlement agreement? You'll see in the numbers that there will be 2,600 per capita for the nations. Now 2,600 is based on a number that's coming out of the Measuring to Thrive, but that number is wrong. And because what they've done is they've used that number at 2,600 based on the 22-23 and based on an agency or a nation already having the capacity and the infrastructure. It's not about building capacity. So there's an assumption that you had an up and running community prevention program and building. So I think that's really important to understand that in British Columbia. One of the things that, how we could strengthen this agreement, and again, we've said, right now we have the 45 billion already through orders. We know Canada has not made change because they were willing. Every step of the way we've had to hold them to account and hold the hammer over their head. In negotiations, there was only two things that Canada wanted: the Canadian Human Rights Tribunal to be gone and to be indemnified. What we did with this agreement, I couldn't say what they did with this agreement is gave everything Canada they wanted on the silver platter. I think the scary thing is if this agreement goes through, there hasn't been reasonable minds that are actually working in the field to make these decisions. There was no evidence base to make these decisions. There was no experts at the table. The National Advisory Committee on Child and Family Service long-term weren't at the table. So when decisions are made that the post-majority is going to be capped and that the post-majority funding is just going to go directly to nations, there are certain ramifications for that that's real on the ground. That would mean the center that I have up and running in Prince George, British Columbia for high risk, we have post-majority, we have youth from all over BC, from all over Canada that go to that center, that if this agreement goes through, that center would no longer be able to be funded. That's the reality of it. All of the programs that have been started within the agencies to support the nations, the supportive housing that we just opened up with 18 units to provide supportive housing, wraparound supports to those youth that were formerly in care, that would have to be shut down because, again, the funding would go to the nations and it wouldn't go to the agency. I think that what we're missing is that we've fallen so far behind to think about where we could be, because what Canada will or will not do. This could be a yes and that's what we need to fight for, yes and. Yes, the nations get the funding, and yes, the agencies get the funding to provide prevention. We have so much work to do, and we can't have any cuts. This agreement, the estimates, the financial estimates, is that there will be a shortfall of BC agency funding over 5 years of 1.57 billion, a national shortfall of 9.874 billion. This is shortfalls. While we're trying to building capacity in British Columbia, we're going to have this shortfall, and we don't even know what our baseline is. I think the way that we can do this is that we look at having the definition of a Jordan's principal child to extend to child and family service, to extend to this agreement so that we can consider off and on reserve, not just on reserve. There's many things that we could do. We could have the oversight of the CHRT extend for at least 2 to 5 years so that we ensure Canada fully implements it the way that we want the final settlement agreement to look. So I'm going to leave it at that. Thank you, and I know we have time for questions.
Thank you. Thank you. I just want the delegation to know that we are going to take questions. This panel has gone on a little bit longer than we wanted, but not complaining, just saying that we wanted you to see the PowerPoints and hear the discussion behind the PowerPoints, because this is such a big decision that you all have to make. We want to make sure that you have all of the information. So, having said that, we are going to take questions for as long as we need to. I do have one, if we're still waiting for folks to warm up here. I have one from the online, and it is, how realistic, coming from Cheryl Casimir, First Nations Leadership Council and First Nations Summit, how realistic is it to think we can renegotiate this agreement? What assurance do we have that a new agreement, a new government, Conservatives potentially, would be open to renegotiating? What reassurances do we have that the other parties would be open to this as well? Is that a legal question, or Cindy, you want to take, or Mary, you want to take a shot?
So we can't speak for the other parties about whether they would be open to do that. They are, the other parties, at least those that represent chiefs, they take their mandates from you. So at the end of the day, I suspect, you know, if you direct them to do something, then that's what they ought to be doing. In terms of Canada, I mean, it is a risk. Maybe they choose not to negotiate. Even this government has not been a lot of fun to deal with on child and family. We've had to bring a lot of non-compliance orders. The question is, even if you had to stay at what you got right now, if I was, just honestly, if I was either take what we have now or go for a final settlement agreement like this, I would take what we have now. Even though it doesn't meet all the things, because it's more secure and it is more transparent, accountable to you. So I can't make any promises for Canada, and I can't speak for the other parties. I would hope that they would be willing to renegotiate, especially at your direction, because that would be the way of respecting free, prior, and informed consent. I don't know, Scott, if you have more to add.
I do. So thank you for that question. So first of all, I'd just like to remind the chiefs that this actually happened before in relation to the final settlement agreement on compensation. And that agreement, the total amount that was initially proposed for that agreement was, I think, just shy of $5 billion. That was rejected, sent back for renegotiation. It went from $5 billion to $20 billion. And I think, Cindy, the final number was $23.4 billion in that agreement. So there is an example, even within the context of dealing with this particular case, where the matter's been sent back for renegotiation and a much better result has been achieved. Like, imagine having settled for $5 billion when you could get to $23.4 billion. I think the second question, second aspect of that I'd like to highlight from a legal perspective, and this is why I spent a little bit of time on this in my presentation. If a new government is elected federally and they decide not to negotiate or renegotiate, the baseline is the Canadian Human Rights Tribunal orders, which will remain in force or effect. That's the backstop that the chiefs have, and I think that would give me quite a bit of confidence going forward to say, no, we need to do better, and we can do better. Can't speak to how other parties are going to be able to deal with this, other than, of course, AFN, because AFN is supposed to take the directions from the chiefs in assembly. So that's you guys when you go to Calgary next week, and your directions haven't been complied with. That's why we went through that AFN resolution. So, you know, we need to get back to complying with the chief's direction. And frankly, this, from my perspective, the negotiation moving from being run by AFN national staff back to the chiefs and chiefs oversight committees, reporting back to you directly as the chiefs in assembly. So I'll leave it there, but I think there's lots of potential to get a much better deal here.
Thank you. Microphone 9, Chief Shanna.
Haishka, Madam Chair, Lachala Watsad, Shanna Thomas, recently taken up responsibilities from Pahalikton, Hereditary Chief of Likes, and just want to thank you for the presentation. I know we did have an opportunity to have some discussion over dinner last night, but I'm just going to reiterate a few of the things that I had mentioned then. We, particularly those of us in treaty negotiations, are very familiar with the Crown walking away from the negotiating table. That's a real lived experience of our people. We're also very familiar with the Crown changing their mind. And we're very familiar with the Conservative government and their approach. Those of us on the coast who are fishing nations had a right to fish on the Fraser, and they bogged us down in a commission that took years to prevent us from being able to exercise our right to fish. I can't speak for the Nuu-Chah-Nulth, but I know that the Nuu-Chah-Nulth won a right to sell fish for an economic opportunity, and they too were bogged down in a process to try to bring that right to life. We've also seen in the Chilcotin decision, when they won the recognition of their title, and how that got bogged down. So I have complete and total faith that if this agreement is rejected, and I'm not suggesting that we support it, but I have complete and total faith that if this agreement is rejected, the Crown will do everything it can to prevent itself from having to continue to engage. So I think we need to be prepared for that. And I'm not saying that as something against the recommendation to not support it. I'm saying we're the strongest we can be when we know what the worst is going to happen on the other side of the table as a consequence of our decision. And every decision we make has a consequence, whether it's good or bad. And as long as we're prepared for that, then we can make that decision and stand by it wholeheartedly. I know for my community, Leixon is part of a delegated agency, and if we want the delegated agency to carry out programs and services, it's our responsibility to enter into that understanding with them. I don't need a separate order going to the delegated agency to make sure. The nations make up the delegated agencies. The nations are the ones that provide the direction to the delegated agencies. So for me, that's not an issue. What I do take issue with is the fact that the Crown is committing to it with the caveat that they have to get appropriations to approve the allocation on a year-to-year basis, because we know that's not going to go through. We know that we're headed for hard times. Everyone is prepared for hard times. We're all preparing now, trying to get things done, because we know we're going to run out of funding. So that on itself is enough to cause pause. I got the look from the chair, so I'm going to stop there. Thank you, Madam Chair.
You know, the chair is taking exception to all of these points that I'm giving them the look. There's no look. You'll know when there's a look. All right, we'll go to microphone 21 and Chief Elaine.
I'm a Heathlick, Elaine Moore, on the Nishkat village of Kitwansik. I want to say thank you for the presentation. It's quite interesting trying to catch up and keep up with the language that you speak on a daily basis. But I do want to say, you know, we're in election mode. Canada is in election mode. Why aren't we making noise about these 20 issues, you know? The non-compliance issues? Share those issues with us in a briefing note so that we can do our job and make some noise about that during election mode. That's frustrating. You know, we know that Canada is well known for their unwillingness to negotiate in good faith. I don't think there's any good stories yet. So I think if we start making noise on a regular basis and having the notes that you have to help us, to help our leaders understand what the implications are. I want to understand why or how this affects us when it comes to the rest of Canada. BC is not going to support this. So how does this affect our voice at AFN?
Thank you. Thank you. So I'd like to go back to the panel on addressing Chief Shanna and Chief Elaine. I'm not sure who, Cindy?
Yeah, I'll just speak. I mean, it is definitely a possibility, as you point out, Chief, that Canada will just say, we're not negotiating anymore. However, then that still leaves Canada with a problem. The tribunal orders and the tribunal's ongoing jurisdiction. So then what could happen is that we would consult on the contents of what should be in a motion brought before the tribunal with the authority of the chiefs, and then have the tribunal adjudicate that and hopefully make a decision in favor of that solution. So it's not, Canada's not like in a regular situation where it's just negotiations or nothing. It is wanting to get out of the jurisdiction of the tribunal, and if it really wants that really badly, it's going to have to make sure it's not discriminating any further. So I think that's really key. In terms of briefing notes on the non-compliance stuff, we actually had a non-compliance hearing, Chief. We'll recirculate some of those things. I mean, all this happened like over the summer when you guys are swamped with all kinds of stuff. We'll make sure that that stuff gets out to you.
Just maybe if we can speak to the regional approach. Cindy, Mary, and I have been asked to appear before a number of the regions that are holding briefing sessions, and we understand that a number of the regions are going to come out not in support of the current draft of the final settlement agreement. So I think in terms of what, I think, Chief, you're asking what can be done sort of locally here or regionally here in British Columbia. I think there's going to be some resolutions on this issue before you this week. So that's one option. Definitely, we need as many people as possible come into Calgary to vote in the Special Chiefs Assembly to make sure that the final settlement agreement doesn't get approved. If for some reason it does get approved, then we're into the situation where the parties would have to bring the final settlement agreement before the Canadian Human Rights Tribunal for sign-off. As Dr. Blackstock mentioned, at that point there would be an opportunity for multiple parties to seek interested party status and speak to why the final settlement agreement shouldn't be approved. So that's sort of the next steps. So you could imagine First Nations Leadership Council applied for interested party status in the non-compliance motion, so you could have FNLC participating, but you could also have either individual First Nations or blocks of First Nations, either individually or with their delegated agencies. And that would be very important so that the tribunal can hear BC's perspective on why the final settlement agreement shouldn't be approved.
I'd just like to make
Microphone 1, please.
I'd just like to make one point, just sort of on that non-compliance, that we do have those information sheets. But again, specifically to British Columbia, I think what's really important here to note is that right now the First Nations Leadership Council are an interested party in that non-compliance, and thank God. I'll read something that, so it was Canada and the AFN legal team against the Caring Society and against the First Nations Leadership Council. So this is what basically, what in their submission, AFN. Save for the limited interim relief below, the AFN confirms that it takes exception to the substantive request of relief raised by the Caring Society and endorsed by the First Nations Leadership Council. Takes exception to it because we were trying to push the envelope and say you had to, stop the wait list, you had to provide the supports that's needed. And then to add insult to injury, we have a submission coming from the AFN that talks about the potlatch. What we were saying is that we thought because in the tribunal it talks about culturally sensitive services and supports, and there was a question around attendance of 2 children going to a potlatch that lost their parents. And so that was a denied request. And so we brought that forward, and now the AFN says, while important culturally, the AFN would note that the adoption of the original request, this is to bring the boys to the potlatch, was unprecedented and certainly an expansive interpretation of the tribunal's existing orders. This is beyond simply exceeding the normative standard based on substantive equality. So while we're pushing the envelope to say this is something that is so important to us in our services, the First Nations Leadership Council support us, AFN Legal is saying, nope, the potlatch shouldn't be considered as a Jordan's Principle request. And so when we talk about all of these things, we have to be specific to what is happening now within the non-compliance and why who do we trust? Ask yourself that, who are we trusting? Is it the lawyers and mostly non-Indigenous old white guys in Canada and lawyers, or are we trusting the ones that have actually done the work, the National Advisory Committee on Child Welfare Reform that knows what's happening in the most remote communities, and the Caring Society and Cindy Blackstock? Who do you trust?
Thank you. Are there any additional questions? I don't see any online. Microphone 26, please.
Good morning. Thanks for all the info sessions, Mary and the team there that's been providing this new information we didn't have before. I'm kind of struggling with too, the state of our communities and how long it would take to renegotiate another deal. I'm just wondering, is it another option to secure a major portion of what's being offered and leave some at the table for ongoing negotiations? So maybe some programs could start while we wait. Just wondering if that's an option, Hella.
Let me take microphone 24, and then we'll come back to the panel. Microphone 25, sorry, Chief Helen?
Cooks Jajam. Wait, wait up. Helen Henderson wins quest. Hello, everyone. My name is Chief Helen Henderson from Chikeskan First Nation, and I'm happy to be connecting with each and every one of you today. I want to honor the work by acknowledging our matriarchs, our knowledge holders, our elders, our champions. In this journey, there's been a massive amount of work and advocacy, lobbying, and fighting on behalf of our Chmemel Tutuit Elkwaseltan, our children and families, children, youth, and families. I want to honor our Musqueam ancestors for being in the room here with us today and allowing us to have these critical discussions. I've listened in the past several weeks since the announcement that this FSA was made available, trying to wrap my mind around what it means for Cheskenam and work on the ground. But what comes back to me as a process-minded person is the process in and of itself, and how on a larger scale, the process in and of itself is discriminatory. It's a discriminatory process. I can't shake that feeling. When there's conversations happening without the title and rights holders, when there's conversations happening about our children. I will share with you that when I sit across from these tables that have been talked about by our sisters and brothers around the table, that I hold them to account always about who they are in my life and how little impact they have in decision making. Because they haven't been to my territory, because they haven't met any of my children, because they don't do on the ground work, there's a serious disconnect. So I'm often saying, if it doesn't resonate on the ground for my children, youth and families, then it's not going to work. And I can't support it. But my question at the end of the day always is around process. And I've heard from a regional chief that he didn't even see the agreement until that July date, along with the rest of us. So my question is around structure and recourse for these governing structures that we find ourselves in. What is your recourse as regional chief, as an example, to hold AFN to account? If we're giving direction through resolution as First Nations leaders around this table to the AFN, if that's the mechanism through all these forums, and we're not heard, and it's not followed through, then what is the mechanism? And why would we continue using a process? Are we setting precedent by allowing this to continue? But at the end of the day, the whole process in and of itself has been taken away from us, very top down, and it feels discriminatory. I'll say it out loud. So what is our recourse when systems or structures, processes break down along while we're going through it? I shouldn't have to say out loud that as Gukbi and as leaders, matriarchs in our community, that we're so bogged down, oppressed by their systems the systems that they created that we're trying to change and get out of. That the whole process that's before us is set up for failure. And how is that fair? How does that continue to be accepted in 2024? So how do we as Indigenous leaders, title and rights holders challenge and those processes, those structures that apparently, seemingly aren't working for us? Kuksjam.
Thank you, Chief. Where shall we start? Cindy?
I would just, I can't speak about the AFN governance thing. I'm going to leave that for others who are much better at that kind of stuff than I am. In terms of securing whatever money's on the table, yeah, like Canada really should not be, should be, if they're honoring in good faith, they ought to observe the direction of the chiefs, and they should put the money on the table until they've exercised free, prior, and informed consent and giving you that direction. I think that's something that the chiefs should call for. We haven't seen the types of calculations that really lead us to believe that this is actually more money. We'd like to see those calculations. I think the chiefs need to see those calculations. But if there's more money on the table, then yeah, then let's try and secure it. Scott might have ideas about how that can be done legally. I just wanted to correct just one quick thing. We did at the Caring Society see an early draft of this agreement back in about March. We provided feedback on it, but we didn't get any responses to our feedback. So just full transparency to the chiefs, just wanted to let you know that piece of information.
And I'll just sort of respond to you, Chief Billy, and I think that was, your question around, is there something that we can secure in this so that we can proceed? We're working. We already do have 45 billion over 10 years already. That's secured through an order. One of the things that you must know that there's a law in Canada that states that any sitting government cannot tie the hands of any succeeding government in agreement. So if the Liberal government signs this agreement, Poilievre gets in, or Conservative government gets in, the Conservative government cannot be tied to that agreement. And that's where the annual appropriation is very, very worrisome. However, any government has to follow the orders. And right now, the bird in hand that we have is 45 billion. And what we are proposing is exactly what you're saying, is yes, we have the 45 billion. We do have the Canadian, capital at actuals, we have post-majority at actuals, we have all of these things right now that would, and the orders that would continue, so that we do have that time to get a better deal that actually really truly reflects what's needed in our communities and our children and families. So absolutely, we do have, again, not to reiterate, right now we have the tribunal orders, which would be minimum 45 billion after 10 years, but we also have nothing that's capped. Post-majority isn't capped. The CHRT 41, that's not capped.
Thank you. And we'll go to Regional Chief to speak to the AFN governance piece.
Hello. Deniza Tsekuza Skiza. Just want to acknowledge the Coast Salish people, the territory, the Musqueam. I guess I'll just be frank here, and for the last few days, I've been speaking to my colleagues, the other executives, the other regional chiefs, and they're discussing this matter right now before Calgary. And I'll just be frank, the news isn't good for this FSA. There's too many concerns about the structures. The FSIN, the Federation of Sovereign Indigenous Nations in Saskatchewan, are not supporting this. We've seen the Union of BC Indian Chiefs 2 weeks ago, a very strong resolution in not supporting this. I just was seeing an email from the Tsilkotin, who urges everyone to vote against this FSA. The Yukon are discussing it tomorrow, and it doesn't look good. I believe Manitoba already discussed this, and it doesn't look good there. Quebec will be doing a virtual meeting tomorrow. It doesn't look good. So what's the recourse? I think sadly, as we move through this negotiations, although BC wasn't a party to it, COO, NAN, AFN, the Child Family Caring Society, and the federal government were in the room negotiating this deal. I think the recourse is what we're doing now, is reacting, sadly, with many things, we react. So we have several resolutions coming up in regards to this agreement. And as we discussed last night at the dinner and perhaps here, is the support for this FSA in its current form doesn't fit the needs of British Columbia. I think the recourse is to reset negotiations. I think we got to really think about who's at the negotiating table. So we are at the table, and if there is negotiations continue. I don't think it's a yes or no. I think if there is a resolution that passes next week, is to carry on with negotiations. The other recourse is to have a seat at the table at the CHRT. So we will have a resolution, as I stated last night, from the BCAFN to encourage with our sister organizations, the Union of BC Indian Chiefs, First Nations, BC First Nations Summit, and also the Child Caring Society, or Our Way Society, to gain intervener status, so we can have a voice at the CHRT when they discuss this. So that's the recourse. The other recourse was we sent several letters to the AFN from British Columbia, and these letters came from British Columbia, Yukon, Saskatchewan, Quebec, and New Brunswick in regards to the whole process. We thought at the executive table our voice wasn't heard about our concerns, and we sent several letters since the beginning of the year in regards to the whole process. But obviously those fell on deaf ears. So I think it's really important that we reset negotiations. I think it's really important that we're at the table as British Columbia. We're the third most populous First Nations region in this country, behind Ontario and Quebec. We have the most First Nations communities with 204. We have many children in care. So, the stakes are high for British Columbia, so there's no reason why we shouldn't be at the table when negotiations begin or have been going on. And as you said, Cookby, I didn't see this agreement, the final settlement agreement, until it was released at the AFN AGM. So the other recourse is to restart the Chiefs Committee on Child Welfare. They haven't met in 3 years. Our previous appointment, my previous appointment was Cookby Judy Wilson, and is now Chief Don Tom. The other matter in terms of the AFN, I think, is that we haven't utilized to its fullest potential within the AFN the social department. And I think it's really important to utilize everything at hand with our experts. And the other matter here that was brought up by this panel was appropriate data. It has been very difficult to get the data from the federal government on this matter. But at the same time, it has to be specific to British Columbia. So that being said, I think that's really the recourse that we can begin and start. But I really encourage that negotiations continue. I don't think we throw the whole thing out. I think we carry on to try to address the shortcomings. I believe the resolution will be coming forward from our position in British Columbia. Thank you, Madam Chair.
Thank you. And with that, I would like to, apologies for no closing remarks for all of you. I trust you understand that we're under some pressure here from our agenda. Would like to please join me in giving a round of applause to the panel. Dr. Cindy Blackstock, Mary Teegee, Scott Smith, and Don Johnson, thanking them for joining us. And we would like to now turn to your resolution. And then we'll hear from Don on the next agenda item. But right now, we're going to say thank you and turn to your draft resolution 06-2024, addressing the shortcomings related to the draft final agreement on long-term reform of First Nations Child and Family Services. And Regional Chief will be giving gifts to our panelists. So make sure you see Regional Chief. This resolution is moved by Cookby Helen Henderson, she's in the room, and seconded by Deborah Foxcroft, proxy for Sichat, she is in the room. And for the record, we will read the therefore be it resolved. Therefore be it resolved that 1, the BCAFN Chiefs and Assembly express significant concerns regarding the current draft final agreement on long-term reform of the First Nations Child and Family Services Program, as it does not adequately ensure the protection of the well-being of our children now and for future generations. 2, the BCAFN Chiefs and Assembly call on the Assembly of First Nations and Canada to pause the current process and immediately enter into a transparent and accountable negotiation process in full consultation with First Nations leadership, families, and communities to develop a revised agreement that guarantees adequate long-term funding for prevention services, child and family services, and community-based supports that meet the actual needs of children and families. Establishes a permanent oversight mechanism led by First Nations in all regions to ensure Canada complies with its obligations, including regular reporting and enforceable penalties for non-compliance. Creates a co-governance model where First Nations have equal decision-making authority with Canada in determining funding levels, service delivery, and future reforms. Ensures protections beyond 10 years, creating a framework that will safeguard the rights and well-being of children for generations to come. 3, the BCAFN Chiefs and Assembly direct the Regional Chief to work with the Union of BC Indian Chiefs and the First Nations Summit as the First Nations Leadership Council to advocate for amending the July 11th draft final settlement agreement to address shortcomings relating to the lack of respect for the inherent right of self-government held by First Nations, the lack of transparency and accountability in the governance processes, the numerous funding issues, the short-term nature of the agreement, the weaknesses in the dispute resolution tribunal, and the lack of inclusiveness of modern treaty nations. 4, the BCAFN Chiefs and Assembly urge immediate action to address the current gaps in funding and services to prevent further harm to our children while long-term reforms are negotiated and implemented. 5, the BCAFN Chiefs and Assembly reject any efforts by Canada now or at any time in the future to abandon or delegate its legal duty to consult to the Assembly of First Nations or to any other entity. And 6, the BCAFN Chiefs and Assembly urge the AFN to respect the negotiation mandates articulated in AFN resolutions when negotiating on behalf of First Nations regarding FNC, FS, and/or Jordan's Principle. That's your resolution. That's been duly moved and seconded. Discussion. Any discussion on this resolution? Microphone 24.
Yes, Rick Johnson, Quixonaquami's First Nation. Is the amendment, is the resolution talking about amendments? I'm not sure if that goes far enough. Maybe we, I don't know, some wording around maybe a possible rewrite.
Let me take that under advisement and turn to our technical people. And while they're thinking about where to put that, I see that we have Chief Maureen Luggie on, excuse me, on the Zoom. Chief Maureen, please.
Good morning, Denise Skyze. I would like to propose a friendly amendment to this resolution, and I'll just read it out. That the BCAFN Chiefs in Assembly direct the regional chief to work with the Union of BC Indian Chiefs and the First Nations Summit as the First Nations Leadership Council to seek interested party status in collaboration with the Indigenous Child and Family Services Directors, Our Children, Our Way Society, with the intention to bring forward First Nations in BC perspective position in the Canadian human rights case known as First Nations Child and Family Caring Society of Canada et al. Versus Attorney General of Canada for the Minister of Indian and Northern Affairs Canada. Let me know if you need me to text this to you or to text it to somebody who's typing on the screen.
The one typing on the screen is Maureen Buchan, and I believe she has it. Could you have a look? And while you're checking that out, let me go to, we haven't lost sight of Chief at microphone 24, Chief Johnson. That one is being, I think we're considering, would like you to consider adding, revising, sorry, we have to scroll up a little bit. There we go. And number 3, First Nations Leadership Council to advocate for revising the July 11th draft.
Yeah, that's fine.
Okay, thank you. So on that resolution where we're going to add revising to number 3, could I go to Cookby Helen for whether or not you agree? A microphone 25, please.
Cookby, Helen Henderson, I agree.
Thank you, Cookby. Can I turn to the seconder, Councillor Deb at microphone 19?
I agree to the friendly amendments.
On revising, thank you.
Revising.
Thank you. And can we go back up to the one from, or go down to, I'm not sure where we are. Oh, there we are. Chief Luggie, can you look at this? Can you see it, or do you want me to read it out to you?
I can see it.
Great.
And it is the proposed amendment that I was seeking, Masai.
Thank you. So for the record, we would propose to add a new number 7. The BCAFN Chiefs in Assembly direct the regional chief to work with the Union of BC Indian Chiefs and the First Nations Summit as the First Nations Leadership Council to seek interested party status in collaboration with the Indigenous Child and Family Services Directors, Our Children, Our Way Society, with the intention to bring forward First Nations in in BC perspective/position in the Canadian human rights case known as First Nations Child and Family Caring Society et al. V. Attorney General of Canada. That's the proposed amendment. Can I go to the mover? It could be Helen for comment.
Cook's-Jem Chlia, just a clarification. I know last night we talked about possibly having another resolution to address intervenor status, and my question is this the action item from this conversation?
I don't believe Chief Lugie was in that conversation last night, but let me
see.
check with technical to see if we have something in the
Excellent,
works.
thank you.
Because your point is, if we have something in the works, then we don't need to add it here.
Yes, I
Right?
understood
Okay,
there was going
thank
to
you.
be a resolution specific to intervenor.
Okay, let me check. Did we have anything come in? Yes. So we don't need it here. Okay. Chief Maureen Lukey, there is another resolution coming forward that will address this direction to the First Nations Leadership Council as interested party in the CHRT. So with that, we won't need to add it here because you will be addressing that in a separate resolution. So since we're going to address it, Cookby is suggesting we won't be accepting that here. But I just want Chief Maureen to know that it's not being lost. It's going to come in somewhere else. Thank you. And I would like to hear from Deb. Microphone 19, please.
Deb Foxcroft, proxy for Sishot. Just after a second review here, there needs to be a correction to the number 3. We talked about, or it says to advocate for amending the July 11th draft FSA, but I'm wanting to recommend a change to that, is that we would be not advocating for amending, it's about rewriting the July 11th draft FSA to address shortcomings. And it's also about that we are, yeah, so I think that's what, I just needed to make a change to that.
All right, so we have First Nations Leadership Council to advocate for rewriting the July 11th draft FSA.
Correct.
Thank you. And we'll go back to Cookby Helen, microphone 25.
Cook's-Jem, for the space, I'm new to the BCAFN processes and I'm learning, and I'm a learner for sure. In speaking and getting some advice, I believe that there's no harm in including that number 7 piece that we just talked about. That's also going to be addressed in a separate resolution. I understand that going through these processes, that certainly there's no guarantee that resolutions move forward. So just based on that possibility, it's certainly important to at least note in this resolution.
Okay.
Is my reasoning. So
Okay.
I certainly don't disagree with including number 7.
So you're accepting number 7?
Yes.
Thank you, Cookby Helen. And we'll move to the seconder, microphone 19. Councillor Deb, on the addition of the new number 7.
Is that the same one that we just proposed?
We thought we could include, we know that it will be in a future resolution later on today or tomorrow or whenever it comes up, but it will come up before the end of this meeting.
Okay.
But the thinking is that there isn't any harm in having it here and then having a separate resolution.
Okay, I agree.
Thank you. Thank you. All right, so Chief Maureen, your amendment is back in. Phew, there we go. And we'd like to go back online, and I see proxy Bill Yoakum, please.
Thank you, Madam Chair. Thank you for the great work you always do. Thank you, Mary and Dr. Blackstock for the great work as well. Squilitzilton, Bill Yocum, Sanemo Proxy Counselor. I'd just like to, nothing to add except we'd like to lift our hands up to everyone who brought this resolution forward, because there's too much wisdom in the room, too much hard work by the people in the front line. And BC has to have a voice and a say in such an important matter for years and generations to come. So we lift our hands up on behalf of Chief Wise, and we're thankful for the resolution that's come forward this morning. Thank you. Isepka.
Hachkasiam, thanking you. Bill, I'd like to go to microphone 16 and Chief, oh, thank you.
Art Adolph, proxy for Chief Darrell Bob. And actually, I have a couple of friendly amendments. On the first paragraph, we talked about the discrimination that this whole process is supposed to address. So I'd like to add, as it is discriminatory and does not adequately ensure their protection. So basically identifying what Dr. Blackstock was referencing to include it in the resolution.
Thank you. You're talking about in the whereas clause?
Yes. Oh, no. In the therefore, the number 1.
Okay.
It's it says First Nations Children and Family Services Program, comma, as it is discriminatory and does not adequately.
Thank you, sir. Did you say you have a couple of amendments?
Yes.
Okay,
and,
we'll take the other one as well.
Number 3, there's reference to the inherent right of self-government. And I'd like to remove of self-government and just basically indicate the inherent right held by First Nations. Is
your amendment. Okay.
And the other addition I would like to recommend is on the end of number 3, it indicates, and the lack of inclusiveness of modern treaties, including non-treaty nations.
Okay, thank you. Proxy Adolph? And we'll go back to, forgot where we were, microphone 25, Cookby Helen. For those additions, so we have in number 1, we added in is discriminatory and does not adequately.
Agreed to number 1.
Agreeing to number 1. Over to the seconder, Council Deb, microphone 19, please.
Deb Foxcroft, proxy for Sishot. Yes, I'm in agreement with those amendments.
Thank you. And we'll move to the second one. It's in clause number 3, where we have taken out in that line where it says inherent right, we took out self-government, we just left inherent right. Can I go to microphone 25? Cookby Helen?
I'm in agreement.
Thank you, Cookby. And we'll go over to microphone 19, Council Deb Foxcroft.
I'm in agreement.
Thank you. And the last amendment is at the end of number 3, adding including non-treaty nations. Back to Cookby at number 25.
I'm certainly in agreement, and I just want to ensure that we're being inclusive of everyone that we possibly need to think of here. So if that's the case, then I'm in agreement.
Thank you. Sometimes it just needs to be explicit for everyone to be comfortable. Thank you. Microphone 19, Deb?
I also agree. Thank you.
Thank you. All right. I don't see anyone else online, and I don't see any more. Oh, I do see Chief Dan. Microphone 14.
Chief Dan Manuel.
Oh, sorry. Oh, no, that's right. 14. Go ahead.
Thank you, Madam Chair. Chief Dan Manuel, Upper Nicola Band. Just wanted to sorry, I had to step out of the room here earlier and I just came back in. I'm just a bit perplexed, I guess, by the resolution timing in relation to some of the expressions, and I'm not able to see the revisions and the amendments that have been suggested, and I thank the leadership at the table for their comments and discussion, but I can't see the screen, unfortunately. And I haven't been privy to the discussion prior to the motion coming onto the floor. I just have some real concerns around, unless the language has been changed in the whereas or the therefore be it resolved number 1. And again, this is something that just going on the inclusiveness, you know, we have a diverse set of communities represented here. I think we need to also understand that that we haven't heard from the national chief. We haven't heard the alternate perspective of the agreement in the positive or in the support. What I see here is mostly the dissent or the opposition. I would respectfully state that, you know, we should be considering both sides of the position here if we're going to collectively make an expression on behalf of our region, as I think is trying to be expressed by this resolution, and understanding that we will have and do have diversity of opinion at the table, and bringing this in the fashion binds those of us that may support the agreement or may not agree with the statement that there are significant concerns or that we have significant concerns regarding the current draft final settlement agreement. Thank you, Madam Chair.
Thank you. Thank you, Chief Dan. And I understand, I take your points on where and how this is being presented to all of you. And it is due to your timing. You're all going to Calgary next week. Are you raising your hand in support or to respond, Deb? Okay, thank you. I'll go to you next. I just want you to know that this is all so that we can have, we've had the discussion today, ensuring that you have the complete picture, because up until the last few weeks, that if you went to our Loving Justice conference, you'd only had in front of you the final settlement agreement as it stands. Some people have had the opportunity to show it to your own legal counsel, which everyone supports. You should give it to your own legal counsel to talk about what your perspective is from your First Nation. You've also had in hand the legal opinion from Mandel Pinder on behalf of all the children and families work that the First Nations Leadership Council has been doing to show you to break it all down, to show you what it means. I'd like to go to microphone 19.
Good afternoon, and just want to acknowledge and thank everybody for their comments and questions and amendments. I just wanted to say that although, as many people know, this has been rushed to make this decision, I know that in BC there's been many information sessions and webinars for chiefs and for everyone to get this information. Just so you know that at the back table there also is a list of the resources for you to be able to scan. And I just wanted to say that it's not as if we haven't been doing this work in British Columbia, and also a lot of the Leadership Council and has been involved in this from the very beginning stages. And this is historical, we know that. And I just wanted to say that there has been a lot of information shared and resources, and there has been an openness to everyone to be included in all of those sessions in British Columbia especially. Shoot, thank you.
Thank you, Deb. So thanking you for your point of view. Chief Dan, the resolution is where it is, and we're going to continue on. Microphone 14.
Madam Chair, if we're going to consider the resolution, then I'll take the opportunity to speak against the resolution. Again, I want to express that collectively we have a diversity of opinions. We're represented here today by a certain number of nations. We've talked about in the presentation that we just heard from Cindy and Dr. Blackstock, my apologies, Mary and Scott and Don. Again, the discussion around how these decisions are going to be made and held, I believe that individually our communities should be also wary that free, prior, and informed consent doesn't just apply to how the government seeks to receive our consent. It also applies to ourselves when we're talking collectively amongst ourselves about issues that affect us individually as the proper title holders. The proper title holders of these rights are our individual communities. They're not held by the BCAFN, they're not held by the AFN, they're not held by the Child and Caring Society, they're not held by the delegated agencies or their representatives. So when we express a common position, we have to be clear that in some cases we may not be able to express that, and that I feel that that's okay and that's valid. That's a valid exercise of our jurisdiction and our rights. We have to be aware and cognizant and respectful of our individual rights expressed, and that's what I hear that we're trying to do. The work we're trying to do is to express individually. So collectively, in the resolution as I have drafted, and again, I can't see the revisions that were prepared on the screen, I'm just concerned that we're going to put ourselves in a position that divides our caucus, that divides our approach, because again, it's apparent, and as I said, I'm speaking in opposition to the motion. And if that's the case, then the significant concerns that are being proposed to be expressed should also affirm for those nations that may be opposed to the motion our opposition. Thank you, Madam Chair.
Thank you, Chief Dan. Your opposition is noted, and thank you for your perspectives. I'd like to, question has been called on the, how do you call it, on the chat, but before that, I had two more speakers, and then we'll go to question. I have Chief Shanna, then Chief Ed John. Microphone 9, please.
Haishka, Madam Chair, Lakala Watsad, Shanna Thomas, Hereditary Chief, Laixon First Nation. Just want to thank everyone for the discussion and the work into the amendment, speaking in favor of the motion. Thank you.
Thank you, Shanna. I'd like to go next to microphone 23, Akaili Cho, Chief Ed John.
Adi is not neki. Dine as kekne. Baganetsa den I tebe hodistin hoyatal tak.
Kastabi kastlani inni awdaket kaya lahaltak in sesdehan tilcha sutin teloninsan wasn't an it was an instance. Firstly, I want to acknowledge our relatives here in Musqueam, to thank them. In the language of my people, I spoke very briefly to express the concerns that we have respecting our children and how important that is, and that since we started seeing the 60s scoops in the residential schools and the loss of our languages, the loss of our relatives, to foster and adoptive care, and many of them coming back and wondering how come nobody stood up for them. The need to connect and reconnect our people, and that's been an incredibly large challenge that we have. Really grateful that my community put their confidence in me as their chief, and I have a wonderful council of 7 people, 5 of whom I've never been on council before. So we have a lot of work, and this is one of the very big issues. We have a table full of issues that this is one of many. And I'm sure if all of the chiefs here are in exactly the same position, we're not involved in the day-to-day work in this area. However, what we do know is what we see day-to-day in our communities and the impacts of children being taken, families being disrupted, no support to the families. And I know that there's discussions in my community. They're saying that money will be coming to our community directly to be able to do some of the work. We belong to a delegated agency, and they have somewhere thing in the neighborhood of, for 3 communities, I think somewhere in the neighborhood of 65 to 70 employees. From my communities, 2 communities, there are in the neighborhood of between 60 to 65 children in care, permanent continuing custody orders. That's very significant. And so, and we have basically in my community 2 people to look after that. And it's kind of troubling. So we're looking to see that we have resources to be able to do the prevention work that's needed in our communities, the work that's needed. The problems are in our communities. They're not anywhere else, within our families, within our communities, individuals. In the last little while, I brought a number of youth to the Jack Indian Residential School to talk to them about intergenerational trauma. What surprised me more than anything else was they had absolutely no knowledge what LeJack was or what it stood for, what the residential school, and yet we talk about it as if everybody understands that, and it knocked the hell out of me to understand that these young people didn't have a clue, didn't understand. No one had taken them out there to say, look, this is what's going on. So I think when we're looking on the pathways from removing government from this area of work, both federally and provincially, there are responsibilities that both have assumed the province under the provincial legislation and the federal government with the residential schools. As we move from there into delegation, we have quite a number of delegated agencies, various levels of delegation here. What we haven't seen, except maybe a couple of instances where the community is exercising its own inherent right with no delegation from Canada, no delegation from British Columbia. And if you remember the February 9th Supreme Court decision of the Quebec reference case dealing with the federal child and family services legislation, that case essentially carved out a foundation of the inherent right to self-government for our communities to be able to make decisions. So we're moving to that level, and my community is now moving in, talking and planning to be in that place. And I look to my relatives from the Nisga'a
Lissam's government, who have been undertaking this for quite a number of years. On the practical side of things, the recent agreement on the island with the Alcaminum Treaty Group, what they're proposing and planning, as we heard in one of our recent meetings, that's I think the direction that many of us are going in, and we need the support, we need the capacity development, we need the resources to enable to do the work that's so important. So what I heard, and I want to thank Mary and Scott and our dear White Bear advocate and lady from Mandel Pinder, from what I'm able to hear, a lot of it is largely procedural, the concerns that are there. If AFN is a party to the court case, yes. NAN is a party to the court case. The Anishinaabe First Nations and the Chiefs of Ontario. And in the agreement, I see that it's not the Minister for CERNA or the Minister for Indigenous Services who is the party to this agreement, it's the Attorney General of Canada. I understood that he was to be, or was, maybe was already to be on our agenda here. And I think we need to make sure that we ask questions. The concerns are raised by my colleague across the way here around whether we have to support it or not support it and creating that division. Looking at the 399 terms in the agreement, I've gone through it, and I have more questions than I have answers. And today I heard some of the concerns that have been raised, but they're pretty obscure in terms of lack of transparency, accountability in the governance process, numerous funding issues, short-term nature of the agreement, weaknesses in the dispute resolution tribunal, and lack of inclusiveness of modern treaty nations. I would have thought that Inishka would be part of AFN, but you go back to the agreement in paragraph 3-7 talks about to uphold the rights in section 35. And I think that's really important, but what it's missing also is what the Supreme Court of Canada said, the braiding of laws together, whether Indigenous law, international law like the UN Declaration, and state law, laws in Canada, the braiding of those three levels of authority working together for the advancement of the concerns of our children. I think it's not just Section 35. I think we're beyond that into the Declaration in a very significant way. And I think the standards in the Declaration provide a very significant opportunity to expand on the 17 words in Section 35. Section 35 does not do justice to Aboriginal issues in this country in any way, shape, or form. And the courts have been lurching from pillar to post to try to figure out how to interpret those 17 words. So that's been I've been a student of that for all my life, and you know, since the '82 Constitution was repatriated. I don't know why we would agree to oust the jurisdiction of the Canadian Human Rights Tribunal under this agreement, why we would go that far. Whether it's even necessary that should be included in there, I think that's something that we haven't talked about, except for, it says, the Jordan's Principle issue. That's still on the table under the jurisdiction, as I gather, of the Human Rights Tribunal. I could be wrong, but that's the way I'm reading it, and I'm thinking if they're leaving it open for that, why are they taking the jurisdiction out on the other issues? And then Article 379 talks about best efforts to procure First Nations support. Now, free, prior, and informed consent, and as governments making decisions, I think it's really important to understand that as my colleague across the way, we're in this new place of the UN Declaration, and we're sorting out ourselves how we provide our our support or consent to our national organization, which we always say is an advocacy body. Now, when we vote yes here, do we have to go home now and prepare resolutions from our nations to support this agreement? You know, when an agreement or a convention is negotiated at the United Nations, for example, and they vote at the UN, then now the states have to go back to their respective parliaments to secure support for that particular United Nations instrument. I think there's processes that we have not in place yet to do that, to ratify, as it were, an international agreement. The Paris Climate Agreement 2015, for example, I was there for that. Once Canada supported it, voted yes, but then they had to go to Parliament to get the necessary legislation in place to support that climate action agreement from 2015. So there's some of those procedural issues that really concern me. Our council has had some preliminary discussions about it, and we're very much on the page of ensuring that we receive the finances that we need to take care, not just of those 63 children in continuing custody care, continuing custody orders, but their families who are still, many of them have not had access to their children for a long time. And this is still going on, even within the authorization from our own delegated agencies and what's going on there. The last thing I wanted to bring up was I listened to Mary carefully, what she said, and she said there's $45 billion already that's based on actuals based on tribunal orders. I'm assuming that's still the case, and that here we are talking about $2.5 billion perhaps, over and above that. The orders are there. Why would Canada want to oust a jurisdiction? And also the issue of ongoing liabilities to take themselves out. I don't know how AFN can become our intermediary. They are not rights holders to begin with, and they should not be put in that position. I think AFN will tell you first, the national chief will tell you AFN does not hold any treaty rights, does not hold any Aboriginal rights. The rights holders are the peoples in our communities, and I think Canada's, being mischievous by putting this forward in the way it is. And the very last point is I'm really absolutely surprised why our province, the 204 First Nations, have not had a seat at the table in the negotiations of this agreement. It surprises me in a very big way. So I'm not even sure what to make of all of this. It's as our council hasn't made a decision one way or another. I'm being forced to abstain today, and perhaps even in Calgary until we have a further discussion. We've heard one side of the story. I see Catherine Lapage, she's the ADM, assigned to this file nationally, I gather, not just in British Columbia. And I don't know what they're thinking, to be honest with you. But I do know that she has taken, and I see Stuart Watke from the Assembly of First Nations, who's the legal counsel, advising and at the table, I understand, and how these issues that we're talking about and concerned about are not being factored into the agreement. It really baffles me. So I'm in that place where I see shortcomings in this agreement, and I see unnecessary language in this agreement, and certainly one that, we need to be, we're standing for those children, and their parents or guardians and our communities who are struggling through this each and every day. That's where I am now as a chief, elected chief at Lonsdale Nation. We have two communities. So, Madam Chair, thank you for bearing with me as I'm looking through this. It's a bit of a complicated agreement and a lot of concerns for sure. At the end of the day, we have to make judgment calls, and those calls are discretionary. So thank you very much.
Thank you. Thank you. And apologies to Councilmember Foxcroft. Question has already been called. So we're going to move to the question. We've had some discussion against the resolution, so we'll need to vote on addressing the shortcomings related to the draft final agreement on long-term reform of First Nations child and family services. And for the sake of brevity, I would like to ask for, if they're entertaining the question, if there are any abstentions. I'd also like to ask the staff to help count. Are there any abstentions in this question? Thank you. And any against this motion? Can we check online? I got 5 in the room. Did you? You got 6? 5. Online. No abstentions or no against online. And I have the 5. I had 5, right? Thank you. Thank you. Did you say 6? Thank you. You're sitting on the side. I didn't see you. Thank you. All right, so we have 6. All right, all those in favor? Okay, can you hold that for a sec? And checking online? 6 online? 33? So math, 33 altogether? 7 online? 27 in the room? 33? All right. Thank you. You can put your arms, I'm sorry that you had to hold them up so long. The math wasn't quite mathing up here. All right. We have 27 in the room, 6 online, 33 in total for this resolution. This resolution is passed by majority. Thank you all. All right. We are a little bit behind. Well, we're like about an hour behind. And we have our good friend Dawn Johnson, who has promised me that she is going to be 10 minutes. So if you have questions, if we could do questions on the side, or if we could submit questions and then we could read the responses out. I'm just conscious and aware of the time that Dawn has with us, and we also have National Chief in the wings, and we really want to get to those presentations as well. So this is what I am saying we're going to do. I'm not giving you any choice. We're going to hear from Dawn for 10 minutes. If we have any questions or comments, we'll make sure that we are able to get responses from Dawn. Over to microphone 1, please, and thank you so much for bearing with us.
Thank you, Madam Chair. Yes, and I promise I will try to keep this to 10 minutes. I'm just here to provide a brief update on the FNLC's intervention in the Jordan's Principle non-compliance motion that was raised earlier. So as mentioned, there was a non-compliance motion brought by the Caring Society against Canada on Jordan's Principle. That motion was brought back in December of last year and just heard in September of this year. And so some of the issues that led to the bringing of that non-compliance motion was with regards to ongoing delays in backlogs and processing of Jordan's Principle requests, severe backlogs in all the regions, but in particular in BC, it was noted that there was over 2,000 backlogs of Jordan's Principle requests in the queue. So that means unopened and not processed applications that had been put in for Jordan's Principle. So that was something that the FNLC became aware of and was extremely concerned about, and felt that it was important to bring a BC perspective in this non-compliance motion. Other orders sought by the Caring Society were in relation to the definition of urgent requests, so looking to get some clarity from the tribunal, in particular expanding those orders to clarify that the definition of urgency included situations where a child was impacted by a declared state of emergency, whether that was by the province or a locality or a First Nation, as well as children who had experienced the recent death or where there was the imminent death of a caregiver or close family member, that those would be considered as urgent requests in the definition of urgency. Also, issues around the processing of reimbursement for Jordan's Principle requests that had already been approved. And so that was reimbursement to individual requesters, often family members, as well as to service providers who were providing that service and then invoicing for Jordan's Principle, leading to all kinds of challenges. So the First Nations Leadership Council also wanted to address those issues from the perspective of BC. In mid-March of this year, Canada brought a cross motion seeking orders of its own and asking the tribunal to dismiss all of the Caring Society's orders. So the FNLC applied earlier this summer to become an interested party. The tribunal granted the FNLC interested party status in August of this year on a limited basis. So that means that the FNLC was able to bring written and oral submissions before the tribunal on that BC-specific perspective in order to assist the tribunal in determining these orders sought. And it, as I said, just limited to these specific orders and motions. So it doesn't extend to the overall discrimination complaint. It doesn't extend to other motions related to Jordan's Principle or this program. So the FNLC generally supported the Caring Society in their position on each of these issues. One of the most critical issues that was debated throughout was how urgent requests were being managed and dealt with, and connecting back to basics policy that had been adopted by Canada and co-developed with the Caring Society to assist in ensuring, kind of from a no-nonsense, back to basics perspective, that Jordan's Principle requests were being dealt with and addressed on a timely basis, and not creating additional barriers or delays for First Nations children and families. As I said, FNLC also supported the Caring Society in expanding that definition, in particular for First Nations children who are impacted by declared states of emergency, given the very real impacts of wildfires and floods here in BC, as well as the opioid crisis that we're dealing with on a daily basis. FNLC also, and actually AFN and COO and NAN also opposed any extension of the timelines of orders of how Jordan's principal request would be heard. That was one of the orders that Canada sought. Was they said that they aren't able to meet the timeline for processing Jordan's principal requests as previously ordered by the tribunal, and asked the tribunal to extend that timeline for them rather than address the backlog. I just note that there's a briefing note in your kit that outlines in more detail a lot of these pieces. I just want to highlight in my 10 minutes the key issues. So at the end of the hearing, the tribunal reserved its decision. We're still waiting to get that decision from the tribunal as to whether or not they'll grant any or all of the orders sought by either the Caring Society or by Canada. There did seem to be some indication that the tribunal may choose to go the route of ordering negotiation amongst the parties on the specific issues in the motion, or in the Caring Society's motion as well as Canada's cross motion, namely around defining urgent requests, potentially how to address backlogs. Sorry, the other key piece that was brought forward was the establishment of a complaints mechanism that was recognized and identified by the Caring Society as a significant issue, and actually acknowledged by AFN. Although they oppose the establishment of a complaints mechanism, the Caring Society and AFN have really been playing that role in supporting families who aren't having their requests heard, in escalating and elevating those requests. Something that came up throughout that I just want to touch on really quickly that's quite important is that Canada has a negotiation mandate until March 31st, 2025, so till the end of this fiscal year, on long-term reform of Jordan's principle. It was advanced and argued by AFN in Canada, as well as to a degree by Koo and Nan, that the orders sought by the Caring Society are better left to long-term reform, that the tribunal should not be imposing any additional orders, that they have a negotiation table that is currently underway. The Caring Society was previously at that table but had to leave in order to bring the non-compliance motion, and Dr. Blackstock spoke to that just briefly earlier. So that's important because that is the other piece on long-term reform that is happening right now. Chief Ed John spoke to this current draft final settlement agreement on the First Nations Child and Family Services Program excluding Jordan's principle, and that's correct. That doesn't apply to Jordan's principle. There's a separate negotiation of a final settlement agreement that is underway with regard to long-term reform of Jordan's principle. And as we understood and was expressed numerous times throughout the hearing earlier in September, was that Canada's current mandate is till March 31st, 2025. And so I raise that because it's important that, for First Nations in BC and beyond to be watching for that and to be raising these concerns and identifying issues well in advance if it's going to roll out in the same way that the FSA on the Child and Family Services Program has. It's important to start thinking about it and paying attention to pieces specific to Jordan's principle, because that will be brought to you for your consideration and potential approval at some point in the coming months, depending where things go. So I hope I'm within my 10 minutes. Great. I'll stop there.
Thank you so much. Round of applause for Dawn for getting her presentation in at 10 minutes. We're getting a standing ovation from me and our friend down at 17. Thank you for your presentation. We really appreciate it and the information you're bringing forward. The briefing note is in your kit, and if you would like to ask further questions to Dawn, please get the questions to the staff, and we'll get the answers back to the plenary. Regional Chief would like to thank Dawn with a gift. And while he's doing that, if I could invite National Chief to come to the front. And while we're waiting for all of this to go on, I want to note that chiefs and proxies, please email or visit Joanna down in the corner red table if you have not received your voting link. If you have not received your voting link, please visit Joanna and Ron down in that corner so you can be able to vote in the next election. And Well, we come over here. Sit or stand, or where am I going? Where am I? PowerPoint? Are you here? I don't know. Yes, you can speak up here, and Stuart can have a seat here. All right. Let me just grab my stuff. Okay. Nice to see you.
Well, hello. Anine, bonjour, nice to see you all. It's a beautiful morning here. I want to thank Creator for bringing us all together here this morning, and thank you for welcoming me to your beautiful territory. I want to say good morning to our chiefs, grand chiefs, hereditary chiefs, elders, youth, participants. I see many counselors around the table and many other people smiling and happy. Wonderful to see you all. Thank you for the warm welcome. And it's my honor to attend. I also want to say good morning to Chief TG, Regional Chief TG. Wonderful to see you. It's my honor to attend the 2024 BC Assembly of First Nations Annual General Meeting held here on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh Nations. I want to recognize Chief Sparrow and the Musqueam people for welcoming us to your territory. Chimigwech for welcoming us here this morning. Apichik Kichinendam, Akinab Kibi Jayanoma Nungum. And I also want to thank, I've got a couple of knowledge keepers with me, and he knows one of the chiefs around the table. So I want to thank them for traveling with me this week. It gets a little tiresome on the road sometimes, so I uplift our elders when they help us move forward in a good way. This is my 5th visit to Coast Salish territory in my first 10 months as National Chief. And every time we are here, we learn so much from each and every one of you. And we leave here eager to return again. This is the case when I was 4 years old, coming to this very community. I think there was a AFN meeting here when I was 4 years old. My dad was a young counselor, and the chief had brought us from our community by car. And the entire country came together, and nobody really was in airplanes at the time, but we all came together from coast to coast to coast in this very land that we're standing on. So it's got my heart from when I was a young child, remembering that and watching many of our old chiefs speak about our rights and trying to find a different way for First Nations people forward. I know that's going to be the case again this week. And over the past year, we have had the privilege of meeting with chiefs and First Nations across this country. During these gatherings, it's always wonderful to see our chiefs and assembly alive and well. And we are optimistic and excited about our future together. First Nations, from coast to coast to coast, are demonstrating we can manage multi-billion-dollar projects and lead this country. You don't need to look much further than Vancouver's skyline to see the impact First Nations are having in this province alone, and I commend you all. With each day, more Canadians are understanding that First Nations success is Canada's success. We are witnessing a shift, and I'm so glad that you're all part of it. Excuse me. Our Assembly has come a long way over the past year, and today we are energized by diverse opinions, not threatened by them. Today, we are an Assembly unified behind a common belief that First Nations families should be empowered to care for your own children. And I think before I get into that, I just have to say, I was talking to my friend Perry Bellegarde last week, and he says, speak more, reminding First Nations to occupy the field, do your own laws. I know that this is one program, and this is one section of it, but creating our own laws, creating our own space within our communities is the way that we all should be moving forward. Telling governments exactly what you want and how they're going to govern you when it comes to our children. It's such a tough issue, and I know that it's a sensitive issue, as I've heard across this country, speaking to chiefs everywhere and people everywhere, how we see a broken system amongst us, but we're trying to find that way forward. So there are many issues that we have worked on during our first year here, the past few months, on policing, the infrastructure gap, the calls to justice, calls to action, and economic reconciliation. Ottawa certainly isn't short of issues that they need to work out with each and every one of you. But today I want to use my time to talk about the most precious resource, which is our children. For too many years, we have been fighting in courts to fix a racist child welfare system that picked up where residential schools left off. And because of our unity in this fight for justice, we reached a historic turning point last year with what was at the time the largest compensation settlement in the history of this country. And I lift you all up for that. I know that at that point there was many resolutions on the floor at the Assembly, and people came together and they came out of there with one resolution, and I commend you all for that. We also owe a debt of gratitude to the representative plaintiffs for their resilience throughout this process. They have been pillars of strength for the thousands of children and families who experience discrimination. While we made Canadian history with a $23 billion compensation agreement, we know there was much more work to do. So we didn't stop there. In June, we received a federal court approval of a distribution protocol, which will allow for compensation to start rolling out this year. We also secured a commitment from the Prime Minister for a formal apology in the House of Commons. This is a top priority for me over the next few weeks. We get him moving on that we get working on that, and that we do that together. In February, and I want to lift some of you up, some of the elders that are here. I know we'd asked them for prayers at that time, right before the Supreme Court ruling, to do ceremony across this country, because I think something that huge, and I know Jody Wilson-Raybould and I heard her speak about this, and I thought, yeah, she's right. It could have set us back 50 years, but it really pushed our rights forward. So I know that we celebrated that historic victory at the Supreme Court on the constitutionality of Canada's Act regarding First Nations children, youth, and families. With this ruling, the Supreme Court acknowledged Canada's Constitution allows pathways to recognize First Nations inherent rights. For too long, the provinces and territories have held up or obstructed this recognition. Now they must acknowledge First Nations jurisdiction and the necessary paramountcy of our laws. As significant as it was, the Supreme Court's decision left issues regarding implementation of the Act unaddressed. Sustainable funding remained unaddressed. We had $19 billion for the reforms, but we needed more. Without this, the promise of the Act will not be realized. So we did not stop in February. We went back to the table and we kept talking and talking until July. During the Chiefs Assembly in Montreal, we finally completed a draft agreement with the Government of Canada. That's the one that's before you now. And that guarantees a minimum of $47.8 billion for long-term reform over the next 10 years. In addition to setting a new Canadian settlement record, this proposal helps Chiefs and First Nations develop laws and budgets with certainty and insulated from the next 2 federal election results. Everywhere we travel, Chiefs are saying it's time to empower First Nations families to care for our own children. It's time to put First Nations in charge once and for all. That is why that's what we're trying to do with this draft agreement we reached with Canada in July. And as I say, it's draft until you say otherwise. We are pleased to talk about it today and to respond to some of the questions we have been hearing from Chiefs. I know that we have about 6 major updates. We've heard you, Chiefs. I know Stuart's here and he'll speak a little after. But first we want to stress that $47.8 billion is a floor because unfinished business remains. There are outstanding issues beyond the mandate of the tribunal. This agreement does not deal with statutory funding or address children off reserve. It does not directly address the failures of our provincial governments. And those are outstanding issues that each and every one of us are going to have to do across this country. Provincial governments have a lot to account for, and they should not be let off the hook for their role in perpetrating this racist system. In BC, First Nations children are almost 20 times more likely to come into government care than a non-First Nations child. These are the next battles to fight. We have never stopped fighting for First Nations children, and we won't stop after this agreement is approved by Chiefs later this month at our Special Chiefs Assembly on Treaty 7 territory in Calgary. Excuse me. We believe the terms and guaranteed funding in this agreement finally give control back to First Nations rights holders. It provides us with a real opportunity to finally start fully investing in prevention instead of rewarding apprehension. So what does this agreement mean to Chiefs in BC? First, it means a 50% funding increase for programming over the next 5 years. At the midway mark of this agreement, BC First Nations will receive an additional $1.9 billion. This does not include other federal investments in housing and capital. 2/3 of the total $47.8 billion will flow to First Nation governments once the draft agreement is signed and approved by the Canadian Human Rights Tribunal. We will be ready to sign it after the Special Chiefs Assembly. As I said, we're looking for your support on that. The other third, or $16 billion, will go to support First Nations children and family service agencies to continue their specialized and legislative intervention supports. Contrary to some reports, the Assembly of First Nations does not receive funding under this agreement. But I want to make it very clear where we're coming from on this. Agencies that provide child and family services should not be the ones deciding what is best for your First Nation. That is up to the rights holders, that is up to the Chiefs in Assembly. That is why we are pleased that this draft agreement puts decision-making back in the hands of your communities, exactly where it belongs. If this agreement is approved, the rights holders will have all the flexibility that they need to do what you think is best, to address areas where more resources are required. No First Nations will lose anything with this agreement, which starts getting us away from the status quo that has been holding us back for too long. Funding rates will be adjusted after year 4 and year 9 to ensure reforms continue to be effective and responsive to current needs. Decisions will be made by our communities, not by those who benefit from the current system's failures. And contrary to some misinformation, funding will continue beyond the agreement's 10-year term. It acknowledges Canada's ongoing obligations to First Nations children. Another key feature for BC Chiefs to be aware of is this agreement's dispute resolution mechanisms. As we put more control back in the hands of rights holders, the dispute resolution process envisioned for this draft agreement will be entirely First Nations led and entirely dedicated to child welfare reform. This is an improvement from the Canadian Human Rights Tribunal. While we have had success with the tribunal, individual First Nation complaints can take years and incur large legal costs. The new dispute resolution process in the draft agreement is more efficient and fully accessible to First Nations and agencies, and the entire process is paid for by Canada. There is more to talk about in this agreement. I think it's a fair deal and will be good for our children today and in the future. But I want to first acknowledge that it is not perfect. This is where the dialogue we have been having with chiefs across the country for the past 2 months has been so important. We want to thank chiefs that have been spending hours in meetings, going through this agreement over the summer and the fall, and participating in this meaningful dialogue. This is the Assembly of First Nations at its best when we're together like this. We've been honored to be invited by many chiefs to visit their communities and to talk about this very difficult issue. These are not easy conversations for any of us. All of us have been affected by this in one way or another. Monday, I was talking to chiefs in Manitoba. Yesterday, we were talking with chiefs in Alberta. Last month, we were in Shuswap, Nicola Valley, and the Okanagan here in BC. The weeks before, we were in Quebec and Saskatchewan, and in August, we were in New Brunswick and Nova Scotia. And many say they're eager to move ahead, support the agreement, and take the next step to turn this racist system upside down. At the same time, we have heard other chiefs say that they need more time. And we're glad we listened. We delayed the Special Assembly by a month from September to next week. And I want to recognize Regional Chief TG for your advocacy on this and other important files. In addition to providing more time for chiefs, this extra month has provided us with a chance to improve the draft agreement to reflect constructive suggestions received over the past couple of months. These will be translated and circulated to chiefs this week. I know that Stuart has many updates and the revised agreement that should have went out yesterday. For BC Chiefs, we want you to know that we have heard you loud and clear on regional representation on the agreement's important implementation oversight committees. This is why we've made sure that you will rightfully be included in the representation from BC. We will make sure that that happens, and that's in the new agreement, and it's in the wording, so Stuart can go through that when he comes up. We are also pushing to ensure population data, including off-reserve members, is properly accounted for. Another comment we heard during the dialogue was this idea that we can get a better deal if we hold out longer. My response has two parts to that. First, we are making the agreement with some of the improvements that I'd referred to. And second, we are not done fighting. And this agreement represents a strong floor to fight from. United will be in a much stronger position to take the next steps in our collective battle for First Nations children off reserve, statutory funding, and provincial accountability. Still, some chiefs may want to vote against this historic agreement because a better deal might appear. With respect, this approach ignores Canada's current political reality. You don't need to be a political scientist to figure out we will very likely be dealing with a different government sooner than later. And do we trust a government? We know how it was with them a decade before that to negotiate a better deal, and based on the history that we know. In my first 10 months as national chief, I've worked very hard to reach out to all the opposition leaders and meet with them and meet with their spouses and their families. And I just have to say, I believe that there's some common ground on many of these issues. But I can't stand before you and guarantee that this will be the commitment again. As the current Conservative leader, we've met and we talked about different programs. We talked about policing. We talked about a new deal on fiscal relationships with First Nations. We talked about many issues. Child welfare was something that I talked about, and I don't know if there was, on the other side, if there was that willingness to talk about it. So I know timing is, as the Conservative leader said, he said that he won't cut into programs that are already in place for Canadians. So I say, let's get this program in a place before the next election. Let's support this agreement and go united in our next battle for the health and well-being of First Nations children and families. Many issues to deal with. We still have to deal with Jordan's Principle down the road, and we have to do that together. So there's no getting around the fact that the rejection of this deal will be a significant victory for layers of those benefiting from the status quo of discrimination, pain, and suffering. Rejecting this agreement not only risks losing this funding commitment, but also the significant momentum that we've all built together since 2007 towards long-awaited reform in child and family services. This is why it's so important that we move forward together now to ensure the needs of First Nations children are met now and in the future. Let's never lose sight what this work is all about. It's about seizing this opportunity for our children, for our future. And as I conclude, and I look to all of you, I can't think of how far we have come together, about things were like when I started working for First Nations as a young woman. I come from a community in Manitoba, and back then I worked for a regional chief and different, and of course Phil Fontaine was national chief at the time. And 25 years ago, we had done polls across this country, and it was such a low public opinion poll that the pollsters didn't even want to tell the regional chiefs or the national chief in that room what average Canadians thought of First Nations. One magazine, Maclean's, described my home province, Manitoba, as the most racist province in Canada. And now we have our first First Nations premier. So, and last week was the 1-year anniversary of Premier Canu's election. But this progress is not always guaranteed. I'm glad that we went that way. And I commend all of you for UNDRIP, for your work on that, Chief John, and many others that worked on all these issues the last 25 years. And we're going on a good way, but we still face racism and opposition. Even with this, right? There's a push in Ottawa to wipe that money off the table. And so there's much work to do ahead, but united we can do anything. And we have worked with honor and integrity to fulfill the trust within us. Chiefs, we've been mandated 4 years in a row over and over and over again to try and get an agreement on the table. And we are making a real difference for the future of our families and children. But we can't afford to be complacent. I know we've come far, but we can't afford to stay there. I'd seen a graph yesterday that last year alone, we had the most First Nation kids in care. Status quo is not working, my friends. It's hurting us. It's hurting mothers and children and fathers and families and grandparents. And we have to find a new way forward. At this week's assembly, let's get the business done for the nations that we all serve. Let's share our ideas, debate, and have dialogue, but let's use this opportunity to reflect on our achievements and set the path forward. So I know that there's probably many questions. I'd like Stuart to go through the 6 changes through the agreement. We've heard you, chiefs. And thank you, Chimigwach. Absolutely so thankful to be and honored to be welcomed here today on this very important issue. Thank you for allowing me time to present, chiefs. Miigwech. Stuart.
Thank you. Thank you, National Chief. Stuart is Watke, the legal for AFN, will move to the podium and give some brief comments. He's promised 5 minutes. Oh, he'd like to do it here. Microphone 2, please.
Yes, good morning, everyone. Thank you once again for inviting us out to BC. My name is Stuart Watke. I'm General Counsel with the Assembly of First Nations. I'm originally from Garden Hill First Nation in Manitoba, Treaty Number 5. Now, you received a briefing this morning, and I'd like to respond in some ways, because I think that some of the information that's been provided is not entirely correct. One of the first things that was brought out is that roughly $45 billion is currently protected under CHRT orders. That's not the case. Right now, Canada is operating and providing funding under those CHRT orders, and they're spending about $3.2 billion per year right now. You multiply that by 10 years, that's $32 billion that Canada will spend under the CHRT orders. That's about a $13 billion shortfall compared to the settlement agreement. There was also questions with respect to the CHRT jurisdiction and why the parties are looking to remove the CHRT. The CHRT is a human rights body, and its focus is on human rights legislation, essentially the Canada Human Rights Act. Its focus is very narrow, and the people that are overseeing that are 2 non-native lawyers. And we're putting the fate of all our children into 2 non-native lawyers. I could, as a lawyer, sit on the Canadian Human Rights Tribunal. There's nothing special about it. These people, of course, have human rights expertise, but they're not immersed in our cultures. They have not lived in our communities. They do not understand fully our cultures, and yet you're being asked by certain parties to put all your faith for all our children into lawyers. We're offering an alternative with the ADR process that will be housed with First Nations individuals. It will be overseen by a First Nation judge, and the adjudicators will all be First Nations, and there's going to be ability of First Nations to implement their customary laws in those adjudications. And lastly, there will be duty counsel with the ADR, which means they'll provide free legal services to your communities, and there would be no need to hire outside counsel, that everything would be paid for by the Government of Canada. If you go to the CHRT process, you will have to pay for your own adjudication. And secondly, First Nations right now don't have any standing in the CHRT process. You would have to get one of the existing parties to adjudicate your claims for you. And the AFN does not see that as an appropriate mechanism, considering that First Nations are right holders and they can advocate on their own behalf. Now, we do have some amendments that were brought forward under the, based on the discussions we were having recently. And really, the Reform Implementation Committee is one of the major requests that First Nations across Canada were asking, essentially seeking regional representatives. We did post a revised settlement agreement on our website yesterday, but late last night we received confirmation from one of the parties that one of the amendments we were seeking was approved by them, in which case the makeup of the RIC will be different. I shouldn't say will be different. It will be as proposed. So each region will have their own representative. But unlike yesterday's agreement, the revised agreement that we'll be posting shortly today will stipulate that each region will be able to select their own member on the RIC, and there will be no oversight by any parties in that respect. Secondly, We've heard First Nations very loud and clear through our discussions where they were listed as service providers. We've separated that concept, so First Nation governments themselves have their own definition, and they've been separated from the service provider initiative, the wording in the settlement agreement. Now, we heard this morning of capital funding. The capital projects themselves is somewhat still left vague, and that's on purpose. We are going to leave how capital is developed and administered moving forward to the Reform Implementation Committee. Your regional representative that will be representing BC will have a voice in how capital will roll out and how the capital program will be administered. We can impose on it right now as a parties, but we chose not to. We're going to leave that up to the Reform Implementation Committee, which you'll have a representative on to determine how that will be developed in the future. Another shortfall, of course, was the terms and conditions were not included in the original settlement agreement. All the appendices, including the terms and conditions, have now been included in the amended settlement agreement. And we've also provided an indemnity for First Nations. The First Nations will not be liable for any services that were provided to their citizens prior to a First Nation assuming responsibility over that service. And we've heard very loud and clear that First Nations don't want to be held accountable or liable for actions by the Government of Canada or by third parties before them taking on the jurisdiction or the programming themselves. So we've included that in the settlement agreement itself. So those are some of the major changes that we have. But I just really want to put together in very short order how these reforms came about. Right now, we have a discriminatory funding regime, which Canada said was discriminatory, in which case, when you provide prevention services or other measures to keep a child in home, there's a cap on funding for that. But when it comes to the apprehension of children, there is no cap. And we pose this question in Canadian Human Rights Tribunal: what happens if an agency comes in and apprehends every child in a First Nation community? And Canada said, under the regime, they would pay for it. So when people are asking you to consider actuals and holding on to the actuals process, essentially what they're asking you to do is to hold on to a regime where children can be apprehended by agencies and First Nations have no voice on those apprehensions. Under our settlement agreement, we're making agencies more accountable to First Nations, so there's going to be a cap on apprehension money. If agencies apprehend a number of children and they run out of money for apprehensions, they're going to have to go to the First Nations and work with the First Nations to ask for more money with the federal government. So the days of unhinged apprehensions will be coming to an end under this settlement agreement. First Nations will have a greater voice on what services are being provided in their communities, and the days of government acting alone or agencies acting alone will be coming to an end. As the National Chief mentioned, 2/3 of the money will be going to First Nations directly at the beginning of every year, and agencies would be required to work with First Nations. It's a far better process, we would argue, than what we currently have, where the existing regime focuses on removing children. Our efforts are to ensure that children are kept in the home with the families, their parents, moving forward, and that every measure is taken to keep those children united with their families and communities, as opposed to apprehension. Child welfare right now is a European concept. We all know it has no intersection with our own customs, our own values. So I use this example. Say you have a single mother who's working 2 jobs to put a roof over her kid's head, to put food on the table. Under current child welfare, that mother is being neglectful by not supervising her kids. And in many cases in the past, those children were removed from that mother, placed in a foster home off reserve, and the government paid foster parents to raise that children. We've eliminated that. Under our regime, that mother would be entitled to supports directly from the First Nations, whether it's through prevention, as far as giving her supplements to income, child support, not child support, but child care, babysitters, that type of thing. If there's not enough food in the home, money can be used to provide food in the home. There is no reason to continue to apprehend children, and that's what this settlement agreement represents. It's a clear departure from the existing child welfare system. It puts First Nations in the control of child welfare, and change is hard. And when you look at the human condition, it's easier to take the least opposition to move forward. Right now, it's easier to apprehend a child and put him in foster home, and that's it, and you don't have to do anything else. It's much harder for a child welfare agent to actually work with the family, provide programming, find programming for that family, make sure those services are being provided. It entails more work, but it keeps the family united, and that's what this agreement represents. So there are strong points with this agreement, and once again, we recommend that you approve it. The last thing I would like to say is people have been referring to this clause in the agreement that says AFN has to support this agreement or promote it. Everybody knows here, no one's bound by an unsigned contract. That agreement has not been signed. There is no legal obligation for AFN to endorse this agreement whatsoever. We are bringing forward it, we are recommending it because we think it's a good agreement. But the idea that we're legally bound to promote this agreement is completely false. Once the Chiefs and Assembly approve the settlement agreement and the agreement is signed, then those provisions will come into play, and it's meant to protect the agreement's integrity. Once the agreement is signed, we don't want a new Canadian government coming in trashing the agreement. That clause will prevent a Conservative government from coming in and saying the agreement's horrible, we should do away with it. They would have to support it. So it protects First Nations just as much moving forward. So that's the intent of that clause. It has nothing to do on our activities at this point. So thank you very much.
Thank you. Thank you to Stuart and National Chief. If we could have a round of applause before we go to questions and comments. Thank you. I would like to say thank you to the elders and diabetics that have gone to serve themselves. You see that we are having a working lunch, so if you wouldn't mind to quietly do that, that would be great. And we're open for questions and comments. I have microphone 18, then microphone 23. And just asking for us to be as succinct as possible so we can get as many delegates in as we can. Thank you. Microphone 18, Mary?
I guess I have, there's just so much to unpack. There's so many untruths, I guess, to be very clear. One of the things, the definition of insanity is to keep doing the same things again because you'll get the same results. Now let's learn from the compensation final settlement agreement, where that compensation final settlement agreement wasn't even provided to the chiefs before it went up for approval. And let's think about what was that compensation amount at the very beginning that was signed by you, Stuart, that was negotiated apparently by you, and also endorsed by the sitting national chief. So that was $5 billion. $5 billion. We went to 20 billion, and we were going to leave people out of that. And so again, we had to make a stand for those children and families that were going to be left out of the compensation. And again, we asked for accountability. We asked that free, prior, and informed consent was respected. And thank God to the tribunal, thank God that we got an opportunity to provide input into that. So that was 23.4 billion. I have a question. How much, Stuart, are you getting paid now that you're on the sick as well? Also, how much is the lawyers getting paid that actually worked on the compensation? I believe that was Corbière yourself. So we need to know, we asked that before, we still have that question left unanswered. We'd like to know, how are you getting your direction? So we have a resolution, very clear, the resolution that speaks about providing options to the chiefs before any final settlement agreement is done, to give us ample enough time to review that. And so I'm wondering, at this point, just for process matters, how are you receiving direction? Because I was in those negotiations table, don't forget. And when the post majority came up, you said, oh, let's give it to all the chiefs. You hadn't even gone back to seek direction, but so I would like to know a very clear process. I do believe that some of the comments, again, you know, the Canadian Human Rights Tribunal, I don't know if I've heard anything as ridiculous that it's not culturally appropriate, but yet we're going to go to an ADR that's been untested, not tried, and is overseen by Canada at the end of the day. And so when we look at the agreement, the decision-making, our Indigenous rights as leaders and as a hereditary chief, we have say. And so this agreement leaves the predominant decision-making to go to the chiefs of Ontario, NAN, AFN, and Canada. And that, to me, doesn't even follow FPIC, never mind our Indigenous rights and our self-determination. So I think there's very skewed presentation here. The other thing too is to be very clear, 379 of the agreement, the parties shall speak publicly in favor of this FSA and shall make best efforts to procure the endorsement of this final FSA by First Nations leadership. So in that's what you're working with Canada. Canada still has a duty to consult. It can't offload that duty to you and to your staff to go around BC and have these webinars where there is no process for input or amendments. That's what free, prior, and informed consent is, that there's an actual process to hear the people's voices. At the table, at the negotiating table, there was no experts there. I've heard many disparaging things about the agencies, and yes, some of the agencies and the nations, their relationship isn't that close, but some are great for the most part. So if you look at how many nations have chosen, this is their free, prior, and informed consent. They've chosen to have services provided by an Indigenous agency rather than a provincial system as a stepwise approach. That ought to be respected and not made as if it's a bad thing. That's a chief's decision. And so you're questioning the chief's decision-making when it comes to them choosing to be part of an agency. You're undermining and you're devaluing their decision-making. And I think that you owe us that have been fighting in this fight for so long an apology. All those good people here that have decided that their nations are going to be served by an agency instead of the ministry. I'm really, again, very disheartened by that. What you're doing right now is dividing and conquer. And that's what we don't want to have. What we've been saying at the Caring Society and what I've been saying as a hereditary chief is that it's a yes and approach. The very reason we went to court in the first place back in 2006 was because the agencies weren't receiving prevention funding. You know that. So what you're proposing in this agreement is to go back to what the conditions were in 2006. That does not make any sense. And again, the definition of insanity. So what we're proposing is a yes and approach. This agreement goes far short of that. There can't be any fear-mongering. We know that the Canadian Human Rights Tribunal orders extend to any government. What we do know, again, is that the law of Canada is that no sitting government can tie the hands of any succeeding government. We know that. We're not going to take a chance on annual appropriation that the Poilievre government is going to be very, very considerate of what we need. So I just need some of those questions answers where you receive your directions. What are you getting paid as part of this SIC? What were the lawyers getting paid for the compensation, the lawyers that represented, wasn't it Corbière and Nagaba? We need to know what that was, what that was. And then we also need to know, why is there not even a process to include experts, especially the National Advisory Committee on Child and Welfare Long-Term, in this agreement, because our children deserve the best, and definitely this is not the best. Masai, thank you.
Thank you. Thank you, Mary. I'm just trying to organize our time. I'm wondering if there are anyone else that would like to have a question or comment to National Chief, so I can figure out how much time we... Okay, thank you. So I have 6 altogether, so I'm going to take 3, and then we'll come back to I'm still going to take 3 at a time, but we're going to get to everybody. So we had 18, 23, 12, 20, oh, I got 23 twice. Oh, shouldn't. Yes, Harley, that's right, Harley. Thank you, Harley, Chief. 29, 9, and 24. Okay. There we go. And 14. Okay, that's going to be my speakers list. Checking online. I don't see anyone online. We're going to work with this because National Chief has time. Well, we already kept her waiting, and there's a time that there's a drop dead time, is all I'm trying to say. 3 at a time. Asking chiefs and delegates to be as concise as possible. I'd like to go to microphone 23. Chief Ed.
Thank you. Thank you. I want to wish my daughter a happy birthday today. She's just walking out the door here. Beautiful young lady. Sorry, Rissy.
He's not sorry.
She loved to say October 9th is her birthday when she was young. So I just want to, again, thank Stuart and National Chief for your otherwise different, decidedly different presentation. And some of it leaves me a bit confused. I gather Stuart was saying that there was a revised draft of the agreement, and I wonder if we would have that so we could take a look at that. It'd be useful for our information today and for next week. Second concern I had was regarding I heard very clearly Mary T.G., our colleague here, who's been involved in this for a long time, saying that there was $45 billion under the CRT, Canadian Human Rights Tribunal orders. But I heard Stuart said, well, it's not right, it's 3.2 billion. So over 10 years, he was saying that's 32 billion. That's a bit confusing for me. The last question, suppose now we're able to go to Canadian Human Rights Tribunal for any other funding, and the resolution says there's short funding. If we were able to proceed to a CRTC hearing, what other additional funding would we be looking for? That would be the question. Would that gap be covered by the if it's 45 billion, would that be covered by the 2.5 billion that's in the final settlement agreement, or is it something decidedly different? I don't see any cost estimates as to what other services where we might be shortchanged and what the value of these services might look like. So thank you.
Thank you, Grand Chief Ed John. I'd like to go next to microphone 12, Chief Don.
Kinwam, National Chief, it's good to see you. A couple questions. I'm trying to scribble down, and now I got to try to read my scratches. First, I wanted to say I just sense the polarized discussion here, and it seems disrespectful. We need to put the children in the center and consider those as opposed to getting oppositional. The July settlement agreement that was shared, it did neglect the 204 First Nations in British Columbia. You need to accept that was wrong. And I hope that the same mistake is not going to be repeated in the amendments. Not just looking at the one table, but I understand there's multiple tables. And so I'm hoping that that the BC, the rights holders, are going to be respected in those amendments. Again, not being positional or adversarial, but being empowering and advocating for me for all of us. The 2/3 of funding that's going to be going to the First Nations directly, I think I heard you, Stuart, saying that then it would be up to agencies to negotiate with the First Nations and how those are shared or allocated. And so I wonder there, in terms of the liability, you know, are the First Nations now assuming the liability associated with these? Here we are, we're talking about billions of dollars in settlements. And so for First Nations, as we're building up our capacity and we're growing our self-determination and self-governance, it would be, I guess, dangerous to be assuming that liability right off the bat. And then I really like your story about the single parent, not just single moms, single dads too, and the neglect if they have to work 2 jobs. And so is that, how does the settlement agreement make that reality? Because it seems that that's a possibility, but it's not necessarily part of the agreement. And I think the last question that I had was in regards to Métis, and in you know, if 2/3 of the fundings are going to the First Nations, and in British Columbia we don't have Métis settlements, but we have many Métis and multiple organizations representing them. How is that considered? Thank you.
Hello, thank you, thank you. I'd like to go to, should we go straight to Stuart or National Chief? Would you like to make a, please? You'll close, okay.
No, thank you, absolutely. No, I'll have Stuart go through all the technical pieces and then I can close off at the end, Chiefs. I know there's lots of technical discussion to talk through here, and I just want to make sure that we hear you and that we're hearing you, because we are, like I said, this is your agreement, this is your money, this is your yes and your no, and I don't ever want to take that from you as National Chief. And I know that it's hard when we're shifting a whole bunch of money from the provinces to First Nations. I know that it's a big decision for all of us, but I really believe we're doing what's right, and I really believe that we put more power into the hands of First Nations. That's how I was raised. We're capable, we're able, and I know that there's lots of technical questions, so I want to hear from you. I don't want to take much time, but I want Stuart to clarify many of those technical issues, because you have legitimate concerns, and I'm so glad that we're finally invited here to speak and talk to you today. Thank you.
Yes, thank you for the questions. I'll be happy to answer them. I do want to deal with the perception that, you know, the AFN's trying to divide and conquer. That's not what we're about. We recognize the good work that many agencies are doing across Canada, and the social workers have a very tough job in intervening with families in crisis. We recognize that. The AFN, since we filed a complaint in 2007, have been supporting agencies. We have been advocating for them. We've been going to the CHRT, getting orders that were in favor of the services that they provide. So, you know, we are not being disrespectful to agencies, but we also hear many stories of children going into care, being placed in the foster homes, and a number of things happening to them. We also know that when a child is separated from their family and communities, the loss of their culture, their language, the attachment to their identity has a profound effect on these young people. So the work that we're trying to do is to ensure that those good relationships that First Nations have with agencies will continue. But we do know across Canada that there are some agencies that have a very bad relationship with their First Nation governments. In many ways, they operate similar to the way the provincial governments used to operate. They go into a community with the RCMP, they remove kids, they don't tell the chief and council, and it's the way they do business. Right or wrong, that's what the reality is in some communities. But what we're looking at doing is looking at how can we strengthen those relationships. And it's really about, right now agencies report to Canada, they report to the provincial governments, and they report to First Nation governments. We want Canada to just be the funder. And they'll get audited financial statements, and that's the end of the story. With the provincial governments, we're trying to oust their authority as much as possible. They do have legislative jurisdiction over the services. We can't do anything about that under this agreement. But through the funding mechanisms, we can remove them as much as possible. And that leaves an agency's relationship with the First Nation government that they serve. And that's really what this agreement is looking at doing. How can we foster a more positive, a better, beneficial working relationship where we try to cut out 2 levels of government? That's what we're looking at doing. Now, Ms. TG talked about the ADR process being untested. The ADR process will be overseen by a former First Nations judge, someone that's far more qualified than 2 lawyers to adjudicate cases. The adjudicators themselves will be made up of First Nations individuals. And as I mentioned, if your community has an issue or dispute with Canada, you can bring in your customary laws into that adjudication process. You can't do that with the Canadian Human Rights Tribunal. With the Canadian Human Rights Tribunal, your First Nations have no standing currently to bring any dispute forward. You would have to do it through one of the parties. What that essentially means is that the parties will have ongoing care and control and oversight over this whole program in your relationship with the Government of Canada. That's not an appropriate role for any party at the Human Rights Tribunal. That belongs solely between your nations and the government on a nation-to-nation basis. You don't need AFN, you don't need the Caring Society to prosecute your claims for you. So it's really that control aspect that we're trying to eliminate as well. The AFN has nothing to do with policing relationships. It's not our role. Now, Chief John talked about what other additional funding we'll be looking for. So I can mention, as I mentioned, and Canada's here, they can probably confirm, they are complying with CHRT orders right now on the Child and Family Services Program, and they are spending $3.2 billion per year. That's a fact. So the argument that roughly $40 billion, $45 billion is protected, it's not true. And if you look at the orders, for instance, on post-majority support services, there was a consent order on post-majority support services which expired March 31st, 2022, or 23. That order has sunset. There is no obligation for Canada to provide any funding for post-majority services. When it comes to housing, we have $2 billion in housing in the settlement agreement. Canada, the tribunal has no jurisdiction to order anything on housing. The band representative program, we have funding across Canada for that. That is only required under Ontario's legislation. There is no obligation, and the tribunal has no jurisdiction to make orders on that as well. Now we hear that we would like off-reserve to be included in the settlement agreement. I agree, it would be nice for off-reserve individuals to be included in the settlement agreement. Canada obviously did not agree with that. But in any event, the idea that we can go back to the negotiating table or go back to the tribunal and get off-reserve included is not possible. The tribunal has no jurisdiction to make any orders regarding child and family services for off-reserve children. So on 4 fronts, right off the bat, there are faults with the Canadian Human Rights Tribunal process. We've included all those things in the settlement agreement, which will be guaranteed for 10 years and potentially beyond that. And, you know, we've heard from legal counsel today, and hopefully they look at the orders themselves and make an assessment on exactly what the orders say. All the orders right now in the Human Rights Tribunal are interim in nature. Any party can go before them, file a motion, and seek final orders. Canada could do that, and we'll be stuck with whatever the tribunal orders we'll be stuck with. So we do see that working on the settlement agreement is a positive way. With respect to what other funding is out there, so we based our reforms on IFSD, the Institute of Sustainable Development and Democracy, who the chiefs in Assembly have mandated us to work with to look at the long-term reform funding approach. And we have done that, and we're based, all our funding approach in the agreement is based on their recommendations. I also should mention, Ms. TG asked me how much I'm making. I personally don't think it's any of their business. But I am an employee of the AFN. I get a salary and that's it. I don't get any money from the SIC. It goes to the AFN. I get no money. I get my salary, that's it. Much like the rest of my staff. Now we know that the Caring Society is lawyers. We don't know how much your lawyers are getting paid. But in any event, I don't want to argue. But you know, as far as the compensation agreement, it was mentioned that at first it was $5 billion, then it was $20 billion, and $23 billion. The $5 billion was only for one class, and that was for the removed class at that time. So we were able to make enhancements to that, but that $5 billion was for only one group. We have 8 groups in our settlement agreement right now, which it makes up the $23 billion. With respect to the other questions on polarizing discussions, and it's clearly we don't want to polarize discussions. We clearly want a good working relationship with all the parties, and we've been working towards that for the longest time. Now, the settlement agreement, unfortunately, did neglect BC First Nations, and it's unfortunate. This whole process is a product of litigation. And we have 5 parties right before the Canadian Human Rights Tribunal, and the tribunal ordered the 5 parties to work together to negotiate a settlement, to come up with solutions for the tribunal to consider. Now, it's not the most ideal process, and clearly, if every region was representative, I think that definitely would have had better results, or it would be, we would have had a number of perspectives that we could have considered. But those were the cards the AFN was dealt with. We had a tribunal with 5 parties, and the tribunal made an order ordering us to do something, and we were fulfilling that order. Moving forward, we recognize that BC has a strong voice and needs a strong voice, which is why they have a representative at the Reform Implementation Committee. That committee will be responsible for the implementation of this settlement and all the reforms that are that are included in it. So when it comes to the various reforms such as prevention, housing, post-majority services, that committee will be making decisions on how that's implemented across the board. And if there are shortfalls, if there are gaps that accumulate over time or become apparent over time, that body will have the authority to make recommendations and to look at fixing those gaps. BC will have a voice in that, as well as every other region across Canada. And we are looking at respecting the rights holders. As I mentioned right now, under the current First Nation Child and Family Services program, there's not a lot of room for First Nation governments in that. We are reforming the program so that First Nation governments have a stronger voice in the program itself and how services are provided to their communities. Now, the question on liability and is it dangerous? So the way the reforms are working, and you heard this morning that they're saying that prevention services will be taken away from agencies. That's not accurate. When it comes to prevention services, there are three types of prevention services. There's primary, there's secondary, and there's tertiary prevention services. The agencies will be responsible for tertiary prevention services. Those are those prevention services that are mandated under provincial legislation. And that funding comes from their protection funding. They are fully funded to offer prevention services. The primary and secondary services that we're offering are outside the child welfare legislation regime. For instance, if there's not enough food in the home, First Nations would be funded under their prevention funding to provide food to that parent. There's not much liability associated with that. If a family, an adult parent has addictions issues, rather than referring to the child welfare system, the First Nations will have funding to look at providing counseling for them or programming for that individual. There's not much liability associated with that. So the types of services that First Nations will be administering are really those poverty-related driven issues. When it comes to housing, for instance, there's ability to do renovations, that type of thing. On post-majority services, it's really those services that a parent would normally provide an adult child. The child moves out of home and goes to university, the parent normally provides financing for their rent, books, public transportation, food, that type of thing. Those are the types of services that the First Nations will be rightfully providing. Also in post-majority, they can be looking at reunification programs, bringing children that were in care back to the communities. So when you look at it more broadly, those mandated services that are required under provincial legislation will rightfully remain with the agencies themselves. And the agencies themselves have protection under legislation with respect to liability. When it comes to the services that First Nations will be offering that's contemplated in their settlement agreement, it's really alleviating those poverty drivers. And when you deal with issues such as not enough food in the home, at first it's not a child welfare issue. But over time, if there's malnourishment, it will become a child welfare issue. The prevention services that First Nations are getting are meant to deal with those crises before it reaches the stage of child welfare intervention. So hopefully I've answered all your questions. And again, we're hoping that this agreement itself does foster good relations. And we don't mean to in any way drive a wedge between First Nations and our agencies. We recognize the good work that's out there, and we recognize the very hard work that many social workers work under. Thank you.
Thank you. I know that we all have opinions about everything that we're talking about. I know we all have the authority and the mandates from our communities to be here. I want us to respect the decorum of this organization, and I don't want us to have any outbursts. When we invite people here in our Hualmo Kosalish way, when we invite people here, we invite them to have the discussion with us. And if I could ask the gents over there on the AV to make sure that my mic can interrupt quicker, that would be great. I would appreciate that, because it is not our way to, we're not trying to fight here. We all have the same goal. We all have those children in the center, and that's what we're all doing here. Thank you. Now, we have 5 people left on the speakers list, and I'm respecting National Chief's time. National Chief said she will hear from all of you. And if we don't get all the answers from all of the questions, we have Matthew, one of our technicians, who will be taking them down so that they can go with, because I'm assuming they're all going to be technical questions, but I don't know that. So we want them to be able to, we want the AFN to have the opportunity to respond and for you to have the opportunity to receive. Okay, so thank you. And also, when you speak, I mean, I'm recognizing the red lanyards. I don't know everybody by name, so if you could say your name and which community you're representing, especially if you have a proxy. I know you all have a red lanyard, but I don't know everybody, and it will help me. Thank you. Now, I wrote down numbers. I'm going to wing it, but I know that I have Chief Harley at microphone 23. Here's the order. Chief Harley at microphone 23. Chief Linda at microphone 29. Chief Shanna at microphone 9. Chief at, I want to say Johnson at microphone 24. I'm hoping, I must not have got it wrong because poor guy didn't look up. And Chief Dan Manuel at microphone 14. That's going to be our order, and I am asking you to be as concise and as brief as you possibly can, and I'm sure you can comply. Chief Harley.
Yes, Harley Chingy, McLeod Lake. Half a decade ago, Doug Kelly came before the Leadership Council, UBCIC, and all the other First Nations groups with his First Nations Health Authority negotiations. The same agitators that are at the table today were the same guys that were wanting to take over the negotiations from Doug Kelly back in the day. I backed up Doug Kelly and I said, keep going forth, my friend. You're doing a good thing. Today, First Nations Health Authority is the only First Nations run operation in Canada. Hats off to Doug Kelly for holding his ground and moving forth. Very few people stood beside him. I was one of the few. Today, we all benefit from that. Today, people are trying to destroy what's being done by AFN National Chief and her team. They've been called liars. They've been stepped on, they've been spat at, they've been talked down to. Very disrespectful, very disrespectful. You know, we all have a vote next week in Calgary. Each of us representative of our nations. We all have a vote. On one side, you say, people are saying that this province, that province, and another province are all against it. I hear otherwise. I know a lot of chiefs throughout Canada, and I know there's a lot of support for this agreement. I speak for my people, and I speak in support of this agreement going forth. It's for the benefit of our children. Thank you.
Thank you. Thank you, Chief Chingy. We'd like to go next to Chief Linda Price. Microphone 29, please.
Thank you. I just want to, Chief Linda Price, Algatra First Nation. I just want to thank you, National Chief and Stuart, for coming today to our assembly. We really appreciate it. I heard Stuart speak on the draft FSA, however, not on the shortcomings of the agreement, and I would have liked to hear about that. I think those are some of the issues we need to focus on as we move forward from it. I just wanted to say that here in BC, we are used to a more thorough consultation process on matters. I recall when the master tuition agreement expired for tuition for our children attending public schools in BC, the MTA was a legal instrument that enabled the feds to transfer funds to the province for tuition in BC. We had all types of inequities on that matter. And I recall all of the discussions that we had about it. And finally, we came to, a conclusion. So I really believe that it was important for us to be more involved. We needed to I guess, have more information out front. And I recognize that it was a legal procedure. And obviously, sometimes in the legal processes and negotiations, we don't have privy to the information. But I recall when I arrived in Montreal in July 2024, and we had to address this matter, a lot of the chiefs in assembly had discussions, and they were very concerned that they hadn't seen this document. And we had to go back to our communities, and there was this big announcement, public announcement, and lo and behold, we hadn't even seen the document. And so we had to go back to our communities and explain to our members that, in fact, we hadn't seen the draft document, that it was actually a draft document that we hadn't seen. So I think it would have been nice if we could have had a more thorough consultation process. And I know, Stuart, you indicated that if every region was represented, that we would have had a better result. That's what you just said. So I recognize that, there was a little bit of a gap there. And it would have been nice if we could have, had that filled prior to this. Thank you, Chenaria.
Thank you, Chief Linda. We'd like to move to microphone 9 and Chief Shanna, please.
Hi, Shka, thank you. Lakala Watsat, Shanna Thomas, Hereditary Chief, Lyakson First Nation. Just want to thank you for the discussion. Just a few points. One, when we talk about the implementation of the UN Declaration here in British Columbia, we talk about free, prior, and informed consent. And that's not only a standard that we hold the Crown to, that's a standard we hold ourselves to. And this agreement is woefully inadequate for the implementation of free, prior, and informed consent. I think it's important to recognize that in British Columbia, we're not sleeping on our rights. In British Columbia, the leaders of this province have been at the forefront of every initiative and every battle. The leaders of British Columbia have supported the work in every aspect that they can that advances their community. And I apologize to Chief Chinji, but I disagree. It was not Doug Kelly that created the First Nations Health Authority. It's the chiefs of British Columbia that created the First Nations Health Authority. And each region had a member on the team that went into their regions and advocated for that agreement. They also answered all of the questions, and it was the chiefs that came together. So it was a grassroots initiative that involved all of the regions in British Columbia, and all of the regions had a voice and a representative. So I just want to make that super clear. When it comes to the work and moving forward, it's not, for us, we're used to having to deal with highly confidential and sensitive information in British Columbia. We sign non-disclosure agreements all the time so that we can be engaged and involved. And it's really concerning to me as a new chief. My uncle was hereditary chief for 30 years. To know that the one advocate that we have at the table, Regional Chief Terry Teegee, was not involved in this discussion. Wouldn't have been difficult for him to sign a non-disclosure agreement and have a conversation. It also wouldn't have been difficult to have a dialogue with him about what he thinks BC would be looking for before you go into the negotiating room. There's lots of ways to bring British Columbia's voice into the work. When it comes to the agencies, I've said this consistently over the course of all of the discussions, our communities in British Columbia create the agency. The agency answers to us. There's not, for us, there's not a disconnect, an us versus them. They are us. They are acting and engaging and implementing the direction that we give them. So I'm super concerned that the chiefs are being asked to vote on something that they didn't have a role in creating, that their regional chief, who is their representative, did not have input into, and that's after the fact. This is exactly the kind of thing that we fought against in British Columbia, negotiating something and then coming to us after the fact. So I just want to thank folks for the discussion, but just to remind us, that British Columbia is very serious about the implementation of our rights and title. We don't have very many pre-Confederation treaties in British Columbia. We have some, but not many. So we act on these things now, and in the context of sovereignty and in the context of implementing our inherent right to govern. That means ensuring that we're engaged, ensuring that we're participating in the decision-making and that we're making informed decisions. Thank you.
Thank you, Chief Shanna. I'd like to go next to microphone 24, please. Chief Johnson.
Gila Kesla, Rick Johnson, Quixonaquami's First Nation. Just, thought I'd offer some comments. I'm a residential school survivor myself, and most of our village, is under that also. We were taken, back in the day without, we were powerless over Canada. I said last night that when we were taken to residential school, our village was 100% in our language, and we're down to 1 now. And it's and nothing's changed really since then. The policies of Canada and British Columbia, their effort around cultural genocide is just it's still here today. Our most precious resource we have is our children. Absolutely. But we've come a long way over, when I was a kid in school, there were, Section 35(1) didn't exist. It took a lot, it took leaders of First Nations leaders in this country to implement that into the Constitution. So when it comes to free, prior, and informed consent, I think all of us take it pretty seriously. I know, I phoned home last night and I was talking to my brother, and my brother had a stroke 15 years ago, and he said, bro, you know what Chuck Berry said, you got to get it right. And we can't come back later on and, as Shakespeare said, all the world's a stage. We have our exits and our entrances. One man at his time plays many parts. We can't go back to and say, Jesus, I wish we'd done that. We got to absolutely get it right. And, I worry about it's a big number. $45 billion or $47.5 billion. When you break it down, what does that come out to per year, per nation? Is that enough? And how much is the, I haven't heard any talk around how much is the bureaucracy going to take? I'm a commercial fisherman, when they bought us out in the Mifflin plan, $450 million for the fishermen, barely any of that money made it to us for retraining. So, there is that component there around how much is the bureaucracy going to take? I haven't heard that number. And, it's concerning. I mean, I think the 47.5 billion, I don't think anybody's against that, but the process, yes, like I met with Parks last week, and they had a management plan for our territory all written up for us. So the meeting didn't go very well around process and around rights and title. So, I just wanted to offer those comments on behalf of our nation, where we don't have a delegate agency, my aunt the other day, this is reality on the ground. Many of our family members, whether it's our aunts or our grandmothers, are raising our grandchildren, our nieces and our nephews. MCFD came into the village and offered her $100. And that's just the same process that we've been pretty accustomed to. We become, I don't know, we become numb in that area. it's, but, we'll keep trudging forward around that because we've survived that since contact, really. So, I mean, let's get this right, and let's start around the proper process, and I think we can fix that, and I just wanted to offer that. Thank you.
All right, here we are. It's 1:05. We still need to get to Ms. Catherine Lapa. Minister Varani is coming at 1:30 exactly on the Zoom, and we're not going to be able to adjust. And National Chief is being gracious to extend her time with us. I'm going to go to Dan. I'm going to ask Dan, I regret that we have to ask you to be really extra brief, but this is where we are. We have, and Stuart has recorded all of the questions that he needs to comment on. I'm going to ask Stuart if he could make those responses in writing to us and we can disseminate to the chiefs, and then we can leave the remaining time for National Chief to respond back to you. We would like to leave her 10 minutes, and she needs to go by 1:15. So there you go, Chief Dan. I need you to be 2 minutes. Thank you, sir. Microphone 14.
Madam Chair, Chief Dan Manuel, Upper Nicola Band. I just want to, if I have to keep my comments brief, I will reserve my comments to some specific, or to support the National Chief and the AFN for the work that they've done to address this important issue within our communities, a long-standing, as we've heard and all morning this morning and through our dialogue, that these discussions have been ongoing for decades now in relation to the delivery of child and family services in our communities. And the expressed acknowledgement from the AFN staff that the recognition that the agreement does in some cases not go far enough, but we are working towards a collective resolution. As expressed earlier, I was disappointed by the order of the agenda. And I also just want to make a mention, we've here in the previous resolution, as it was discussed, voted against the resolution calling for the BCAFN to reject the agreement or the motions. But I also wanted to acknowledge my colleagues sitting to my left and my right here, Chief Jackson and Chief Seymour, and also the other two chiefs of the Nicola Valley, Chief Marcel Shackley and Chief Lindsay Tai. We belong to a delegated agency in Merritt, the Strockham Child and Family Services, which has been in existence since 1991. We've been doing a lot of work in the review and listening to the dialogue and discussions, and I'm really wanting to express to everyone here that, again, the collective nature of the work we're doing has to recognize the diversity of opinions at this table and the diversity of options that are being presented. And at all times, we should be respectful, especially when we invite guests, like we have invited the National Chief and the staff of AFN to provide us information. And I feel it is very disrespectful for us collectively, if we're going to express a collective voice, that we need to adhere and to respect all diversity of the opinions here. I also want to talk about just briefly a couple, there's been a couple of references to the First Nations Health Authority, and I think it's appropriate to discuss that in the formation, and one of the questions that's been raised in the objectives to, or objections to the agreement, is that it only contains a 10-year funding commitment from the Government of Canada on the implementation, and the transfer of the Health Authority was exactly the same. There was a 10-year commitment of funding that was provided when the chiefs of British Columbia voted in favor of transferring the Authority of Health to provincial authority, a provincially First Nations run health authority. That was 10 years. That 10 years just ended this year in February of 2024 was the 10-year anniversary of the transfer of health authority in this province. And we can all sit around the table here and acknowledge that the Government of Canada has recommitted to funding and to continuing the funding of health within this province, because it's a fiduciary obligation and duty, much like the duty and the responsibility to provide funding for child and family services in our communities. And on the notions of the non-disclosure that were raised by my colleague, we all recognize on a continual basis, there's many nations around this table that sit at negotiating tables with various governments, whether it's provincial or federal. The Leadership Council itself has signed non-disclosure agreements in discussions with the province of British Columbia. And I want to raise a specific, because if we're going to talk about the AFN's non-disclosure, we also have to talk about the Leadership Council's non-disclosure around the discussions they're having with the government of British Columbia around changes that impact us directly in the off-reserve components of this file. Because those are the things that have to be also discussed. And I use the reference of the Land Act, the proposed Land Act modifications that were proposed last winter by the provincial government, and the discussions that were being held between the Leadership Council of this province and the province of British Columbia. And I made a direct request to our regional chief for information about what was being discussed there, and I was told it could not be shared because of the non-disclosure agreements that were in place between the province and the Leadership Council. So if we're going to call out the AFN for their adherence to non-disclosure in negotiating agreements, then we also need to look at our own leadership here within the region and have that dialogue and discussion. This is why I was raising earlier that it's important that we acknowledge and we express the diversity of opinions when we make decisions. Thank you, Madam Chair.
Thank you. I would like you to know that as the chair, with the staff, we are doing the best that we can with the agenda that you approved yesterday. There have always been changes that have to happen to accommodate schedules, and today we're doing a lot of accommodating. National Chief accommodated us, we're accommodating, Catherine Lapa is accommodating us, and we're trying to keep things on point. We have not cut off any speakers. We have asked people to be as quick and brief as they can, and here we are. We are being as respectful as we can. We're protecting where we need to, and we're doing the work that you have directed the staff and the chair to do. And we thank you for your patience. National Chief is already over her time with us. She is going to speak briefly, and Stuart Watke has taken notes. We have a list of your questions and comments. Everything will be sent to Stuart, and they will make the response and send it back to us, and we will disseminate it to the chiefs. And that's just where we are, given the amount of time that we have. And no, there are no more comments. We're going to go to National Chief and let her have her closing remarks. Thank you. Microphone 2, please.
Well, thank you. Thank you, chiefs. Thank you so much for having us here today and having this. You're right. It hasn't been done in a good communication way. This had started back in 2007, and I want to lift up Cindy Blackstock. I want to lift up Phil Fontaine. You will hear from them next week. I commend them for starting this together. And I know that things had happened in this process during negotiations that one party had left. I can't speak to that for anybody else. I know that we need them back as we work on Jordan's principle. I hope they'll come back to the table. It's important that we try and stay united in all of this. And I know that there was other people in 2009, the Chiefs of Ontario intervened. And in 2016, the Anishinaabe Nation intervened. And I know that I've been a regional chief for, that was my portfolio. And I know that I can tell you for sure, when we would have Assembly of First Nations executive meetings, that I tried my best to be open with my colleagues as regional chief. And I know as national chief, I'll continue to do that. I'll give them the highs, the lows, and even things when it's tough to answer that. So I know that sometimes maybe being a national chief, maybe I overlooked that a little bit. So Chief, I hear you on the non-disclosure. We should have probably sent non-disclosures across this country and just sent you the documents directly. And I think maybe just thinking that my colleagues would, and I'm not blaming anybody. I think we should have just sent that out maybe in June or something like that when we started to talk about rolling this out. But nevertheless, this started in 2007, and I commend each and every one of you around this table that we got this far. I know that it's not always easy, but kind of coming into it as a new national chief, seizing that opportunity to make sure that we put money on the table. And I know maybe that I'm not going to solve our drug crisis, our crises in our communities. I know that I'd seen one of my elders some time ago, and he had said, it's going to get 10 times worse before it gets better. And back then there was not some of the things that we see now, some of the drug crisis that we see now, are some of the, the poverty just because of the inflation around this country. I know that we could have, I'm going to take this moment and really reflect on that and make sure that that never happens again on anything else that we do, because we still have to go through Jordan's principle. And that's going to be a tough program to try and fix together. We have to do it together. We have to go through it together, and we have to decide our path forward on that, because as we see, it's not working. But I want to just thank you again. I know that I'm also going to say this. I know that I instructed Canada. I know we can't see the numbers, but I said give the First Nations directly, each and every one of you around this table, the exact number, what you're getting now versus what under this new agreement, so that you can make an informed decision next week. So I know that those are coming Thursday night, the latest, I'm told. At the end of the day, that assembly in Calgary, Chiefs, that's your assembly. That's not my assembly. I'm just the person here working for each and every one of you. And you decide what you're going to do, whether you're going to vote on it, whether you're not. That's for you to decide. But certainly I can just say this, that where I come from a community, a place where it's horrific, and I know that I see it right across the country because you all face it too. Status quo is not working for us. And as we take more control back for First Nations, like you did on health, I commend you all. I wish this entire country followed you, and I'm sure they will eventually when they're ready. Child welfare is hurting us. Child welfare is pulling apart our families, and we need to go back to giving supports to the grandmothers, the grandfathers, the aunts and uncles within when we have problems, that we try and support each other to keep our kids at home with us. And I know this is just one program. I get that. And I'll say this, start occupying the field away from this program. Occupy your own laws, assert your own jurisdiction, work with this, negotiate for yourself. You have all that. You have some tools in the toolbox, but never let them give you any less than what's on the ground here. This is a ground level. This is a good starting point on this agreement. Don't let them give you any less money than that. Go for more as you start to assert your own laws, your own jurisdiction. And I know many of you are doing that, and I'm so proud of you. And we need this whole country to begin to do that. I know that it's a hard discussion, and we've come a long way from residential school. We have a long way to go. And I know that we're going to do it. We're going to leave, are we going to leave our kids better 20 years from now, 10 years from now? I think so, because look at us all here wanting to do what's right for our children. We're all so passionate about it. So I'm so thankful. And in every territory that I go, this issue brings out the best in us, and I'm glad for that. It brings us out. So I'm just going to leave that on that note. Occupy your own laws, but at the same time, we can look at this and what's the good pieces of it and what can you improve with your own community. And I think, I'll be there to lift you up in any way as you assert your own laws, your own jurisdiction. I know that that's I know that's off topic on this specific program, but that's your duty. And as National Chief, I won't sign off on anything next week. I said, your assembly, your decision, I will follow your lead. I'm not going to do anything off track, but I'll say this as leading on this, being a mother and coming from a poor First Nation community in Manitoba and seeing many of my relatives, my cousins, my friends having to deal through this really racist system that's infringed upon us as women and children. I see it from I think that's where my heart's coming from. And I'm always going to try and do the best that I can. And if it means getting some money out to our communities that we can start to try and heal, I've just tried to do the best that I can. And I know that there was people negotiating here. And of course, I want to commend our colleagues as well, because we've, at the same time, I was bugging the Prime Minister, bugging Cabinet to get money on the table. And maybe I should have sent you something a lot quicker. And our draft final was on the July 11th. That's when we were able to release the English version. And the Quebec version didn't come till August the 12th. So there's been errors along the way, and I'll accept that. And I know that, of course, we have changes again today, but as we work through this is why these dialogues are so important, that we try and get those changes in. And we look for your direction next week. And I know that it's a tough decision, but you will get your regional or your individual breakdowns for your First Nations by Thursday night, I'm told. And you have, of course, discussions with your families, with your communities, your councils to make. So I lift you all up and we look for your direction. So Chimi Gwech, thank you for welcoming us here to your territory, and we'll see you in Calgary. Regional Chief has my number if you need to reach me individually. And my email is nationalchief@afn.ca. We work there for you in Ottawa, and we'll continue to do that in a good way. Thank you so much.
Thank you, National Chief. When you took this position, there's a lot of things they didn't tell you and how difficult this job may be for 634 First Nations across this country, the diversity. Certainly, I know that, representing British Columbia. I do have some gifts for you, but I think, the last thing we say, although these conversations today were very difficult, if it was easy to resolve this issue, it would have been done decades ago. But what you see, what we talked about here yesterday in the last few days and last few months on the final settlement agreement is that it isn't going to be easy. So we're going to have to go through these difficult conversations, but nevertheless, I think the issue is so important for our children that perhaps we do get in those spots that we don't want to compromise. But at the same time, I think we really got to consider where we're at, and that perhaps more negotiations has to proceed to address everybody's issues. I'm not, I have hope. I've real hope that we're going to get this over the line, and it's with your help in this room and across the country that this matter is too important to ignore and set aside. And I think it's really important that perhaps in some of these conversations and trying to address the diversity of Canada, British Columbia, and what have you, that these difficult conversations do happen. And, I think I commend you for taking the position of National Chief, and also getting into these difficult spaces here in British Columbia, and perhaps this is occurring for you elsewhere in different regions. But I think it also notes that perhaps there is more discussions required. So that being said, I once again want to thank you, National Chief, and Stuart, for coming to British Columbia, I must say.
Thank you. Thank you once again, National Chief. They'd like a photo op back here. Someone will bring her back. Thank you. All right, now, Ms. Catherine Lapa, we have 5 minutes. But you could have more if you wait after 1:30. But you know, you've been waiting for so long. You poor lady, you've been so gracious and understanding. I want you to know that our assembly appreciates it. So I'll go quick. Yeah, and then I'll question. Because Minister Varani is on at 1:30. Okay, thank you. Can we have microphone 2, please?
Good afternoon, everyone. I understand that I have very little time, so I'm going to go quickly here. I know that you guys have been discussing this for a long time. So my name is Catherine Lapa. I'm the Assistant Deputy Minister for Child and Family Services Reform, and want to acknowledge the territory of the Musqueam on which we're having these discussions, and have listened attentively to what you've said today. I want to acknowledge as well that I'm joined by Karina Chow, who's the Acting Director of Child and Family Services in the region, and some colleagues on the line. Maybe I'll just start by acknowledging that I certainly recognize how difficult a discussion this is. And this is built on a legacy of government underfunding, discriminating, and removing your children. And so, of course, there's a lot of emotion and a lot at stake. And certainly appreciate that any decision around this is a difficult one. It's one that you want to have that's measured, and you want to be assured that you've got the right path forward. I won't be able to go into all of the detail that I would have liked to, but as the National Chief said, you'll be receiving tomorrow by First Nation your individual profiles of what the funding under this agreement would look like and how it compares to what you would have received in 22-23. So it gives you a sense of the increase, and I can assure you that year over year, there continues to be additional increases for population, inflation, and various other elements. For those of you in remote communities, I would have you take note of the remoteness index. It is very significant. IFSD had recommended a 15% remoteness adjustment. This one is in the 30% range, depending on the level of remoteness of your community. There are important elements in here, as Stuart and others have mentioned, that go well beyond the CHRT orders. So the CHRT orders were about specific measures, specific elements of the program. But in the discussion on long-term reform, you can't do that in a piecemeal way. You need to look at all the different component parts and how they support it. And so that's where people have discussions about, you know, what is guaranteed and what is not in the funding. And by the way, I'm not doing the deck because we don't have time for that. But it is important to note, as others have acknowledged, that things like First Nations representative services across the country, post-majority support services to the age of 26, housing funding, and a series of other top-ups such as IT, emergency funding, results, remoteness, and household supports all go beyond the CHRT orders, and that's why you see a continued increase in funding. BC has had actuals in their agencies, where in some areas they've had to do claims, so BC agencies have seen a much steeper increase in funding over the last number of years than elsewhere. I just want to also acknowledge that, you know, this work has been built on years of discussions at this Assembly and many others with you as chiefs, and there's been an attempt to build that into the agreement. So there are minimum thresholds in key areas to acknowledge the fact that there are many small First Nations in BC, that if a model was weighted heavily on population, would disadvantage BC First Nations. So minimum thresholds for things like First Nations representative services, prevention, post-majority support services, are all important ways of reflecting what you have asked for and ensuring that you have enough funds to move forward on things. I would also suggest that you've probably seen the significant increase over the last number of years. In 2016, 2017, this program nationally was $675 million. Last year, it was over $3 billion, and on top of that, there's funding for Indigenous governing bodies assuming jurisdiction under the Act. So it has been a six-fold, almost seven-fold increase as we move forward. And a lot of the additional measures have already been introduced. We did not wait for the final agreement, but as there was agreement on things like results, information technology, household supports, prevention, and so on, that has already flowed out to you in communities. And so we know that you are already working to try and move forward with this in the best way forward. So why do you want a 10-year agreement rather than the CHRT? You might want to consider that one of the benefits of having a 10-year agreement is that it allows you to plan. It allows you to hire people on a longer-term basis. It allows you to have the assurance of what your funding is. And what is different about this than working under actuals and working under the current CHRT orders is you will get full flexibility as well within and between years on your funding. So you can set your priorities and then move it to where you need it to be. So I hope that some of these are helpful things for consideration. I've heard a lot of concern about legal protections. I would say that there are legal protections at a number of areas. First of all, this agreement needs to be brought to the Canadian Human Rights Tribunal. It needs to meet the threshold that the Canadian Human Rights Tribunal determines would allow for the removal of the orders. So they would be independently assessing this agreement as well to see if it addresses it. Secondly, if the government signs this agreement, it is a legal binding commitment. We are not in an election period. This government can make commitments for future governments. And of course, we've all seen it before. Sure, new governments can come in and tear up agreements. Those of you that are as old as me will remember, the Chrétien government tearing up a helicopter agreement of the Mulroney years. But there was legal recourse to that. There were legal consequences to ripping up that agreement. So you would have legal recourse should a future government not adhere to that agreement. And with the dispute settlement tribunal that's envisaged in here, you would have, as Stuart has outlined, the ability as individual First Nations and recipients to raise your concerns of the application and implementation of the agreement. So I hope that you see that there are some checks and balances in this. We're not asking you to forego protections or just do this on a leap of faith. But I do hope that you look at the individual profiles, you think through what is best for your kids, and I really just want to leave you with that we really respect the fact that you as rights holders, you as parents, grandparents, aunts and uncles, have the best interests of your children in mind, and we are here to support you and work with you in that regard. So I really thank you for your continued attention to this. As I was RDG here for 6 years and I had responsibility for the program about 20 years ago, I've always seen the longstanding commitment of chiefs and leadership here over your children and families. And I'm hopeful that we can move forward in a positive way that will break the cycle of the past. So with that, I will say thank you very much. One quick last thing, as Chief Dan will maybe acknowledge, we are also available to talk to you as individual First Nations. So we've been at all the assemblies with First Nations, presenting and so on, but when we get requests for individual presentations or talking through what it means, we've always been available. So I just want to make sure that people recognize and are aware of that. Thank you.
Thank you, Catherine Lapa. Please join me in a round of applause. Thanking Catherine for accommodating our schedule, for being so gracious and agreeing to stay and only take a portion of her time. If you have questions and comments for Catherine, you can catch her on the side. And as she said, she's more than happy to speak with your communities or your chiefs and council. And again, you just don't know how much I appreciate it. Thank you, ma'am. All right, now I want to thank all of you for working through lunch because now we're back on time. Well, we're a little bit still off, but we're going to go straight to, we have Honorable Minister Arif Virani, Justice and Attorney General of Canada, joining us on the Zoom. There you go. Welcoming you, Minister Virani.
Hi there. Hello, bonjour, Hadi and Quay. I wanted to say thank you to the chair and acknowledge that I'm speaking to you from Ottawa on the traditional unceded territory of the Algonquin Anishinaabe Nation. I also want to acknowledge the elders and chiefs that are taking part in this AGM today. I especially want to thank Regional Chief Terry Tiji. Terry, I just saw you on the screen there, who invited me to provide remarks. It's great to see you again. I regret very much that I'm not able to attend your AGM in BC in person. It's always an honor to be a guest among all of you. My goal today is to bring you the latest updates on measures in the UN Declaration Act Action Plan, particularly progress on items under my department, Justice Canada. So I want to start with the third annual report. As we all know, the Federal UN Declaration on the Rights of Indigenous Peoples Act sets out a framework for the promotion and protection of the human rights of Indigenous peoples. This past June, as required by the Act, we tabled the third annual progress report in Parliament. This is the first report to track progress against the UNDA Action Plan, which includes measures taken to ensure this year's partners. We heard that the action plan represents. We also received important suggestions, including the need for federal departments and agencies to more quickly implement action plan measures. I want to turn now to joint action plan work. I'm very confident that we're moving in the right direction, including through the joint work being done by the AFN Justice Canada UN Declaration Act Working Group. This group is now meeting regularly to ensure we are monitoring progress and enhancing coordination across government departments and the AFN as we implement the action plan. I also appreciate, excuse me, I also appreciate our joint work on the AFN co-development principles. We're pleased to be working with all of the members of the First Nations Leadership Council on the BC specific priorities for implementation of this federal action plan. Justice Canada is also seeking nominations for the Action Plan Advisory Committee. This committee will be a way for Indigenous experts to provide support and advice to me as Minister of Justice on the implementation of shared priorities in the action plan. Our goal is to have the committee up and running by early 2025. And to be clear, the committee's advice will complement but not replace the bilateral work that the government will continue to do with Indigenous rights holders and representative organizations. Now I want to turn to some of the progress on Justice Canada's shared priority measures. From a Justice Canada perspective, our work together includes ensuring that First Nations and all Indigenous peoples' rights are upheld, recognized, and respected, and that Indigenous legal traditions can thrive and coexist alongside Canadian law. We're also focused on Indigenous self-determination. This includes supporting Indigenous participation in implementing the UN Declaration Act. Over the past 2 years, our government has provided more than $20 million in funding to many Indigenous partners, including the First Nations Leadership Council, for this important work. Now I'd like to share a couple of examples from Justice Canada that are helping to drive our work on the UN Declaration Act Action Plan. So I want to start with shared priority measure 1, which is assessing the consistency of federal laws. We're now moving forward on updating our interim guide for federal officials on how to assess consistency of federal laws with the UN Declaration. That work builds on previous interim guidance that reflected input from key Indigenous partners, and we're looking forward to improving the guide itself. Our goal is to make it as clear and as practical as possible so federal officials can implement Section 5 of the UN Declaration Act with greater consistency. I want to turn now to shared priority measure number 2, which is the non-derogation clause. Bill S13 is still making its way through Parliament right now. This bill will introduce a non-derogation clause into the Interpretation Act. If passed, the clause would apply to all federal statutes and regulations. It would require that they be interpreted to uphold the rights of First Nations, Inuit, and Métis as affirmed by Section 35 of the Constitution Act itself. This is not controversial legislation, and it should be passed quickly, but I'm being candid with you in saying that unfortunately, the Conservative Party of Canada has been unwilling to provide support for unanimous consent to move S13 forward quickly. It is heartening to me that the UN Declaration and the Act are also increasingly being taken into consideration by courts at all levels. But with respect to S13, I just want to say that if I'm going to put a sort of an ask to all of you in this group, and I know you have questions for me in the Q&A later, it is simply that to just be active on S13 and the importance of Bill S13, particularly with the Conservative House Leader, Mr. Andrew Scheer, because that would be encouraging and would help us in the work that we're trying to do. So now let me turn to sort of what the courts are doing. So as I was saying, it's very encouraging to see the UN Declaration and the UN and the Act itself are being taken into consideration by courts at all levels. What I'm referring to here is the fact that in February we had a momentous decision by the Supreme Court about Bill C-92, in which it declared its opinion affirming the validity of that bill, Bill C-92, that deals with First Nations Child and Family Services. What that legislation did, and we passed that, you'll remember, under our first parliament, the parliament in between 2015 and 2019, is it recognized Indigenous jurisdiction over child and family services, and it contributed directly to the implementation of the UN Declaration. And I know a number of the leaders that are present with you today will attend the Special Chiefs Assembly next week in Treaty 7 territory in Calgary on the long-term reform of the First Nations Child Family Services Program, in order to deliberate and to vote on the proposed reforms featured in the draft agreement. These are all examples of important progress, but there's more to do from a justice system perspective, and I'm very committed to doing my part. It includes advancing the action plan's shared priority measure number 28, developing an Indigenous justice strategy. So let me turn to that now. When we talk about the Indigenous Justice Strategy, or IJS, you know that the goal is to provide a framework for concrete actions to address systemic discrimination and the overrepresentation of Indigenous peoples in the justice system. The strategy is also an opportunity to identify legislative and policy measures that are needed to revitalize Indigenous legal traditions and justice systems. I'm happy to say that we are now in the final stages of co-development of that strategy. The feedback received from extensive engagement with Indigenous partners, as well as with provinces and territories, led to the development of a key elements consultation draft document, which was widely released in June of this year. We're currently in the final weeks of validation of that document, in lockstep with our Indigenous partners. We recognize in particular the work of the BC First Nations Justice Council in helping to shape First Nations contributions to this important document. I'm pushing to see this work completed as soon as possible, so that we can then turn our efforts towards regional and distinctions-based implementation of the strategy. But I'm going to open a parentheses here and put another ask to you quite candidly. When we talk about an Indigenous justice strategy and curing overrepresentation, we have to look at people that are now in our justice system, including our corrections system, that might not deserve to be there, including those that might be wrongfully convicted. So the second piece of legislation I want to raise for you is Bill C-40. Bill C-40 is about creating a miscarriages of justice review commission. It's about rethinking how we approach wrongfully convicted people, how we access them and empower them to bring forward applications so their wrongful convictions can be overturned. We know that if you're an Indigenous adult, you're 6 times more likely to be in prison than a white adult. And if you are an Indigenous youth, you are 8 times more likely to be in prison than a non-Indigenous youth. Those are horrific statistics that we need to correct. And this bill, Bill C-40, is a piece of legislation that can help us correct that situation. But I say to you again in an open plea that we are in a minority parliament and we have months to go in this parliament, but we don't know how many months we have to go. So what I would say to you as an open plea is that if you want to advocate for another piece of legislation, I would encourage you to reach out to senators right across the political spectrum about Bill C-40 and its importance to the BCAFN in terms of reversing wrongful convictions of Indigenous accused. So I'm going to turn now to the next matter that's in my remarks here, which is shared priority measure number 107. And this is the special interlocutor. So I want to give you an update on Kimberly Murray, who's the independent special interlocutor for missing children and unmarked graves and burial sites associated with Indian residential schools. This is a key shared priority measure in the action plan, and deservedly so, in my opinion. Indigenous communities have always known about the mistreatment and abuse and felt the pain of the loss of loved ones who never came home from Indian residential schools. The location of potential unmarked graves on the site of the former Kamloops Indian residential school served as a catalyst and a wake-up call for people literally right across this country to reflect on the profound generational harms of Indian residential schools and the impacts of this trauma that First Nations, Inuit, and Métis continue to face to this very day. This has been amplified by the location of other potential unmarked graves and burial sites at many other former Indian residential schools, such as St. Mary's Residential School in Staulo Nation in late 2021. Since her appointment in 2022, Ms. Kimberly Murray and her team have been working with First Nations, Inuit, and Métis governments, as well as representative organizations, communities, survivors, families, and many others. She's enabled important truth-telling and sharing of ideas about how to honor the children who never returned home. The 6 national gatherings that she and her office have hosted across the country have supported families and communities on their path to healing. They've also allowed Ms. Murray to gather important information and perspectives as a basis for her recommendations for a new federal legal framework to identify, protect, and preserve potential unmarked graves and burial sites connected with former Indian residential schools. Our government is committed through the UNDA action plan to evaluate and take action on these recommendations. And I'm looking forward to receiving her final report alongside Indigenous leadership at her closing gathering at the end of this month. So in conclusion, I just want to say that I know you are all looking for faster progress on implementing the UN Declaration. Every time I meet with Terry TG, he raises this with me because he's a tremendous advocate for all of you. I share that sense of urgency. This is challenging, transformational work. We will succeed as long as we're working at it together as partners. But I also say to you, I'm encouraged by our progress to date. And I also know that with the provincial election currently underway in your province, we've heard different visions for how British Columbia ought to move forward. I want to convey to you that in this government at the federal level and with the Liberal Party, I want you to understand that you have a partner that values and cares about the progress that we've made so far and remains very optimistic about the work we can do together in the future, not just the future months, but in the future years to come. I think every step forward moves us closer to making the objectives of the UN Declaration a reality. And together, I believe we can achieve the vision embodied within it, which is about upholding human rights, combating systemic racism against Indigenous people on this land, advancing reconciliation, healing, and peace. On that note, I will say thank you, merci, musicho, and miigwech. Thank you.
Thank you. Haichkasi, I'm thanking you, Honored One, for your comments. We do have some time for questions from the delegates. I have a speakers list. I'm going to take the first 3, and then we'll go back to Minister Virani. We'll start with microphone 23, Grand Chief Ed.
Thank you, Madam Chair. Edward John, Chief Tlazdan Nation Minister. Virani, it's good to hear from you and the work that's being undertaken on the implementation of the UN Declaration. It was not long ago when Minister Bennett, Carolyn Bennett, and Minister Julie Wilson-Raybould attended the United Nations Permanent Forum on Indigenous Issues session at the UN in New York and reversed Canada's position of opposition to the UN Declaration and announced that Canada would adopt or support the Declaration without qualification. And that was a very important moment for us because it was after 25 years or so in Geneva working on the Declaration that the then conservative government, much as they're doing now, were opposed to the Declaration when it came time to support it at the Human Rights Council in Geneva in June 2006. I should, on the last point that you mentioned about the missing children, I want to bring forward to your attention the International Convention for the Protection of all persons from enforced disappearance. The word missing is not used, but disappearance. The thing about this particular convention is that on the day the Human Rights Council in Geneva voted to support the UN Declaration on the Rights of Indigenous Peoples on June 28, 2006, the very next item on that agenda was a declaration on forced disappearances. That was the next vote that was held by the Human Rights Council in Geneva. So those two particular instruments came up at the very same time. And of course, they took different pathways to the UN General Assembly. But for my way of thinking, I thought there was something fortuitous about the fact that these two instruments came up together at the Human Rights Council and voted. Both were voted in a supportive way by the Human Rights Council. So, but no one speaks about this convention. I think it applies in the case of missing children from Indian residential schools. And the terminology within the context of that convention, I think, is important for your government to bring that into consideration as you're looking at this work. I'm involved in the residential school where I attended in the northern part of British Columbia. I'm involved in an advisory committee, an advisory group to the radar penetrating work that's been undertaken, and looking back into the truth of what happened to our children who attended that particular school and who never returned home. There are many burial sites in the former residential school sites. Some of those are marked, and there are many children that are there, but in other places throughout the schoolyards, throughout the school grounds, more work's being undertaken. So just to connect the word missing, generally used, and the word enforced disappearances in the United Nations Convention that deals with issues that are of that magnitude. So I just wanted to make that point. I want to note the 2 points that you made about S13 and Bill C40. I think, thank you for the advice, and I think that it'd be wise for our chiefs to take that under advisement and to make sure that we're able to follow through both on S13 and C40. Thank you very much for your comments. The only thing now, of course, is the UN Declaration, and the legislation was considered in a very significant way by the Supreme Court of Canada in the Quebec reference case on the federal legislation on children and families, and that the court said the declaration is now a part of Canada's positive law. That's significant from where it started from the ideas to the declaration to the adoption to the court taking that into consideration and talking about that now in this country. We have three sets of laws that can be woven together. In the case of children and families, for example, the state law, which are Canada's and provincial laws, Indigenous laws, these are our laws that are being recognized, the inherent rights of our people to our laws, and international law, in this case, laws that apply internationally, the UN Declaration. Many of the standards in the Declaration are already part of international law. Some of them are part of customary international law, but as a whole, I think in this country, this declaration now is part of Canada's or customary international laws that applies to this country. It's not, they're not simple ideas or wishes or wish list or anything like that. They're something more substantive, and as Canada's Supreme Court said, part of Canada's positive law. So thank you, Minister.
Thank you, Grand Chief. I have two more speakers, and then we'll go back to Minister Varani, and that's unfortunately going to be probably all the time Minister Varani has for us. I'd like to go to microphone 13. Cookbee, oh, there you are. Cookbee Spahan.
White, Hansla, Jawan, Squash, Lease Bahan, Cook, Bevan, Slutku, and Lick Up Nation. Hello and good afternoon. Lease Bahan, Chief Quarter Band, also proxy holder for Shakan Indian Band. Thank you for your presentation, Minister. I just want to send out an invitation to you and your office, as well as your colleagues of Indigenous Services Canada, on discussions that Cowater Indian Band wants to have with your office, as well as Minister Patty Haydu. We've been trying to get in contact and have meetings with them for the past year, and we haven't heard nothing. Just in regards to justice, I want to let you know and update you on what has been happening in the Nicola Valley in regards to policing and that, and you know, the lack of, and where the federal government isn't showing enough support towards First Nations. And I would really appreciate a commitment from your office to sit down with my council, myself, and as well as the Nicola chiefs of the Nicola Valley. So sending out an invitation for you to meet up with us and have more discussions, because the time that has been allotted at these meetings is very short. So looking for a commitment from you, Minister. Kukstem, thank you.
Thank you, Cookbee Spahan. Our last speaker is Council Proxy for Cowitson, Calvin Swestis, please. Microphone 8, please.
Haichka, Madam Chair. Aikwana Silam Nama. Ianthat Swestas, Calvin Swestas, Proxy, Cowichan Tribes for Cindy Daniels. My question to the regarding the IJS is, like in 2006, our number of our Indigenous citizens across Canada incarcerated in federal jails was around 12%, yet we are only about 4% of the population in Canada. Today, we're probably in the mid-30s, representing population in the federal institutions, so it's rising. Yet the federal government always promotes the Gladue report, Section 718 of the Criminal Code of Canada, and how it's supposed to deal with our people in a different way rather than through the criminal courts. So I'm just, my question is, how are we dealing with our people much differently when the numbers keep rising? Some of the answers I received was that our citizens aren't being sentenced longer sentencing as in the past, but we're still being sentenced, and our population numbers are still rising in those institutions. And I've always said that perhaps that section of the criminal code shouldn't have been in there in the beginning, because the Criminal Code of Canada is the law of the colonization persons that developed it to enforce laws of Canada, but yet we're in that book. There's another book out there, it's called the Indian Act, which is also a federal law that guides us and overwatches us each day in our life. So how are we going to, my question is, how are we going to work with the IJS to develop something better along the lines of Gladue 718 of the Criminal Code of Canada? What more can we do? What are we going to do better with that section in the criminal code? Are we going to develop a better process? Are we going to be involved in that process? Because in some ways we are, but those numbers of our Indigenous citizens are still going to federal jails, and it's not going down. The numbers are not going down. So that's my question, Madam Chair. Haichka.
Haichka CM. I'd like to go back to Minister Varani, please.
Thank you very much to all three of the speakers. I'll just deal with them in the order that I heard from them. So Chief Ed John, good to see you again, and thank you for your wisdom as always. In terms of that walk down memory lane, I obviously remember Carolyn Bennett and Jody Wilson being at the UN and talking about that we would reverse the previous government's objection to UNDRIP. But thank you for reminding me about how dogged and stubborn the previous government under Stephen Harper was going back to 2006. I appreciate your point that you're making about the forced disappearance provisions and that document as it was enacted by the UN Human Rights Council. And I would say to you that, yeah, that's something that we should be looking at, because when I talk about Indian residential schools and when I meet with Kimberly Murray later this year, it's going to be a difficult meeting, an emotional meeting, but I'm also keen to hear her recommendations about how we can and must do better. I appreciate you being so forthright about your own experience at the residential school that you personally attended, but also your work on the council right now in terms of the radar penetration work that is occurring literally at the school you attended, and locating those sites, but also doing what needs to be done to commemorate those sites and to promote healing on the terms that the Indigenous communities want wherever we find them is critical to us. I would say to you that I would agree with you absolutely in terms of the momentous nature of the Supreme Court decision this year. What also wasn't lost on me is that sometimes you have divided cases amongst the Supreme Court where you've got a decision that maybe it's 6-3, or maybe it's a 5-4 split decision. This decision wasn't just 9-0, but this decision was the Supreme Court wrote as literally the court. They didn't assign a name to who was writing it because they wanted the emphasis to be clear for everyone reading that decision that this is the Supreme Court's position on the status of UNDRIP as codified law in Canada, which is really, really significant and really, really meaningful. I want to turn to Chief Cookby Spahan in terms of your request, and I'd say to you, I'm open for exactly such a meeting, and I would ask you to please get in touch with me. Terry knows how to reach me quite easily, but my chief advisor for all things that relate to Indigenous rights holders is a woman named Tanya Monahan. So it's just TANIA.Monahan, MONAHAN @justice.gc.ca. So if you wanted to reach out to Tanya directly, and please start with my office. And if you're having trouble with Minister Haidu's office, I commit to you that I will try and connect with Patty Haidu's office to address the needs that you have for that meeting, because it's very, very important what you were outlining. And to Kelvin from the Cowichan Tribes, I hear you, and I can sense the frustration in your voice. And when the stats aren't going in the right direction, you're frustrated. And you've got a right to be frustrated. What I can say to you quite honestly and sincerely is that we are doing everything in our power to try and change the pattern on those stats. And I'll give you a few examples. So about 20 months ago, we passed a bill called C5, which dealt with mandatory minimum penalties, which were very much in fashion for the Harper government with the Conservatives. And when they enacted those penalties that established mandatory minimums, what they did is start to clog up our jails with people that had, in some cases, committed relatively minor offenses, but were given a jail sentence no matter what, because that was what was required by law. And that had a really disproportionate impact on Indigenous accused. And we reversed a whole swath of those penalties about 20 months ago. I would say to you also that we passed a bill that sometimes doesn't get a lot of focus, but it dealt with how we train judges, because I think you mentioned GLADU a couple of times. GLADU is meant to sort of ensure that courts, when they're sentencing individuals, have a holistic understanding of the person, but the courts themselves need to be more sensitized. And what a bill called C3 did is that we talked about training for judges, and we said, okay, it started out as a training on sexual assault law and how it impacts women, but we broadened it out to say it's got to include things like social context training, and that training has to include training on things like systemic discrimination as it applies to Black and Indigenous accused. And I think that's important, because what we're there saying is that there's training that needs to be done by all justice system actors, police, crown attorneys, and members of the judiciary need to better understand some of the biases that are involved in decision making. In terms of sort of the involvement of Indigenous communities, I'll say to you again what I've said all along in the 14 months I've had this office, which is that in terms of the Indigenous justice strategy, that is a co-developed document. We've gone through 2 waves of engagement. We're engaging again, but this is not meant to be a top-down model. This is taking what we've heard from leaders, including the leaders you're sitting with in that room, and in taking that and implementing it into a new way of looking at justice. The last thing I'll say to you is something that was imposed upon me by Corey Wilson of the First Nations Justice Council in BC. What she said to me is that if you really think about it, because you said to me quite candidly that that criminal code was written by sort of settlers and it's about sort of European-based concept of law. You're right. That's exactly what it is. But what Corey Wilson said to me is that if you're going to talk about legal pluralism and different legal traditions in this country, it's not just French civil law and British common law. It's also the Indigenous laws that were on this land at the time of contact. And that's what the Indigenous justice strategy is meant to unlock, is that how can we figure out a way to empower Indigenous communities like yours at Cowichan to actually unlock those traditions about how you would actually govern yourselves? Because that would give meaning to UNDRIP, but it also give meaning to tackling head on this idea about Indigenous overrepresentation. Because if you are administering justice yourselves, policing your own communities, that's how we can cure that over policing and over judicializing of Indigenous people on this land. So those are my thoughts, but thank you very much for having me. I'm sorry that I can't stay too much longer, but I'm very keen to meet with you again in person at the next nearest opportunity. And I just want to say thank you for the work that you continue to do and keep up that good fight. I know it's a tough time right now in BC. I hear it from my BC colleagues, but keep up that important fight about asserting what is right and required in terms of advancing reconciliation, because that is the only path forward for both the province of BC and for this nation. Thank you. Miigwech.
Thank you, Minister Varani. I just want to acknowledge the work that we're doing as I'm the lead on the United Nations Declaration Act Chiefs Committee. We transitioned from an ad hoc committee to a Chiefs Committee, and we do have Chief Don Tonham as a representative and Cheryl Casimir as support, as well as my staff. I think, some of the questions we still are dealing with there nationally is getting more other regions involved, but also getting a good understanding of the federal government's position in terms of implementation and aligning many of the policies and law with UNDRIP. Tomorrow we have the Canadian Border Services issue coming up on our agenda, and so it's kind of a place where we're at, where a number of different agencies, a number of different ministries are taking their view and running with it. It's not clear, it's not concise, nor does it make sense to us that we have a number of these ministries. Department of Fisheries and Oceans are amending the Fisheries Act, and there's another situation where we're trying to catch up in terms of what exactly they're doing. So there's going to be technical meetings and also presentations to the committee to align the Fisheries Act with UNDA. So we need a better idea of how this process is going to work, but also to more resourcing. That being said, Mr. Brandy, once again, I want to thank you, and certainly here in British Columbia, we've been implementing the declaration for 5 years. But I think you were noting on perhaps difficult times. I don't know if that's in making mention of our current situation with politics and also being an election, and also a political discourse from what we're hearing from other parties in terms of their views on UNDRIP. So that being said, appreciate the time, and I certainly know our meetings with Tanya Monahan and also the technical meetings have been going ahead. And we also have a political meeting coming up here very soon. So thank you. Merci.
Thank you. Thank you very much, Kerry.
And thank you, Mr. Minister. Well, We are back on time, and we have a really feel-good part of our agenda. You know, all of us as Huelmuk, Stamuk, Bakwam, Indigenous First Nations people, we all have a way of, in ceremony and in arenas like this, we have a way to thank and honor those who have done incredible work for us. So at this time, we're going to honor our outgoing board member and our outgoing elected representatives. I would like to first call the BCAFN board to come stand up here with Regional Chief. And we'd like Linda and Luisa to be ready for someone to come and bring you up here. And we'd like you to know, in our Huelmuk Kosalish way, we hired a speaker, Shalqualam. Ray Harris is going to speak for the family, and we're going to start this work right now. Thank you. Okay, she's going to give you quarters. Okay. There you are. Sends to whoever.
Yeah.
For the people online, I'm requested to use the mic, so I'll use the mic to help with my longhouse voice. The culture needs a wee nom stomp, says him. Ona Hawaks, Pat Housty, we're going to ask you to stand and be a witness for what you're going to see today. Chief Dan Manuel, we're going to ask you to witness the work today. With the Queen Armstrong, those that have been asked to witness, you're going to see one work today. Regional chief and the host is going to do one work today. Siemnitsiaya, Haichka, you can be seated. We're going to call the ladies forward that have been asked to help with the Lochten, the Spelken, the blankets. Some of these ladies are learning on the job. They're doing so good. Over here. Ask Leah. You take one in here. You take one in. Watch that, see? Put them together. Yeah. Thank you, Chief. Of course, I should have mentioned you're witnessing, all of us are witnessing a custom of the Salish people to do a little bit of what we call work, but taking on some obligations that they would help us on the way. So see tala ni tap swimatal with the spelken. You always eat up me. Ja, you see it na. You always chew nature would come out. It's a swimatal. So need to live at the size. I want to say thank you so much on behalf of the host. Some of you may be working here. Some may have come here to visit. Some are here just to be with the company. But we didn't ask you, say many words to ask you to help, and you're so willing to help, and you make the work go better. You make it so much easier for us, Haichka.
So we're honoring Linda Price and Louisa Housty. So they're just going to go bring them in here.
Siemdesjaya, Dequat Scottam, Chief Linda Price, Linda Housty, Louisa Housty, Siemdesjaya, the Khilistam at Na, Quail, Nate Quinn, Sianamate, Yayas, Chechawatan, Squalawan, Muktapu, Lumno, see me, Techel Namat, Natin, Hey Walkton, Tana, BC Assembly of First Nation, outgoing member of the board, Chief Chief Linda Price, I always say the mother of, so I'm sorry, the greatest hockey player in the world. Woo! Many years of dedication working on the board that we need to do now and then. We need to call upon people, and Linda, I've seen you time and time again in your dedicated work that you do. And we're also honoring this fine lady, outgoing member of the women's representative for BC Assembly of First Nation. Louisa Housty Jones. Her term was, she served 6 years. Siemnachai, let's hear it. There's lots of us here that have had long at the tooth at this kind of work. And I witnessed the improvement in the movement of our people when the ladies came in prominent roles and helped us make the moves. You witnessed that today with the child welfare issue. So I always say thank you. Please give us a standing ovation for these two ladies.
Okay, I got them ready to be blanketed. Are they facing the right way, or do they need to come on? They're okay that way?
Yeah. And we want to say thank you and bring them comfort. So custom of our people is to this ceremony's kind of caught on across the country. We see this now and then. Again, it has many now descriptions. This ceremony, Siebnesiaya, Lanatlu, Si Shiais, Kudetis, Kusalhelaxit, Kusi Lamnuk, the Shiais. Our old people really treasured this kind of work. The planning that went in was days, years sometimes. Ceremonies went day and night to reach the culmination of standing two people up in honor. And the blankets are representing, again, the grandmothers, the great-grandmothers, aunties and sisters. The women are, if you can imagine being embraced by your mother or your grandmother, the blanket is embracing you to represent all the strong women in your families and all the strong women you've met in your lifetime. So that's what I've been told, and it's what I'm passing on to you. And I want to say thank you. We all want to say thank you for that time you've put in for us and sacrifices you made away from your own families. So thank you so much. Siamnasiaya, Atui, Tiakstet, Nitsa, Swimatal, Kutastilum. We have an honor song from my nephew, Tiakstet. Haichkasiam, Haichewit, Squimbatauket, and Siawanet and Steelam, Haichka. Thank you so much for the honor song that you've brought to the ladies here today. Haichkasiam. Hasiam Nasiaya, Swallopni, Hui Namstem, Nitsakwat Tassitan, Squallow and all up. To your friends and relatives, you know that the drums and the songs bring the spirits in with us. And we turn to the witnesses we just want to, witness is a hard job for people. Although it's enjoyable, we'll go by the order we are called. Talk about what you saw today in the ceremony.
For being the voice for our family here, being the voice for all the people that are sitting here. You're always here. I've seen you many times speaking, even in our own homes. Thank you. What I witnessed here today, what I've heard in our custom is to reaffirm what I've heard, what I've seen, the description of these two ladies here, our matriarchs. At your home, you have duties, you have work over there, but yet you are here taking on extra tasks for our people. I really want to thank you for that. Being away from family, being away from maybe children and grandchildren, yet you're here taking on extra tasks, and you've now moved on. And that's the strength of matriarchs. I always want to recognize our matriarchs here. Look who are here, even in the front tables, our matriarchs, carrying the knowledge, the stories, being the strong ones. We always need to recognize our mothers, because without our mothers, we wouldn't be here. But yet you are here, you've done your time. And I'm sure your time isn't going to be over. You're going to still be doing work out there, I'm sure of that. I want to thank you. I raise my hands. Thank you for the work you've done. Continue doing it for our people. Our people need you. Thank you, Heitzepka. I want to thank the family here for doing this kind of work, laying down the blankets, a very sacred ceremony in our culture. I've watched this work happen in the past in these kinds of meetings. Thank you for following the traditions. And I'm sure all the nations out there have their own tradition of doing recognition ceremonies. So thank you for doing the recognition ceremony here for our ladies. So, Heitzepka, thank you.
Just so online can hear you.
Merci. Dia ten ja no kaya wakana sadasla kenja tene bayasta kanawis Udis tin wakana so sawadis sanawis. I want to thank my brother here for the work that he's done so many times in the big house behind us over here on the floor, on the dirt floor, carrying out the traditions and being the voice for this family here. The work that they're doing in recognition of these two ladies. Masi, thank you. Dane nida tadahin dilne
Dane ba kananja te den lahiden la masino tasni. Tabe what is tin wa kanandi atena halen ke wasna no nicha the den lada. I want to thank the family to acknowledge that you have borrowed the ways and the customs of the people here in their house, and to acknowledge that and to use it, and to ask that permission to be able to honor these two individuals that you're standing up and thanking and acknowledging the tremendous work that they have done with working with you, but on behalf of all of our First Nations in this province. I say, Haichka, Haichepka, Masi. I want to acknowledge these two ladies. Di Khani Itlagiza JK Ne Gana JK was Sai Satan Lanja Babas Aten no Aten Sadasla Wachano Tio Se Hunaste Wakanala when they know what Aten Sadasla Masi Nitio Masi and no Zaninzan, no Zazninzan. I wanted to say to the two ladies here, I use the one word "zeke" in the language of my people. Say refers to the umbilical cord that brings life to our families, to our children, to the next generations, to all the generations. It comes from the source, we say "zeke," the women who bring life into this world. And you stand here as proud matriarchs, both of you, carrying out the work in your homes, in your communities, with your children, with your families. How important we spent the whole day talking about children and families and the role that you play in all of this. It's not play, but the work that you do and the important place that you hold in our communities and amongst our families and the work that you've done. Those blankets, a symbol of blessing the floor and symbol of honor and integrity for the work that's been done here, and that they've honored you by putting you on those blankets, as my brother talked about. To Yoktak, I want to say, lastly, thank you so much for your beautiful voice and your song, that you stand in places like this, use that voice of yours and that drum to bless our floor and to bless the people who are being honored and who are carrying it. Always, my nephew, I say thank you. That is all I have to say.
Good job. Thank you, sir.
Good afternoon, everyone. It's very touching to be here today to witness what is taking place. I'm honored to say I'm the mother of Louisa Housty Jones and to be a part of what's going on today. She's always been a hard worker, always been there for people of all ages, and always been a community events person. She's been our go-to. And she's a hard worker, and we're just very thankful to be a part of this very, very beautiful program that you've got. Thank you.
Turn this way. Go stand closer. That's for the online.
Why Pisnoxil? Why Limlimt? To my good friend Ray for the work and being here to share with us his knowledge and to continue to, without question, be a strong leader and a strong voice for the people here. And I thank you for the opportunity to share a few words. Thank you to the family here for acknowledging the work of our matriarchs and the efforts that they've put forward over the last several years. You know, I just wanted to say to Linda and Louisa that I'm humbled to be witnessing here of the recognition of your work and your efforts. I'm a strong supporter of Indigenous women and the roles that they play in our communities, and to be able to witness here the acknowledgement of your work and the wrapping of you in blankets to protect you, and to acknowledge the long history that our communities have in both of your families, the ancestors and the matriarchs that have given you the strength to do the work that you've done here. I just hold my hands up to both of you and acknowledge both of you for your work. I'm also have been asked to do some work on behalf of Melissa Moses, who is the BC, or Union of BC Indian Chiefs Women's Rep. And she couldn't be here with us today, but she had asked me to carry a message for her of the acknowledgement and recognition of the support that she's received from Louisa in the work that she does as the women's rep, and acknowledge you for recognizing her and trusting in her to carry on the activities in your role. And she wanted to acknowledge you for the mentorship you provided to her in the work. And she wanted me to just to pass on this gift. Oh, sorry. Oh, sorry. Lim.
So we're going to say thank you to the witnesses. Someday, going to come to you a question: what did you see happen at a time like this? This is the real oral tradition, custom of our people that's kept us the way we are today. We're different because we remember. We got good memories. So thank you, and I'm asking you, the witnesses, to put it in your memory bank. Someday we'll ask you. Somebody will ask you. So we're going to turn the mic over to Regional Chief. After that, we're going to, I want to direct this so we can deal with it, for the Regional Chief to have a chance, and then we'll have a reception line to greet the ladies, and we'll ask you to stay in the back and trying to get a real good groupie picture. And then we need this history, right? So fix your hair.
Merci. Thank you, Ray, and thank you to the witnesses, Ed, Dan, and thank you. You know, when we do these ceremonies, and we've done them several times with previous board members and those that are outgoing, it's never, I suppose, I think culminating to this, getting a little bit emotional, that it is very difficult to, in this journey that you get good help. You all know in this room of how difficult it is to get good help. And you certainly hope that for Louisa, you've been here for as long as I've been here, 6 years. I've been here just before you came on. You were elected. Yourself, Linda, Chief Price, been here since early 2021. And, during this journey, you would hope that you have a good representative. And for me, and for the BCAFN, and for everybody in this room, and for this province, you represented us in a good way. Louisa, a big voice for all the issues over the last 6 years, or maybe even longer, about missing and murders, women and girls, about how that continues to happen at the National Council table, the Women's Council, and wanting some semblance of justice for our women, for our matriarchs, for our children. You, Linda, I certainly know, I tried to convince you to run again. But I know your job is done here. And you have to go back to your family. Atsu, grandma, you're a grandmother now, to 4 grandchildren, and look after the children. And that's, you have to do that. And we commend you for that wise decision. And you have Chief Don Sam to take that position. And we'll hear later on the new women's rep who will be announced later. And we certainly hope that I'm certain there will be filling those shoes in a good way. So for myself and the family, my board of directors, and behalf of the staff, you know how well they worked with us to help and support you in the work that you're doing, and for myself, the appointments that were bestowed on you to help and support me as a voice on behalf of BCAFN and British Columbia. And in the end, it's never easy to say goodbye, because I won't say goodbye. A lot of Indigenous languages, we don't have a word for goodbye. So you'll always be there. I certainly know that, and certainly I know to lean on you. But nevertheless, it never makes it easy. It's never easy. But anyways, I wish you well in your road ahead and your journey, but I'm certain we'll certainly, our paths will cross again. Snatchalia, thank you. Masi, a big thank you for doing the work that you did on behalf of the BCAFN and behalf of British Columbia, and bringing your voices to the national stage. And it's really important. Thank you. And Casey, we love you. And I thank you all. Masi.
So you're all welcome to come and say a little shake hand, no hugging. Just to help with the day, we were going to ask you to stay with the honored ones to get a groupie picture. It'll be history forever. I love these pictures.
Just hold it up high.
Yeah. So thank you, everybody. Let's give another wonderful round of applause for our two honored ladies. We do have the photographer taking pictures, so fix your mustache. Hey, thank you. Siemnesiaya. Chiitalo Maghaiska. You couldn't say thank you enough times for these ladies. And thank all of you and the staff. I see the staff coming forward also. Thank you so much on behalf of everybody in BC, Canada, and North America. How's that? Huh? Right on. That's a beautiful picture. Siemnesiaya. Just to, in our custom, we'd say to the ladies that have been honored here, that have been brought out, stood out here, what you're wearing is going to be a souvenir for yourself. And the kerchiefs also, that the headbands you have will also be a schames. Our language is schames. If you get lonely or something kind of heavy on you sometime in the evening, just take it, lay it on your lap or wrap it around yourself. Think of all the people that are standing with you and all your grandmothers and your mothers, aunties, all the ladies that nourished and brought this world to the way it is today. Will come to help you. So that's a private, personal thing for you to keep in your heart, your mind, and your spirit. The ladies are going to pick up the blankets. We can all be seated now. Semna siya Nick with high to size. Needs down here with high to size at Naquil. See it tala, see it to Nick, swim it all. Thank all the helpers. The ladies are making their way around with some gifts for you. Haichka Semna siya.
All right. I have not had a chance to catch you up on some housekeeping things. There will be 2 sets of door prizes on the draw, how do you call it? The Wheel of Fortune. When that comes up, 2 door prizes. One is a pair of hockey tickets for tonight's game. Unfortunately, that's for the in-person people only. 2 is a $250 prepaid Visa gift card, and 3 is a $750 hotel credit at your hotel of choice, arranged through Corporate Traveler. There will be 3 draws. Now, all of that is for the delegates, but we haven't forgotten the observers. There will be 3 draws for observers, in person and virtual. In person can come to the table and pick their prize, and virtual winners can email or PM us on Zoom with your mailing address. Now, one more thing. The shuttle bus will be outside at the end of the session. Staff will be on standby to drive chiefs and proxies if the bus fills up. Well, that's right neighborly, I would say. And we aren't even finished our agenda yet. So I'm glad some of you are getting the, how do you call it, coffee break, getting the break sustenance. And I'm really happy that you all were here to observe the ceremony honoring our dear friends who are like our sisters. At this time, I know it's hard to go back, but if you sit here long enough, you might win hockey tickets. So there you go. I would like to call forward Clifford White, who is our BCAFN representative to the BC First Nations Justice Council, and Regional Chief will also be speaking as a Justice Portfolio holder.
Should I go first?
Yes.
Okay. Thank you. Before I forget, just a round of applause for Leah. Once again, stick handling this AGM and being our chair and moving us along. I'm the co-chair the portfolio at the Assembly of First Nations for Justice and Policing, and as well as Ghislaine Picard from the Quebec region. Just want to start for you here in this room and for those online to remember these names. Jack Pichet, Haas Lightning Saddleback, Tammy Bateman, Jason West, Stevan Dedham, Danielle Knife, Ronald Skunk, John Wells, and Joey Desjardins. Those are the 9 names of those who have died in custody since August, either through the RCMP, municipal police forces, or provincial police forces. And I also want to acknowledge those names from here, from British Columbia. you know, and some of the work that I've done prior to becoming the regional chief was speak up for Dale Culver, Giksun Hatsuatan man who has died in custody. Jared Lowndes, Wet'suwet'en man who died in Campbell River. And during the pandemic, my cousin, Everett Patrick, Lake Babine Nation. So it really speaks to the issues of policing in British Columbia and Canada. And, you know, being a family member is to try to find some semblance of justice. And there's two issues going here, a justice system that is against us, really, that isn't just, and a police force that in many respects is killing us, quite simply. So certainly there's many issues that we have to resolve in regards to the many police forces. We do have, as part of the First Nations Leadership Council, a police protocol with the RCMP and the provincial and municipal police forces here in British Columbia. On the highest level at the AFN, we do have an agreement with the RCMP with the chief of police. And also in this space, we're trying to change the justice system and also for the policing system in the well over 53, 54 tripartite agreements in British Columbia, and also our one police, Indigenous police force in Statlium is to create that, the resources that we need. I also want to acknowledge, you know, the work that the BC First Nations Justice Council is doing, you know, the 4 pillars that we've brought forward in agreement with the province of BC just before the pandemic in March of 2020. We're still working on implementing the justice changes that we need provincially here. There are many justice centers, approximately 12, maybe more, I believe, in the province of BC. But on a national level, we have a Chief Justice Council, a Chief Justice Committee to deal with some of these issues that's just been created as a result of a resolution that was passed last year. Some of the work that we're doing there is to work with the federal government on an Indigenous justice strategy. Now, we were really a bit of under the gun in regards to developing a strategy. It was supposed to be released this past spring. We got a reprieve to extend it to next month, to November. So we've definitely have been working with the AFN, and much of what we're seeing at the national level is coming out of British Columbia. It's coming out of our views in terms of justice, in terms of seeking really a fair process in regards to changing the justice system. So that work is ongoing. And further to that, we thought we had until January, but the word is we'll have a strategy developed, or at least a draft strategy, and I have to be clear here, a draft strategy by the end of November. So you can expect that coming out at the Special Chiefs Assembly in Ottawa. I think, you know, one of the things in regards to policing as we transition from program funding to essential services funding is the fact that the federal government is still steadfast in their position in regards to jurisdiction. The task group, which we have Chief Jerry Jack sits on the task group in regards to policing, is one of, you know, quite difficult because we've been here, at least for myself at this table, for 4 years, and I've been discussing this transition from program funding to essential services funding for the last 2. So as we move forward, certainly we know and understand we need the resources for our own police forces in our respective communities, but at the same time, we can't have it impeded by the province of BC or any provincial government or any territorial government. So this is the fundamental issue in regards to why jurisdiction is such a sticking issue in this legislation, is that the federal government wants to divert some of the responsibility to the province. We feel as part of the task group and as part of the AFN that it should be a government to government, perhaps really the relationship between the federal government and your communities and or any other entity that we deem fit to represent us and take that space where the province once we're at. So it's really a difficult position where we're at right now. We've definitely, between myself and Jocelyn Picard, have tried to have more meetings with Minister LeBlanc, who's the new Minister of Public Safety, but it has been difficult. The difficult part is that, for the most part, he's pretty steadfast on the current draft iteration of this legislation. But at some point, we're going to have some input in regards to where we go from here. The only place I could see that there's similarities is in the current child welfare system. As in Bill C-92, where there was position from really to draw down jurisdiction to our First Nations communities. I think that sets a good precedent that perhaps, in this case as well, that we can move out the province and the territories. So we can have a police force and or an arrangement on policing that certainly represents our goals and values as First Nations here in British Columbia and elsewhere in Canada. So currently that's where we're at. In this legislation too, what we're putting forward as the portfolio holder for the United Nations Declaration Act is to make sure that this legislation also aligns with UNDRIP, to make sure that really we convey our sovereignty and self-determination in how we proceed with policing, but also further to that, we've definitely put that forward in terms of the Indigenous Justice Strategy. So internally, one thing I should share, it's been very difficult to get some of the other regions engaged. I suppose I'm taking what I've gathered from regions that are participating, but trying to encourage other regions to bring forward their views on justice and their views on policing. Some are more active than others, especially in regards to policing, such as Saskatchewan and Ontario. We, as the AFN, actually are intervening in the court case in Ontario, where the First Nations in Ontario are bringing forward a case of discrimination in terms of the resources being brought forward in their cases of their police forces in Ontario. So that's where we're at right now in terms of justice and policing. I certainly know I believe we do have a resolution that will be coming forward in regards to support for the creation of a Johnson Alert for missing children with disabilities. What we witnessed in Burns Lake, in Nitaibun, Oakland Schwetter, a 6-year-old girl who was on the spectrum and was nonverbal. It was heartbreaking, it's heart-wrenching, but at the same time, the many messages that I got from my phone and also social media was, why wasn't there an Amber Alert sent out? Amber Alert is specific to cases where there is a known perpetrator for kidnapping the child, and then there's also a known outcome in regards to retrieving the child. That being said, what happens in the case of such as Oakland, but also what happened in Manitoba, Johnson Redhead, who was a young boy, I believe similar age, 6 years old, who was on the spectrum, who was also nonverbal. One case with Johnson Redhead, God rest his God rest his soul, rest in peace. He was found approximately 3 kilometers from his home, and he succumbed to the elements and passed away. But in the case of Oakland, she was approximately half a kilometer away, and she was found, and she was found in good health. And she was found within 72 hours. And further to that, I just want to also acknowledge everyone, First Nations, non-First Nations, everybody across BC that sent resources to Nitai Bund, to the mom Gail Skin, and to the dad, and to the family, and to the nation. I believe approximately 600 to 700 people, volunteers, search and rescue. Because one of the things about this alert, and I should note, and what I've seen and what I witnessed and what was messaged to me, is time. Is time, you know, especially now as we go into fall or winter. Time is of the essence. You know, you only have a short window of time to find the child, especially a child that has disabilities. So thank God they found Oakland, and she's doing well, is my understanding. So the resolution is to support what has been coming out of Manitoba is what is called the Johnson Alert. You know, Johnson Redhead who passed away. You know, if the resources and the alerts came out, maybe there would have been a difference, and maybe he could have been found. So that's the resolution that will be coming up under this segment on the agenda. So I thank you all for this time, and pass the microphone to our representative from the BCAFN, Cliff White, who is on the BC First Nations Justice Council, will give us an update. So, Cliff.
Thank you, Regional Chief. I would just like to say that they do have a PowerPoint, but Christina is going to send it to Maureen, who will circulate it to all of you. So we'll be hearing our update remarks from Cliff White, your representative.
Samoyed, Simgiyet, Sigidmanana, Kapawals, Skorum Doys, Samoyed, Jimlaha, Wilgalam Amasadagam, Saurum Doyle, Musqueam. I'd like to thank and honor Musqueam for allowing us to do this very important work on their unceded territory, and greatly appreciated. And, my name is Nismauta Itratla Walsawatku. My indigenous name, my hereditary name is Nismauta, hereditary chief with Kitratla Nation, and I am your nominee. I am your appointee to the First Nations, BC First Nations Justice Council. And definitely all day I heard a lot about, you know, free and prior informed consent. For the First Nations Justice Council, I really want to put across the fact that this is your organization. The organization is here for you throughout BC, and we encourage each and every one of us to utilize the Justice Council, because a lot of your people who are now gone, your mothers, your fathers, your grandmothers, your grandfathers, my grandfathers, you know, have put this organization together. It's taken that long, through the Union of BC Indian Chiefs, through the BCAFN, through the First Nations Summit, everyone putting all of their energy together to create the BC First Nations Justice Council. And so with the centers being open, there's 9 of them that are currently open, We want you to utilize them as much as you can. We work with a great deal of staff who are prepared to come into your communities, into our communities, to work with us on judicial issues or even your own justice system. Today we heard a lot of encouragement with regards to implement your own laws, get them going. Let's work on making sure that our laws, the way we do it within our communities, is implemented. We've had our healing and wellness circles within our communities. Justice can only be served with you and I being involved. It's important for us to get involved in this process and to bring it home, not into the courts, not through the police. You know, as a child, I watched the steam ship coming into our community, taking us away as children. Residential school, the 60s school. A lot of our people, you know, who are missing, murdered women and girls and two-spirited people. Justice throughout Canada has not served you and I, has not served our people. A lot of our people are incarcerated. 35% of our Indigenous men throughout Canada, 35% of those incarcerated in the men's institution are our people. Your sons, your children, your mom and your dad. 50%, unfortunately, 50% of women incarcerated throughout Canada are Indigenous people. We can't continue to have that happen. Through the Indigenous Justice Council, implementing a number of things, supporting the Native court workers who have been here for years, working on trying to keep our people out of jail. First Nations Court, making sure that our people are being, finding different wellness and healing processes versus going into the institution. New Westminster is a good example of that. New Westminster First Nations Court. Out of all of the people that have come through, 98% success rate of those who are going into First Nations Court, not going into prison, not going into jail, but finding a different way of healing and wellness and doing things in the community. So I just wanted to share that the vision that our forefathers and grandfathers who sat around this particular table, whether it's through the BCAFN, whether it's through First Nations Summit or the Union of BC Indian Chiefs, they all had that vision with regards to having First Nations justice within our own communities. The centers are here for you and I, because if it wasn't for you and I, those centers wouldn't be put into place. There's 9 centers right now, and there's 6 more being developed throughout BC. Some of those centers are in Prince Rupert, Prince George, Merritt, Chilliwack, Kelowna, Surrey, Nanaimo, Victoria, Vancouver. We have a virtual process that's working with people as well, First Nations. We have other centers that are going to be opening in Burns Lake, Hazelton, Williams Lake, Kamloops, Cranbrook, Port Hardy, and looking forward to Fort St. John as well. So utilize them. You fought for them. We all fought for them. All of our organizations fought for them. Free, prior, informed consent. We want to be that vehicle for you to be able to implement your judicial systems within your own community. We call upon you to pick up those phones, call those centers, invite them to your community, ask them for an update in terms of what's happening with our people. So that vision's been set by you, by this table. I've been appointed by this table to be on that council. And it's my obligation to you to make sure that whatever it is that you want to see happening in your community as far as justice is concerned, to reform the justice process. And we're asking the First Nations Justice Council, don't follow the current court system, don't follow the current judicial system. You know, let's find out from the First Nations themselves how they would deal with it, how our communities would deal with it. So we're asking you, come to the justice centers, because that's what it's for, and you put it there. You're one of the people that put it in place, and we thank you for that. Our people thank you for that. Our people who are incarcerated today, thank you for that, because there's an alternative now. Because once you get into the judicial system, it's very hard to get out. Because you learn that, you know, it's been so automatic, just going from residential school to from foster care to juvenile centers into the institutions, and that cycle continues. We got to look after our brothers and sisters and bring them up, bring them home. You know, when we're looking at how hard our communities are, we need to look at them as well and help them through the process. So I'd like to thank you for the opportunity of you know, being your appointee to the Justice Center. And I want to just share one last thing, which is Jody Wilson-Raybould. She basically, when she was the Justice Minister, she said, this bent box, it's not empty, it's full. It's full. And what's in the bent box? You and I. Our children are in that bent box. Our communities are in that bent box. It's up to us to take back our judicial systems, our governing systems, implement our own laws within our own territories, taking care of our children. You and I have a way of doing that. You know, when my mom died, my auntie became my mom. My oldest auntie became my mom. And when she died, my next auntie became my mom. There's a process by which we take care of our children. You know it, and I know it. You know, and so together, only together, by you and I continuing to do this work that our past leaders who have now gone have put into place for you and I, and something that you continue to foster through the BCAFN. So I'd like to thank you for your time and your attention, and God bless each and every one of you.
Thank you, Cliff. And let's have another round of applause for the BC First Nations Justice Council, because they're also being kind and gracious to us today, recognizing that we're a little bit short on time. Christina Cook will email, well, let's let Terry TG RC give the gifts. And let me tell you that the PowerPoint that they would have been giving you is going to be sent to you, and Christina has kindly suggested that she write a little one-pager to help explain the PowerPoint. And if you have any questions or comments, they can be directed to Cliff White or Christina. So thank you very much. And I'm going to turn us to the resolution, and draft resolution 07-2024, call to support the creation of a Johnson alert for missing children with disabilities. We have the mover in the room, Chief Jen Thomas from Tsleil-Waututh Nation. She's over there on the back. And Chief Linda Price, Alcacho First Nation, is right here. And therefore be it resolved the BCAFN Chiefs and Assembly call on the provincial and federal governments and relevant agencies to implement a Johnson alert system named after Johnson Redhead, a new missing child alert system similar to the Amber Alert to address disparities regarding the protection of First Nations children. 2, the BCAFN Chiefs and Assembly call on the provincial and federal government to provide equitable funding for the creation and operational capacity of a Johnson Alert system for missing children with disabilities. 3, the BCAFN Chiefs and Assembly directs the regional chief to advocate with like-minded organizations that responds to the range of identified barriers for First Nations to administer alerts for missing children, in particular, children with disabilities. 4, the BCAFN Chiefs and Assembly affirms the urgent need to improve capacity for First Nations in BC to carry out their own effective and efficient missing children alert systems within their jurisdiction in alignment with the UN Declaration. And 5, the BCAFN Chiefs and Assembly calls on the provincial government to add First Nations in BC or the designated First Nations entity of their choice with their consent to the list of requesting agencies in order to be able to initiate missing children alerts and access existing ground search and rescue services in the same manner as other requesting agencies. And develop a toolkit and training program for First Nations seeking to develop independent missing persons, children alert protocols. The mover and seconder is in the room. Is there discussion? Do we have discussion on this resolution? Microphone 29.
Chief Linda Price, Algatcho First Nation. Speaking in favor of the motion, I'm just thinking of the families that have lost their children due to unforeseen circumstances. Pray for healing for them. Moving forward in a positive direction, I believe the toolkit and training program for our communities will support building the capacity and support communities who want to develop their own independent missing children alert protocols. As we all know, during all emergencies, I know we've had a few in our community, we are on the front line. We're there to respond. And so the sooner we respond, the better, especially our communities that are located in rural and wilderness areas, such as Shanalia, for support of this resolution.
Thank you, Chief Linda Price. I see that the mover is coming to the table. Can I give her microphone 22, please?
Good afternoon, Chief John Thomas, Tsleil-Waututh Nation, and I support this resolution.
Thank you. Any other discussion? Online, can I check online? No. We're good online. Any further? Oh, I heard question. Thank you. Question has been called. Oh, sorry. I think it was a tie, but tie goes to the runner. Microphone 20. Also remembering to say your name for the record.
Chief Sandra Laren from the Gitwangak First Nation in Gitxsan territory. I want to commend the women for bringing this resolution forward. I think it's critical, and I am in favor. My question that I'd love to have answered is why we're limiting it to Indigenous children with disabilities. In my community, diagnosing disability, whether it be visible or invisible, and having it recognized is a challenge with the lack of resources and supports for the North, especially, and having access to that. And what I would hate to have happen is a child, a decision be made not to have a Johnson alert issued, if that disability hasn't been identified because somebody needs to make a judgment call as to whether or not the disability is valid or severe enough. And whenever you leave anything to interpretation, I worry we err on the side of caution and may not do that. So I'm just curious why this can't be for all Indigenous children, because we know the risks of those children that have gone missing and the circumstances that surround it would all be troublesome and all have the same sense of urgency for us to put the resources into finding them. Gabi.
I was just conferring with the technical people as soon as I heard what you're bringing forward. It does say and I'm just trying to get it straight in my mind, what exactly, what we're trying to meet here. It does say in clause 3, for missing children, in particular children with disabilities, but I think your point is that disabilities are hard to diagnose in northern communities. So is that, and I don't know this, I'm just asking the question, is that something that, like, how would we direct the people to be keeping this in mind going forward? Where? So we're also asking these like-minded organizations that respond to the range of identified barriers for First Nations. Okay. Microphone 20, can I ask you to restate what you would like to see?
I think simply the removal of specifying disabilities without defining it. So you can have symptoms or behaviors, if not properly diagnosed, can fall along a spectrum of issues, whether it be from infantile exposure to substance misuse, or it could be on the autism spectrum, or it could be a physical disability, it could be from shaken baby syndrome. I would just hate for if a child went missing in my community and I had to think about whether or not they were disabled, to have a specific alert.
Thank you. Thank you. And I think what we're trying to, so up here, you can see on number 3, we took out identified. So we'll read that responds to the range of barriers for First Nations. So we're not saying which ones exactly, and it will be up to those like-minded organizations to put the fine tuning on the wording. Is that, okay. So can I go to the mover for your agreement on removing identified in clause number 3, microphone 22?
I'm okay with that.
Accepting it, thank you. Microphone 29.
I agree. I'm sorry.
Did you hear that?
Chief Linda Price, yes, I agree. I
thank
just
you.
wanted to also mention that under J, it says issuing an Amber Alert is intended for the most vulnerable, and that should include children with disabilities, as they have varying complex needs, and without knowing their location, their life could be in grave danger. In the province of BC, there's not currently an alert for children with disabilities. So I think there is already one available for those without, but not with ones with disabilities. So I think that was why we put this motion forward the way we did. Thank you.
Thank you, Chief Linda. Did I miss a hand over here? I saw some movement and I wasn't sure. Okay, there hasn't been any discussion to the contrary. We have a friendly amendment. Question was called. Hasn't been any opposition, so this resolution is passed with your consensus. Thank you. And Premier Eby is a little bit late, and I haven't forgotten Ron LaFleur, asking Ron LaFleur to come forward and give us the election results.
Just come here.
Good afternoon. Sorry for a slight delay, but we obviously had some other important business and a beautiful ceremony. It's part of the reason why I really enjoy being part of this BCAFN family. It's really, that ceremony was really beautiful. I would like to quickly announce the results so that you can move on to other business as well. And I want to take a moment to commend both candidates for standing to run for this position. As most of you know, standing for any position takes a lot of courage and a lot of effort. Today we had 52 voters, I apologize. And if we could move to the next screen, you can see that we had Valerie Ascotti with 23 votes and Cheryl Rule with 29 votes with no abstentions. As per that, Cheryl Rule has been voted as your new BCAFN Women's Representative.
It depends on when Evie gets here.
She can go now.
Cheryl can, the one who won. Because we also want to hear from Louisa, but we can hear from Louisa afterwards. If we could ask Cheryl to come up here, and we'll have a little bit of time for you to say thank you to all of your supporters.
Gikshem, I'm really grateful and very humbled. And, you know, I really appreciate the time that was given to me by each one of you. And, you know, I look forward to the hard work that's coming. I know it's going to take a lot of dedication and a lot of time, but I want to say Gikshem from each one of you for voting. So, Gikshem.
How far away is Evie?
Just doing some filibustering, but just some information you should know before Premier Eby comes to the podium. I certainly know he's on his way. We did send an invite out to all party leaders. I sent an invite to John Rustad, leader of the Conservative Party at the beginning of August, and he said no, outright said no to coming here. I certainly know he's been also saying no to his own debates in his own region or the riding that he represents. Sonia Firstenow, I'm not sure about Sonia. Maureen, Sonia Firstenow? No, she can't make it, but we do have Premier Eby to come and address the delegation. I'm not sure if you all or some of you have witnessed or saw the debates yesterday. Certainly some of the positions that we heard from all parties. And I encourage you to perhaps ask some of those important questions to Premier Eby in regards to their platform. We've seen that the Greens and the NDP have a platform that they released. There is kind of one from the BC Conservatives. And also one thing that we can share, I'm not sure if we shared it, is the response that we got from the parties from our questionnaire. We shared it? Okay, we shared it with the delegation here. And those were specific in regards to what we saw from the FNLC. anytime that election, provincial or federal election comes forward, we craft some questions and send it out to parties to see what kind of answers we get, especially in some of the work that we're doing. So just some things that you should know where before Premier Eby comes and speaks to us, the incumbent Premier. And I think it's really important that the other thing that we're doing from the BCAFN the responses are also at the back of the table. The other thing that we're trying to do at the FNLC, our three organizations, is to get out the vote. I think it's really important. We're going to do some campaigning or some media to get our people out to vote. Regardless of what party you vote for, we're really encouraging everyone to get out to vote and make sure that your voices are heard. So we're doing some of that, and we'll be coming out in regards to much of what we're hearing from many of these parties. You may have seen one of mine on TV, the commercial about UNDRIP, about the Declaration works for our people here in British Columbia. I think we're going to do the similar type of media to try to get more of our people to vote. Some of the barriers are one of the things that we did send to Elections BC is that any First Nation that requests a ballot box gets one. We certainly know that that has always been a barrier. And the other barrier that we've seen time and again is ID, and especially for our people that don't have a fixed address. So it is, one of those things where that type of information has to get out to our people of what kind of information they need to vote, whether it's ID, status card, a bill. There are many items that you can utilize to get out the vote, and we're going to share that type of information so our people are going to the ballot boxes. So that's some of the stuff we're doing. We're 2 weeks away, October 19th, 2 weeks away from the election day. So encourage you all to get out to vote, encourage your people to get out to vote. Thank you.
All right, for the first time all day, I'm not hurrying somebody along, or we're not bumping people. Oh, microphone 21, Chief Elaine.
Thank you. I just wanted to suggest we hear some CCR while we wait.
Well, one thing that was said to me, Eby's on Indian time. That's ours. No, Lodi.
All right. You know what? We could do some draws. Not the hockey one, not the hockey one. How about we do the observer ones, because we want the delegation to stay. So do I need Joanna, or I don't know, who puts the Wheel of Fortune up? Not the hockey game. We're going to do that after we hear from Premier Eby, after we hear from Dan George, and after we hear from Louisa Housty. So we're a ways away from the hockey game. Maybe the hockey game will start by the time we're finished. Just kidding. I'm just kidding. It won't. It won't. We do know that Eby will be, how long?
Right away, 5 minutes ago.
How long will he be here for? Half hour? From whenever Eby gets here, Premier Eby, I feel like I shouldn't be disrespectful. He will be here for a half hour. And then we'll hear from Dan George, and then we'll hear from Louisa. No, we don't have any resolutions to do. And I was trying to do a Wheel of Fortune thing, but I don't know if, can we do, are these the observers? Yes? These are of the observers, and there's going to be 3 prizes, and this will include observers online. If you're online, get your contact info to Joanna. Okay, let's do one right now. Go. Yes, yes. Natalie Stewart, Gitwin Silk, you're the winner of the, is she online or is she here? Natalie's here? Okay, way to go, Natalie. You'll check in with Joanna, she'll help with the prizes. And right now, I'd like to turn the mic over to Regional Chief.
Thank you, Leah. As I stated, we did put out invites to all the leaders, and Premier Eby is the only one that took it up on that invite. John Rustad said no. We sent an invite at the beginning of August, and I believe Sonia Firstnow is busy, so she's a no-show. So that being said, without further ado, certainly an important time in our province to discuss the matters of our First Nations declaration, our relationships, and where we've been over the last several years with the NDP, the sitting government. Thank you, and pass the floor. I do have to leave. I have to do an interview on your guys' debate last night to CBC, so I'll have to duck out here. But lady, let's welcome Premier Eby to discussions today on their platform.
It won't be the first time Terry's walked out on one of my speeches. Thanks, Regional Chief. Nice to see you. Thank you, Chair. Yeah, that's right. Thank you for having me here. It's good to be here at Musqueam, on Musqueam territory, and I really appreciate the chance to speak to you. We've done a lot of work together over the last 7 years since the NDP formed government. And it's on issues of child welfare, on housing, on economic development, revenue sharing in different ways. And there's no question that despite that important work, a lot of the challenges that British Columbian families are seeing across the province, Indigenous and non-Indigenous alike, they have a real disproportionate impact on First Nations families, on Indigenous families in British Columbia, whether it's the toxic drug crisis, whether it's affordability, the impacts of inflation, whether it's the housing crisis. It's really felt acutely in Indigenous communities across the province. So we've got a lot more work to do together. And what the framework for that work is the legislation that we supported together, the Declaration on the Rights of Indigenous People in British Columbia, and the action plan that we developed together to implement that and make it meaningful in the province. I know with certainty that the old way of doing things, of fighting in court, of endless delay, of conflict between the provincial government and Indigenous governments is not the way forward. I know that the only way forward is partnership, and when we work together, amazing things happen. There are so many examples of that across the province. I don't want to speak for too long. I'd like to hear from you about any questions you may have, suggestions, and I just wanted to come and express my appreciation for the work that we've done and commit to you that work will continue. If I'm and my team are fortunate enough to be returned to government by the people of British Columbia, it's too important for us not to be working together to improve the conditions of life for all British Columbians, because we know when we work together, everybody benefits. So thanks very much for having me. Looking forward to your questions, and I will do my best to answer them. And if not, I will do my best to get answers for you. Thank you.
And how long do we have?
Oh, he doesn't know how long we have. Well, that's good for you. I'm actually, you can stay up here and I'll moderate from down here, but I can't actually see everyone, so maybe I'll just kind of be over here. So I see we have I'm going to stay over on this side with Cookby Spahan and then Chief Dan on microphone 13 and then 14.
White, Antla, and Jawa and Squash, Leaspahan, Cook, Bevid, Salutku. Hello, good afternoon, Leaspahan, Chief Quarter Band, also proxy holder for Shakin Indian Band. Thanks for joining us today, Mr. Premier, and giving us your time to come talk to us and listen to what we have to say as leadership of BC. I have some huge concerns around what is happening in the Nicola Valley in regards to our healthcare center, our hospital, as well as the police. And so far, the hospital has been closed quite a few times. I think it was 16 times this year. And according to documents that were leaked to the media, it's going to be closed for another 6 more times before end of December. So I'm wondering, with the election coming around, what is your party going to do to fix this very important problem? Because you look at all the highways in the Nicola Valley that it's like the major hub of the interior. The highway to Kelowna, to Princeton, to Kamloops, to Logan Lake, down to Spence's Bridge. And it's a huge concern, not only for the First Nations, but the non-First Nations and also the people who are traveling the highways. My second question is the huge concern around policing in the valley and the lack of. We went from 4 Indigenous liaisons, and I think we're down to 2 or 3. And that's split between the 5 bands of the Nicola Valley. And it worries us as leadership because, you know, there's problems in each of our reserves where drug dealers reside. And at one point in the last few years, there was a shootout in Coldwater. And what's going to happen with the catch and release program that the government is doing with these offenders, and how is that going to be fixed moving forward? Because guaranteed it's not only happening in the Nicola Valley, it's happening all over the province of British Columbia as well too. And last time we spoke, I did invite you back to the Nicola Valley to speak with myself and my council as well as the Nicola Chiefs too. So that invitation stands. So some questions for you and looking for some commitment on some meeting dates with you as well too, Mr. Premier. Thank you, Madam Chair.
Thank you.
Thanks.
Microphone, wait. Oh. Sorry, I just need to organize us a little bit because I got 10 people who want to ask you things. So he's going to sit down and make some notes. Yes, 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 yes. Borrow my pen. You can actually have it.
Oh.
Now I'm going to tell you who the rundown is. So we have Chief Dan Manuel at 14. Then we're going to go to Deb Foxcroft at 19. We're going to stay at 19 and have Chief Jerry Jack. So we're going to take those 4, and then we're coming back to the list. And no, I am not going to add anyone else because we have to be respectful of the Premier's time. And did you note that Cookby Spahan wanted to set up meetings for you afterwards? So there you go.
It's a good sign.
That's a good sign.
Yeah.
That's what I'm saying. I'd like to go to microphone 14 and then Chief Dan, asking everyone to be as concise and brief as possible. Thank you.
Thank you, Madam Chair. Thank you, Premier Eby. I just will keep my remarks. I have a lot of questions and concerns that I would like to raise with you. So if you have some time after the meeting here, I'd be very grateful to catch a moment of your time. We have a very critical issue that's been on my community's agenda for decades, generations, related to the theft of what was promised as reserve lands. It's referred to, as you know, the Douglas Lake Commonage. We've been engaged in discussions with the Government of Canada and seeking to have participation, meaningful participation of the province at this table. As you're aware, land claims, specific claims around land are critical in British Columbia. British Columbia was formed on the assertion of sovereignty of the Crown that has been legally proven to be deficient, and we need to address this matter urgently if we are to be expected to to believe and trust in your promises of a better future through reconciliation. We need to correct the very harmful policies of the past. I'm the fourth generation. My grandfather's grandfather, Chief Johnny Chilhidze, during the McKenna-McBride Commission, told the government of British Columbia, if you claim this land is yours, I'm opposed to that view, and we are of opposite opinions. The resolution of that question has not been addressed for my community, and in seeking to address a small portion of a specific area of land that was stolen from our community, we get foot dragging and empty promises of participation from your government. I would like to hear a commitment from you today to resolve our issues around the land question specific to the Douglas Lake Commonage. Thank you, sir.
Thank you, Chief Dan. We'd like to go to microphone 19 with proxy Deborah Foxcroft, Sishat.
Good afternoon, Deb Foxcroft. I'm proxy for Sishat First Nation, for our chief, Ken Watts. Just want to thank you, and I just know that you are well aware of the opioid crisis and mental health in this province. And Sishat is a member of the New Chonmouth Tribal Council who declared a state of emergency in our communities. I just wanted to say that BC needs to invest more resources and supports to all of our communities in British Columbia. It's not just Sishat on the West Coast, but we need more resources and supports. And just actually last week, we lost another young person to an opioid crisis or opioid overdose, and our people are dying at a rapid rate. In fact, we have a funeral being held tomorrow for this young person, and this is real for all of us, and it affects our communities and our families. I just wanted to say that Port Alberni is one of the second most largest community that has large overdoses, and we are losing people at very rapid rates. What are you and your party committed to do to take real solid actions with our Sishat Nation, but also all of our tribal council nations and in the Port Alberni area? Thank you.
Thank you, Deb. We'd like to stay at microphone 19 and go to Chief Jerry.
Gela Kessler. My name is Clark Wigela. I come from the House of Sisat and Mocha Territory. I'm one of the chiefs from my nation. My English name is Jerry Jack, and it's very nice to see you and address you today, Premier Eby. I just wanted to know your plans, thoughts on hydrogen projects going ahead in British Columbia. I like them because we have to get away from dams, because dams flood our territories and we don't have a say in it. You know, we unfortunately, you know, when it comes time to go to court to prove we lived somewhere, we can't, because it's underwater now. on Highway 28 between Gold River and Camel River, we need proof that we occupied that territory, and we can't because it's underwater. And it's really frustrating because unfortunately, you know, where I come from, and I don't like talking about Captain Cook, but he was the first white man to land in British Columbia, and he landed on my beach. He was met by two head chiefs, Maquina and Callacum, and I'm a direct descendant of Chief Callacum, and that's where I get my chieftainship today. I got to go to court today to prove that we owned that land before he showed up. And it really eats at me every day. My dad went to jail fighting for this in '75. You know, it's frustrating, and you know, love or hate the logging industry. I hope your party makes it easier for people to go to work, not only Indigenous First Nations people, but, you know, when I go to my meetings with Western Forest Products or whoever, we have to get along. And it's hard for them to go to work, and it bothers me that we have to purchase cut blocks in our own territory. You know, they've taken out millions and millions and millions of cubic meters of wood from my territory since the 50s. I remember growing up in Gold River when I was a kid, how many logging trucks went by, you know, but I had something else, but you know, policing and justice is another important issue to me. You know, like my friend Lee was talking about, I was stationed I'm a retired Mountie. I spent 21 years of my life in law enforcement in Canada and the United States. When I was stationed in Merritt, the detachment commander said the only reason why he signed that tripartite agreement because he got extra bodies, extra cars, extra office equipment, and a budget. And I was told not to go to the reserve. You know, and I said, we just signed a tripartite agreement. You know, it's really frustrating for us, you know, on the policing aspect. And I hope one day that I'm going to ask Deputy Commissioner Dwayne McDonald to come to one of our meetings, and you know, because I think it's important. But I just wanted to bring those issues up and get your thoughts. And best of luck to you in the next couple of weeks. You know, I always say, love or hate NDP, they've done more for us than any other political party has done, you know. And anyway, best of luck, Mr. Eby, and your team.
Thanks, Chief.
Thank you. We'll take one more, and then we'll go to Premier Eby, and we'll go online for Bill Yoakum.
Thank you, Madam Chair. Scalizos and Bill Yoakum, proxy Sanamo First Nation for Chief Wise. I just want to not really a comment. I just want to say thank you, Premier Eby, for acknowledging Orca Latham last night in your amazing debate, in which I think you won handedly, and it's great future for BC and being a champion for youth, in this case, Indigenous youth of BC. Instead of throwing stones, you came up with a solution and created one of BC's first youth treatment centers. So I just want to lift your hands up for the great work you're doing. Thank you so much, Mr. Premier.
Thank you for that.
Thank you. Thank you, Bill. Now we'd like to go to Mr. Premier for a response.
Thanks very much. You know, I think in a number of the remarks I hear frustration about the pace of addressing some of these issues. I share that frustration with you. I want to move faster on these things. We've got to do more. And I also hear a strong overlap and concerns that you have with the concerns that the broader British Columbia public has: quality of health care, toxic drug crisis, economic development. So let me do my best to provide answers to what you've raised. On the Merritt Hospital, and I suspect there are many of you that have home communities that are dependent on rural health centers or smaller hospitals in the province. One of the areas of success we've had is connecting people to family doctors. We've connected 250,000 people in the last year, and the pace is picking up. And for people registered on the Health Connect registry, our goal is everyone will have access to a family doctor by the end of 2025. One of the areas where we've really struggled is getting the doctors and nurses into smaller centers for emergency room care. So we've had to revisit what can we do, what additional steps can we take. So we're going to be directing the College of Physicians and Surgeons. There are doctors out there that want to do this work, to give provisional licenses to doctors who can practice in Canada to start working right away, so they don't have to wait for process. For internationally trained doctors that come from similar healthcare systems, provisional license within 6 weeks. And we're going to issue this direction to the College of Physicians because we try to be cooperative with them and work through their processes, but it's still taking too long. It takes too long to get those doctors off the sidelines. We also have a new incentive program for doctors and nurses and health professionals to work in smaller centers, a loan forgiveness program, so that new graduates, in exchange for a 5-year commitment, work in smaller communities in the province. For RCMP, I suspect many of you are seeing the impacts of a shortage of RCMP officers in the province. It's something we've really been raising with Ottawa, pushing them on to get more recruits through. We provided full funding for RCMP policing across the province. The spots aren't getting filled though. And so one of the things that we're looking at doing is, are there things that the province could do to take the pressure off the RCMP so they're able to provide full resourcing for things like liaison positions, like traffic enforcement, other kinds of work that could take the pressure off the RCMP so that they're able to focus on the important work that needs to be done in your communities. We have provided additional funding support, but one of the things also that we want to work on is providing support to communities that want to do more of their own policing as well, given the shortage of policing, the fact that we've dedicated the funding, the money is there, but the policing teams are not. Using that funding, if the RCMP is unable to use it, that nations could provide their own policing programs, provide their own security in communities where they're interested in doing that. Again, I'm very keen to visit Nicola Valley, ideally as Premier still. The people of BC willing, so thank you for the kind invitation, Kupti. On the specific claims process, it always breaks my heart to hear that we're not at least as good as the feds, if not better. So I'll definitely take that back. We should be at the table on most tables. It is us pushing the feds to be faster, to do more, but it's not universal. And so I'm frustrated that for the Douglas Lake claim that it seems to be the province holding that up. So we'll follow up on that, and thank you for bringing that to my attention. For the Newfoundland Tribal Council Declaration of Emergency, there were some very specific asks from the Tribal Council about support for the community, things like counseling, treatment interventions. The declaration came out right before we stood down for the election, but the ministries they were given direction right before the election period to begin working with Newfoundland on some of those specific asks. We're also more broadly, just I'm sure you're aware, but just in case not, for the First Nations Health Authority, they still have, I think there are 5 funded treatment centers that they're working on deployment across the province to make sure people get culturally appropriate care. And they are accelerating their processes. They're working hard to get those open, and I'm very excited to get those open as soon as possible. As far as the funeral tomorrow, I mean, the deaths are devastating, and I know that Indigenous communities are feeling that right across BC, and you're losing so many young people. And I am committed to work with you to save those lives, to make sure that promise of the lives of these young people is not lost, and my heart goes out to your community that you're dealing with that right now. For Chief Jack, lots of great questions about economic issues. Very much in favor of hydrogen energy development in the province. There are a number of hydrogen energy proposals that are coming forward and where the proponents are working with local nations. And I'm very hopeful that we'll deliver some of those clean energy projects in the province. We have a $1 billion hydrogen fueling system in the Lower Mainland going in, a multi-million-dollar investment in a hydrogen motor factory in the Kelowna area. We can see now over $1 billion in investment in this sector and it's only going to keep growing because we have cheap, clean electricity. And so there are a couple of pieces that also pair in with this. One is BC Hydro's call for power for clean electricity. Hydro is ensuring that there's space in that call for power for Indigenous power projects, and we put some money into the new relationship trust so that nations could access money for developing these kinds of clean energy proposals to feed into the grid and help support, for example, the hydrogen sector. So I really encourage you to have a look at that if electricity generation is something that's possible in your territory with the geography that you have. We're focusing on solar and wind, backed up by the dams. We're not proposing new dams. And I thank you for raising the important issue of the impact that these major dam projects have had on Indigenous communities, particularly in the province. On logging, Western Forest Products, we've had some really great agreements struck between Western Forest Products and nations on the island. More work needs to be done. The connection between local nations and the forests around their communities and revenue sharing and participation in management is the direction that company is going, and I think that's really positive. And also we're seeing more Indigenous forest companies being successful, taking over mills as quarterly profit-driven, publicly traded companies, see a low price of timber and say, we're going to close this mill. We're seeing nations stepping up to buy and open mills, and we want to partner with nations around the forest to be able to feed those mills, to be able to support economic development and long-term community development with stable jobs. I think there's a huge opportunity there, and I'm really grateful that you raised it because I think it is the future of the forest industry, just as we see companies like Canfor moving away from supporting communities that have been dependent on them for a long time. So lots of really important and key issues raised. Thank you very much, Chiefs, for the opportunity to speak. Thank you, Chair, for your facilitation. And
You're not done yet.
And I'm not done yet.
You can save that part because we're going to hear from 5 more people. You're pretty popular.
Okay.
Just
Thank you, Chair.
in a good way. So here's the next rundown. We got 5 people that are going to speak, asking people to be as quick and concise as possible. It's almost 4:20, and we still have a couple more agenda items to do. Plus, we're going to be drawing for 2 sets of Canuck tickets, and we're not doing that till the bitter end. I have microphone 23, Grand Chief Ed, microphone 16, Chief Kane, microphone 24, Chief Victor. Online, we'll go to Chief Colin and Chief Sid. Starting with the Grand Chief, microphone 23.
Thank you, Madam Chair. I'm Edward John, elected Chief, Glasgow Nation. Mr. Premier, thank you for accepting this invitation to this meeting. I have, for my reference, and I want to thank your party for providing this platform for our consideration. There's commitments in 22 pages, and it's pretty extensive in a whole range of social and economic related issues. I wanted to, on another hat I'm wearing, I'm the chair of the Native Education College. It's been around 56 years, and it's reached back to the ones who have never completed high school, and has worked with them to achieve their grade 12 certification. And it's been doing that for years, and it's been, like I said, 56 years. It's moving into a public post-secondary institution for next year, and we want to make sure that that's not forgotten. It was supposed to have been this year, but it was delayed or postponed, as we were advised by the Ministry of Advanced Education for a year. I believe it's a commitment that was made in the UN Declaration Action Plan. So we'd like to make sure that it's not left off to the side and forgotten. The second thing is, on behalf of Glasgow Nation, the issue of technology, IT, and cell service in our community, where the nearest town is 50 kilometers away from our village. And there was an incident this morning. The RCMP were involved in one
our members, but the problem came that one of our offices were not able to communicate out because of limited cell service or poor cell service or no cell service actually, and IT service. So that becomes a health issue, becomes a very serious safety issue. And so I'd like your government to take a look at that and work with us to find some solutions. We think that the province has made some commitments earlier around these matters. What I wanted to talk about was last Friday, our annual General Assembly adopted a very extensive document underlining the inherent rights, Aboriginal title that we hold exclusively, historically and now, to the core of our territory. And in that core territory is a huge nickel deposit, as you may understand. It's probably one of the largest ones in the world. Other people refer to as the FPX project. We call it the nickel deposit because the minerals are in our territory, and we have made no arrangements with government, federal or provincial governments, or with industry about what to do with that. There's an extensive interest on it. I think this is the first time it's been raised publicly by me. But I want to let you know that we have a very extensive document that outlines the nature of our relationship on a government-to-government basis, that as First Nations people, and as confirmed in the UN Declaration standards and in the Supreme Court decisions, we have the right to make decisions about our lands, territories, and resources, including minerals, water, lands, and so on. And we want to post the election to convene on a priority basis some meeting with yourself and maybe your new ministers appointed to deal with this. It's important to us. The proposals that we've seen in the past coming from your government have been to continue fostering underdevelopment, just enough money to get by to do some minimal amount of projects. What we want to do is confirm our support for the United Nations Sustainable Development Declaration, Sustainable Development 2030, Sustainable Development Goals 2030. And principles in there talk about two things that I think are important to us. One is to leave no one behind in sustainable development, but more importantly to us is to reach back to those furthest behind. And I have to say that the social economic conditions in our communities are such as that governments need to do that. It can't be just like what's good for the region is good for the First Nations. We need something more that's carefully designed with us. And so I just wanted to raise that. Language is absolutely critical to our communities. It is our number one priority, our Daket language. In the last week and a half, in my community, I've lost 3 elders who are fluent speakers. That's 3 less that we have to rely on. And these were, one of them was extremely excited that he would now be called on to come in and work with the kids in learning our language. Lastly, your colleague, Murphy Abraham, candidate for Stewart Chaco, came to our annual assembly, and he was welcome and endorsed by the community as a candidate to support him in this election. So everyone's mindful is to get the vote out. Get out and vote on the 19th, because that's usually the biggest challenge that we run into. Thank you for taking my questions and my comments, Mr. Premier.
Thanks, Grant Chief.
Thank you, Chief Ed. I'd like to go to microphone 16 and Chief Kane, please.
Thank you. Good afternoon, Premier Eby, Justin Kane, Chief in Esquila. Since NDP formed government, you've definitely implemented a lot of good things. My concern is there's a lot happening. We have 204 communities in the province, and it comes to a point where, we write letters on behalf of our community. Also, I sit at the table for a little tribal council. We write letters at the Statlium Chiefs Council. We write letters. And it takes a long time if we get a response. So I'm hoping, for what I see, is that, with the implementation of many things is a good thing, but I feel that there's not maybe, I don't know, I'm assuming there's not enough staff at the government to have more conversations with the communities. It's not only us as First Nations, but I understand you have a province to engage with as well. So I would look at, I'm asking if there would be a possibility for a commitment from you to top load your staff to help engage with more of us communities to get some of the work done that we're all trying to do at the same time. It comes to a sense of despair when we're not getting responses in a timely manner or at all. So, Cook's Jam.
Thank you, Chief. We'd like to go next to microphone 24, Chief Victor.
Thank you, Mr. Premier, for accepting the invitation. I too watched the debate last night and like some of your answers for sure. Just want to echo some of the things that come up already. The opioid crisis. We were trying to get a mental health worker within our area to try and help with the cause. It's in our neighboring area, Port Hardy, Port McNeill, Alert Bay. It's really ongoing. We're losing a lot of people to that. And we need some support up that way. Also, I want to touch on the emergency services, much like other communities. We don't have a doctor after 7 o'clock. We don't have a service, the emergency service after 7 o'clock. If we want to get any service, we have to go to Port McNeill on a water taxi. And lots of times people haven't made it to Port McNeill. They've died en route. So we need support to get more doctors in our area, more nurses, and we understand some of the surrounding communities have got some support, and we would like to be given the same services in that manner, because we need to get the doctors, nurses, and facilities improved for sure up that way. And right now we're not getting very many good answers. Sure, it's downtime right now, but we'd like to have a meeting with you and discuss this further to try and improve those our concerns, definitely for sure. And we're also in our Alert Bay, the housing and the Numgis First Nation our housing is much like other First Nations. It's horrendous. We have people, 100 people waiting list. And we're seeing provincial housing programs pop up. The federal program is just so slow. It's just not very good at all. And with homelessness, they talked about it last night. And with First Nations, we don't kick people out. We have overcrowding. We got up to 15 people in some houses, and this has to stop. So we need your support. We'd like to set up a meeting with you guys, and thank you for your time.
Thank you, Chief. Our last two speakers are online. We'd like to go first to Chief Colin.
Thank you, Madam Chair. Thank you, Premier EB, for making the time. I have one question. I'll keep it concise. And that question is regarding the ongoing diplomatic situation that has been unfolding up here in the north. As I'm sure you're aware, Premier, the Gitnyaw Hereditary Chiefs publicly burned the 2014 Prince Rupert Gas Transmission Project natural gas pipeline benefits agreement that existed between them and the province. So in light of the principles of free, prior, and informed consent, and hopefully avoiding a repeat of the Coastal GasLink conflict, what has your government done to address this situation? Thank you very much.
Thank you, Chief Sutherland. Next, we'd like to go to Chief Sid Scotchman.
Good afternoon. Thank you to Madam Chair and Premier for making time for today. My name is Sid Scotchman, Chief from Cleakit within the Statlium Territory. I'm zooming in from Cleakit actually. I was hoping to make it to Musqueam, but in the last month we've had a lot of passings in my community. I wasn't able to register to be in person, but thank you for making time for those that are on Zoom for questions. Sorry, just give me a second.
Rose.
Yeah, the pop-up for mute kept coming up, so sorry. Yes, yeah, a few of the other chiefs touched on it earlier, but I want to know more about what can be done for the interior health region for the ER closures. My community, we live in fear every single day. Are we going to get a notification that the ER is going to be closed? Because most of the time we don't find out until 2 hours before. And even then, that's really short notice. We want to sit down with you guys. We want to sit down with Interior Health to form a better communication strategy. It's great and all that you guys are working on more recruitment for rural areas. For my area, for Lillooet, it takes 2 hours to get from Kamloops to here, or from here to Kamloops when the ER is closed. And we only have a couple ambulances available. What happens if someone needs emergency transport but there's no ambulance? They have to rely on a family member, but they're not trained. So is there a way that funds could be made available for areas like mine to access funds to pay for first aid attendants to transport people if the ambulance is not available? And within the Statlium Territory, in the northern Statlium Territory, we have another community that falls within Interior Health Region, and they live an hour from Lillooet. So they have to travel from their community to Lillooet for an hour to get to the ER here. But when it's closed, that's an additional 2 hours, depending if they have to call an ambulance, and then that's another hour onto their transport. Is it possible that you guys can work with this community to get a water taxi, to get air transport if needed? I just want to know more information, and you did touch on it earlier with working on a recruitment to allow doctors from other countries to get to work faster instead of going back to school. That's great, but we want to know more. So thank you.
Thank you. We'd like to go back to Premier Eby.
Thank you. There was a lot there. I'll do my best to provide a meaningful response to all of the issues raised. Grand Chief John, on the Native Education College commitment, we're still committed to converting it to a public post-secondary institution to recognize the important work that it does and ensure there's support for Indigenous students in the province in a meaningful way. They do amazing work. Cell service and internet, our commitment remains. There's money in the budget to get to 100% high-speed internet coverage across the province. And we've been delivering that through citizen services. We're getting close, but we're still not there. You're right. I mean, that's one of the basics for people to be able to participate in the economy now, and also to stay in touch with emergency services. On FPX nickel, this is a really significant opportunity for your nation, for the province. There's a company proposing, this is obviously not for you, Grand Chief, just for anyone else who's interested, there's a company proposing to develop a nickel mine on the site and to refine the nickel, because it is contained in a mineral. It's a different kind of nickel than you find in Ontario, and that's developed there. But it's really important for batteries, and that's why there's interest in doing it. I've been very clear with the company and all the mining companies. There's 17 mines proposed for the province. They need to be working with nations, in partnership with nations, on developing these proposals. In order to support nations in doing that work together, in our platform, we've committed to supporting Nations Readiness Office, which provides resources to nations to be able to participate meaningfully in these discussions. Instead of just getting a fax or a letter or whatever, an email saying, you know, this permit's being considered, or all of these permits are being considered, and then trying to figure out how you're going to balance that with everything else that you have to do. locally to make sure that you actually have the resources to participate in a meaningful way in conversations with these companies, because they are, in my experience, these companies get it now. They understand that this is the path forward, but they also express some frustration. They say, oh, we don't know how to do it. We don't know how to partner with the nations, and who do we talk to and all these things. So they've told us that supporting nations is actually helpful to them, because then the nation's ready to have the conversation and things go much more smoothly. And our commitment around that is also about faster permitting processes, which we know we can only do where there's support from nations because of the various legal rights that nations obviously have in their core territories. The question about, oh yeah, just the scale of the work that we have to do, 200 plus nations, and then, you send in a letter and you don't get the response from the provincial government for a long time. It's real. There are not, and there cannot be, to be totally blunt, enough provincial government staff to respond to all of the concerns and priorities, which are priorities and need to be responded to by the provincial government in the time that I would like and that you would like us to respond. One of the ways that we're able to go at this is through groups like BCAFN, where you're able to identify shared areas of concern, and then we can really make some progress in a way that meaningfully improves life in a whole bunch of communities at the same time. The leadership gathering is a great opportunity to talk directly with ministries about those particular issues in your community where we can make a difference, and that work does get worked through, and we have made progress on many issues that way. When you get to talk directly with ministers, then we're going to keep doing that work. That's our commitment to you, and Chief will be working hard to try to find ways to be more efficient in responding, to be able to get back to you in a more timely way. I'm sure it's frustrating when it's such a dominant issue in your community and it just doesn't feel like it's a priority for the province. It's not the case. We want to get the work done. There is a huge amount of demand and a huge amount of work to do. For Port Hardy and Port McNeill, Chief Victor, I had the opportunity a couple months during the pandemic to live in Port McNeill, and my wife worked at the health clinic in McNeill, so I know a little bit more about the state of healthcare there than I might otherwise. And I had a great time in McNeill. I thought it was amazing and an incredible place. My wife had a very stressful time being a resident doctor in that health center. Often it was just her and a nurse providing healthcare there. And someone would come in who was very, very ill, or from a car accident or whatever, and knowing that she was hours from the nearest major hospital trauma center. And it must be awful to have a loved one who's that ill and needs that kind of care. And it's not unique to your community. It's across the province. For North Island, around doctors and nurses and mental health supports and so on, Michelle Babchuk has been a great advocate for you on these things. She's been working with the Health Authority to make sure that there's more access in particular to mental health and addiction supports. But you will benefit from the work that we're doing to bring on those additional doctors and nurses. It is a shortage of health professionals, and it's terrible because we'll get someone in there and then they'll have these terrible, stressful experiences like my wife had, and they'll be like, I can't do this work, it's too stressful, and then we can't keep them. So we got to get that critical mass in, and then it's less stressful because you're working with colleagues and you have the resources that you need to provide that care. And so that incentive program is going to be very, very important for providing the support in your communities. On the Gitniao-Niska issue around the LNG proposal, Niska has licenses to begin work, and they were given approval from the environmental assessment folks in the province to begin work on their territory. My expectation is, and where this needs to go for the rest of the pipeline route, Niska knows this, they have to engage with Gitniao because it passes through Gitniao territory. Just like any other project proponent, they have to work with Gitniao. I've seen President Clayton say publicly her commitment to do that work, and there is an expectation from me, from the Environmental Assessment Board, and from certainly from Gitniao that work happen. Obviously, there are tensions between Gitniao and Niska on various territorial issues, but I am confident that with supports the nations will be able to work through this. Finally, on interior health, the same series of the same issues, but specifically on the issue of patient transportation. There were when we formed government, the paramedics that worked in rural and remote areas were often on call. They were paid sometimes, I think it was like $2 an hour or something ridiculous for being on call as a paramedic. We had a dated air ambulance system. It needed to be updated. So we've got 5 new jets and helicopters providing air ambulance service across the province. We have full-time paramedics working across the province. And I know that if your emergency room is closed, it's not enough. That's why we have to do the work to get those doctors and nurses in place to deliver that care in your communities. I'm concerned about maybe the access to these kinds of services in these communities, so would like to follow up. It's a bit of a weird time. It's called interregnum during the election. I don't have access to the public service in the way that I do traditionally as the premier when it's between election times. So I can't just call someone up and say, what's going on with the paramedics in this area of the province? What I would appreciate is if the people send us back into government is if you could send in to the Premier's office just a summary of the areas and the paramedic coverage and the paramedic transfer issue, and so then I'll be able to follow up with our health minister on making sure that paramedic coverage is there for your community if in the event that the emergency room is closed and people have that support, and if you have suggestions about how we could add to that with transfers from the local community, happy to explore that. Chair, we're doing more here, are we?
Just one more comment from Regional Chief, and then you can make your closing comment.
Okay, sounds good.
To lower this, thank you, David. Bonus round. Last question is in regards to the comments that we heard yesterday in the debate in regards to the Land Act amendments. What is the plan on moving ahead with the amendments? And if there is stepping back from the amendments, as we've seen this past spring, then what is going to take place? Easy question.
Very straightforward. Thanks, Terry. Yeah, we have to find another path forward here. One of the pieces of feedback we got, both from Indigenous and non-Indigenous communities across the province, was that the Land Act amendments were causing division, were causing racism, were causing a lot of anxiety in local communities. And so we had to take a step back. And we know that we have to work together on so many different issues. And the Land Act amendment became this lightning rod, which was trumped up, and I use that word deliberately, by John Rustad and by the BC Conservatives. But also, we'll take some responsibility here. You know, I don't think that our government did a good enough job before introducing that amendment to reach out to important stakeholders, non-Indigenous stakeholders, to make sure that people understood what we were doing, that it didn't mean that we would be going ahead with wholesale reform in land in British Columbia, undermining local feedback and decision-making, that in fact it was a commitment to work together on these important issues. So we'll do better next time on any discussions on specific initiatives, and we won't be bringing back the Land Act amendments because of, frankly, the huge amount of anxiety and problems that were caused when it came forward, and we'll find a better path forward. So thank you, Regional Chief, for the question. If I could just, in closing, I wanted to recognize Callista Ryan, who's our candidate here. It's in, I think Shaughnessy is the official name. What's it? Kilchenna, sorry, yeah, that's what it is. It just happens to have a lot of Shaughnessy in it. Kilchenna is the community here that Musqueam community is located in, and she's our NDP candidate in this area. I hope it's okay. I invited her to join and to hear your questions and make sure she understood what people were talking about. So, Callista, I'm glad you're joining, and thank you, Wade, for joining as well. Nice to see you. It's not a coincidence to me that John Rustad didn't show up here. He's the leader of the BC Conservatives. He wants to be the premier, just doesn't like to take questions. He refused to do a debate on the island with me. His candidates aren't showing up in all community events. He doesn't take follow-up questions from journalists. If he doesn't like the question, his press secretary cuts off the journalist. I think that it's important, and today's discussion is a good example. It's not comfortable. You know, I want to do more. I want to partner with you on so many things. I want to deliver for your communities and for all British Columbians. It's hard to take questions and have people say, you need to do more. And but my commitment to you is I'm going to keep showing up. It's what I've done before the election campaign. It's what I'll do after the election campaign. And also, I won't repeal the Declaration on the Rights of Indigenous People in British Columbia. This is a law that just recognizes the rights that Indigenous people have in our province. John can repeal that law, but it won't change the inherent rights and title of Indigenous people recognized by the Constitution, the Supreme Court of Canada, and the rights that Indigenous people have here. And you have my commitment that I will always see this work as a partnership, as government-to-government relationships, not parent and child, government-to-government relationship. We are partners in this work of improving our province, of lifting everybody up, supporting your communities as well as the whole province. I'm honored to do this work with you. I chose British Columbia as my home. I was welcomed here by many Indigenous people who were so generous to me and so kind and so welcoming. And all I see in this province is Indigenous people partnering with the non-Indigenous community to make a stronger province again and again and again. There's so many examples I can point to. And despite everything that Indigenous people have been through in this province, despite what they've been subjected to, the generosity of spirit and the willingness to collaborate is, it's an example to everybody, and it's part of the values of our province as a whole. So thank you for that. Thank you for making me welcome here today. I hope to be back as Premier again, and it has been an honor to work with you. I hope to continue that work. Thank you.
Thank you. Thank you to Premier Eby for joining us. We still are not at the time to draw for the Canuck tickets, but we have had Dan George, our good friend, my brother, online waiting to give you the climate change, First Nation climate leadership agenda. I'd like to thank you, brother, for hanging in with us and also asking you be a little bit briefer than you were going to be, just given the time and that you're taking time away from your own family, and we want you to know we appreciate that. Over to you, Dan.
Can you see that all right? Does my slide look okay?
Yes.
Thank you very much. Thank you, Madam Chair. Good afternoon, chiefs, councillors, leadership, and technicians. Thank you for the opportunity to address you today to provide an update on the BC First Nation Climate Leadership Agenda development process. I had the good fortune of working with Patricia Rojas and Christy Denby, facilitating the many dialogue sessions we held across the province to inform this most important work, and their support was invaluable in the dialogue process. I want to preface my comments by noting that I'm not positioning myself in the room as a subject matter expert on climate change. Should there be time for questions, I will call upon Patricia. Should you have any questions, they're outside of my wheelhouse, as she is much more learned on the subject. In the chat column, I believe they're going to be putting a link to the briefing note that includes the high-level recommendations that are being made, as well as a link to register for the October 21st Chief and Leadership meeting. And I understand that the draft high-level recommendations were also included in the meeting package. So in the interest of time, I will jump right into the presentation. So we know that there's an urgent need for action in the area of wildfires. The season of 2024 has been one of the most severe on record, continuing a trend from previous years. And by mid-year, June, tens of thousands of residents were forced to evacuate due to large-scale fires. And we know that many of those people were from our communities, and many still have not made it back to their home community. Increased temperatures and prolonged dry conditions driven by climate change have led to heightened wildfire risks and destruction of properties. In other areas of the province, we have challenges with floods, which has become more frequent, with river swelling and flash floods damaging infrastructure. And this year, heavy rainfall combined with already saturated soils has exacerbated flood risk in communities across the province. We also face droughts within our territories. So 2024 saw ongoing drought conditions, particularly during the summer, which affected water supplies and agricultural productivity. And drought has intensified due to reduced snowpack and longer dry spells, which in turn fuel more wildfires and deplete critical water reserve. So these events call for an urgent need for action, and the climate crisis is outpacing BC and Canada's ability to adapt. And again, we know that the crisis it exponentially affects our people, our communities, and our territories.
I didn't get any chance.
So we know that Canada has committed to co-developing a distinction-based Indigenous climate leadership agenda to build regional and national capacity and progressively place authority and resources for climate action in the hands of First Nations, Inuit, and Métis peoples. At this time, each distinct Indigenous group is developing climate agendas across Canada. And the commitment to develop climate agendas is the result of many years of advocacy from First Nations leaderships and organizations such as the BCAFN and the National AFN through technical tables such as the Joint Committee on Climate Action. The First Nations Climate Leadership Agenda seeks to address structural gaps that we all know exist, such as systemic inequality, short-term funding cycles, and competitive programs that limit access to available funding, lack of First Nations involvement in decision-making, and limited capacity and uncoordinated, siloed federal systems. Resolution from 2023 mandates the BCAFN to work with First Nations to develop the First Nations Climate Leadership Agenda in British Columbia and ensure First Nations recommendations and policy directions are fully considered in the Canada-wide First Nations Climate Leadership Agenda. And we heard that the BC First Nations Climate Leadership Agenda would reflect and respond to First Nations realities, needs, priorities, and interests, and ensure that federal climate policy and legislation respect and support self-determination and our inherent and constitutionally protected title rights and treaty rights, and that it empowers First Nations meaningful involvement in national climate governance, and it ensures appropriate federal financial support for First Nations climate actions. The First Nations Climate Leadership Agenda co-development process was initiated with a spiritual knowledge keeper gathering on climate change on November 17th to 19th. Knowledge keepers shared personal experiences, stories, prophecies, songs, and teachings to support healing and guide our collective work on climate change. For the first time in a ceremonial space, approximately 80 observers from provincial and federal governments and First Nations, including our youth, our leadership and staff, NGOs, the private sector, organizations, academia, and interested parties were invited to witness, listen, heal, reflect, and carry back the teachings to their lives, workspaces, and communities. Following that gathering came a virtual session called A Vision for Co-Development, centered around defining what is co-development and meaningful engagement for First Nations in British Columbia. And the Vision for Co-Development session informed the 8 regional in-person engagement sessions that took place between April and July of this year. And these sessions were hosted in Prince George, Fort St. John, Kamloops, Haida Gwaii, Terrace, Chilliwack, and Campbell River. Based on guidance from the Knowledge Keepers Gathering and the co-development session, participants were asked to identify priority actions, policy directions, and concrete recommendations to the federal government for implementing and advancing the BC First Nations Climate Leadership Agenda. Most recently, we hosted a virtual engagement session in September for all First Nations and First Nation-led organizations that participated in the regional in-person sessions. We presented the themes and recommendations that emerged from the engagement sessions and discussed the next steps to advance our leadership agenda. BCAFN technical staff and members of the BC First Nation Climate Leadership Agenda Steering Committee also participated in 3 national technical meetings with other First Nation regional leads from across Canada and the federal government to bring First Nations priorities from BC into the Canada-wide First Nation Climate Leadership Agenda and the memorandum to Cabinet. Regional Chief Terry Teegee and a steering committee member and UBCIC youth representative Katisha Paul participated in a leaders meeting of the FNCL agenda held in Ottawa in June of 2024, alongside other First Nations leaders, federal ministers, and other senior federal officials. In this meeting, Regional Chief Teegee presented the priorities gathered from the series of engagement activities we hosted in BC, including the urgent call for moving from the planning stage to climate action, emergency management priorities, investments to reduce the infrastructure gap, and the need for holding similar gatherings in BC with rights holders. Using what we heard during the many engagement activities and previous work already done, such as the Climate Strategy and Action Plan and the Action Plan for Disaster Risk Reduction, BCAFN, with the support of 4 Directions, my company, developed the BCAFN CL Agenda High-Level Recommendations to inform a memorandum to Cabinet to seek implementation support. The BC First Nation Climate Leadership Agenda High-Level Recommendations also include a costing exercise which will inform a submission to the Federal Treasury Board. We know that whenever we make recommendations, there's always the question about what it's going to cost. So we are anticipating that, and we have made significant progress in that regard. Currently, the Climate Change Portfolio team is developing the BC First Nation Climate Leadership Agenda report to support the implementation of the agenda. We heard a number of themes, including First Nations rights, jurisdiction, natural law, legal orders, protocols, and identity. First Nations climate leadership, leadership capacity. 3, climate leadership funding. 4, First Nation-led climate planning. 5, space for our First Nations youth, meaningful space. 6, restoration, stewardship, and guardians. 7, climate resilient infrastructure. 8, emergency management. 9, food and water security. 10, true collaboration and breaking down silos. And 11, clean energy transition. So our next steps for this very important work, on October 17th, BCAFN will host a BC First Nation Climate Leadership Agenda All Chiefs meeting. The virtual All Chiefs meeting will focus on engaging First Nations chief and leadership in BC to discuss and provide feedback on the themes and recommendations that emerged from the overall BC First Nations Climate Leadership Agenda engagement process. From late 2024 to early next year, BCAFN will submit a final comprehensive BC agenda report that will complement and build on the BC First Nations Climate Leadership Agenda high-level recommendations and inform the Treasury Board submission, implementation, and future memos to Cabinet. In March 2025, the BCAFN will present and seek support from Chiefs in Assembly on the BC First Nations Climate Leadership Agenda at a BCAFN Special Chiefs Assembly. And the BCAFN will continue to advocate for the full implementation of the First Nations Climate Leadership Agenda recommendations. Madam Chair, I went through the presentation very quickly. I want to thank the delegates for their patience, and I don't want to be the one that's going to be holding people back from the hockey game. So I'll conclude my presentation there, Madam Chair, and if there's any time for questions, I will attempt to answer them or refer them to Patricia. Thank you.
Thank you, Dan, and we appreciate it. Do we have any questions or comments for Dan and Patricia on this issue? Well, even though your presentation was abbreviated, sir, it was a good one, and we don't have any questions or comments. And if they come up with something tomorrow, we'll pass it on to Patricia. So let's give Dan George a round of applause, thanking him for joining us on his holiday. Thank your wife for us. We appreciate it.
Thank you, sister. Back to Disneyland. Take care.
Woohoo! I want to go. And before we get to the draws, let's welcome Louisa Housty back to the mic so she can say a few words to you.
I'd just like to thank you for this opportunity to say some final words. First of all, I would like to offer my sincere condolences to you, Chief Billy Onovich, on your tragic loss. And then also, you could pass the message on to Melissa Moses, and my heartfelt, sincere condolences to Melissa too in the passing of her father. I have been honored for the past 6 years to be the women's representative. During my time and role with BCAFN, I've worked very hard to support, honor, and empower Indigenous women, and not only in my community, but in communities throughout BC. I have 2 recommendations. You know, with my experience, been the women's representative for the past 6 years. One thing that I felt was much needed is that the women's representative really needs to have voting rights. The women's representative needs to be sitting at this table and be able to make decisions and have her decisions and work validated. So I feel that was really important to bring up. And then I also wanted to bring up Billy's recommendation yesterday that, you know, the mental health and addiction needs to be a priority. We are all put here as leaders to make decisions for our membership and make sure that they're safe. If we don't put this as a priority, we're going to have nobody to work for. Our people are dying. So we really need to put this as a priority. So I just wanted to say, this is not goodbye. This is not goodbye. It's see you later. I'll be a proxy.
Thank you, Louisa, for that heartfelt speech. I would like to note that Louisa's mom, Pat Housty, had been a long-serving member of the Heiltsuk Tribal Council, so it clearly ran in her family, in her genes, a hereditary trait, because her mom taught her how to come here and be a leader. So let's give her mom and dad, who are here with us, and her husband, a round of applause. Thank you. All right, now, isn't it wonderful to have your parents here? I could cry. And someone will be crying when they win the hockey tickets. Let's get our Wheel of Fortune thing up. And we're going to draw for, I don't know, where's Joanna? We'll draw for 2 sets of tickets, right? So 2 names. After the first name wins, it gets taken off, right? Wheel of Fortune guy? Okay, thank you. Here we go. Press the button. Are they here? Nyakia? Hannah?
No, I'm online.
Ah, too bad. Too bad. Well, we're sorry that you're not going to be able to attend. So let's give it another spin. Don't take his, well, yeah, you could take his name off because he's online. Berna Billy in the room or online? Left. Oops, must be present to win. Let's give it another spin. Take her name off. We might be here for a while, people. Ed John, woohoo! That's one set down. We have a winner. Ed is here, so Ed, catch up with Joanna. No speeches. We're just spinning wheels. Take Ed off and let's have another spin there, Mr. Wheel of Fortune? Louisa! Woo-hoo! That's awesome. This is a really cool way to say thank you. Thank you for that. Now, how about, should we do one for observers? Joanna, do we have observers here that aren't? Well, we have them online. Do we have observers online? Anybody? We'll do it tomorrow. Just so you know, the shuttle bus will be outside at the end of the session, and staff will be on standby if it gets too full. I want to thank you for staying. Thank you for staying. And I know some of you didn't just stay for the hockey tickets. Thank you for being here, and we'll see you again. Let's do it all one more time tomorrow, 9 o'clock.